Hey everybody. You might notice we're starting half an hour earlier than we've been starting this case. You know that we skip the lunches, we get caught up, and we skip all the downtime of the jury shuffling in and out. The state mentioned yesterday that today might be the day they rest their case. If not today, then tomorrow. So I suspect we're going to hear from that other GBI cold case agent, Howell. I think it was his last name, Jeremy Howell. We were supposed to hear from a jailhouse snitch. Haven't heard his name in the last few days, so we'll see. And then I think we're going to hear a little bit about the DNA, the TrueAllele, maybe. And maybe some other witnesses, who knows. So I wanted to look at some motions that took place pre-trial to really put into context Elizabeth Bingham's role. We just saw her on the stand yesterday. I thought her testimony, it gives me concerns for the way there might be tunnel vision away from someone who might be the actual perpetrator. So I wanted to go backwards on the docket. And so we're going to do some motion readings. We've got 4 motions. One is pretty long. The others are like less than 10 pages. We're going to skip the major case law parts. And what we're going to be focusing on is this early May 2024 time frame. We heard yesterday that on May 5th, 2024, Liz and Jeremy were sitting with Kris Melton and telling him, we need you to help us explain this away. We need to separate you from the bad guy. And then by May 9th, Faust is arrested. So we're going to look at that time frame and see what was going on in those days, knowing the context of what we heard yesterday from Liz. So on May 9th, this is coming from an October 2nd, 2025 motion to suppress statements as fruits of an unconstitutional arrest in violation of the 4th Amendment, so search and seizure, and state law in Georgia, OCGA 17-8-30B, due to lack of probable cause to authorize issuance of the arrest warrants. So on May 9th, 2024, Elizabeth Bingham, Miss Liz, obtained arrest warrants for Mr. Faust's arrest on the offenses of malice murder, felony murder, aggravated assault, possession of a knife during the commission of a felony, aggravated sodomy, concerning the death of another, tampering with evidence, and arson in the first degree. However, the facts known to Agent Bingham were insufficient to establish a mere probability that Mr. Faust committed any of the above listed offenses. On May 8th, the day before Liz goes and gets these arrest warrants, and this is a shorter motion. We're going to get more context. Some of this is going to repeat itself, but we're going to get a lot more context in the next motion. On May 8th, 2024, Georgia State Patrol Trooper N. Wooten, using Mr. Faust's CSLI information, so that's like your cell site location information, conducted a traffic stop of Mr. Faust. The purported purpose of the stop was to adjust Mr. Faust's inoperable brake light and window tint. And if you guys watch the YSL trial, you know how much window tint comes into play with these traffic stops. If you have window tint, somebody's going to assume that you're committing a crime. However, Trooper N. Wooten abandoned the purpose of the traffic stop shortly into said traffic stop and transformed the purpose of the stop into a search for and seizure of Mr. Faust's bodily fluids. Trooper Wooten, under the guise of dispelling any concerns regarding a, quote, sweet smell being alcohol, led Mr. Faust to believe that he was taking a preliminary breath test, PBT, for the purpose of detecting alcohol on his breath, which Mr. Faust consented. Unknown to Mr. Faust, and without warrant or consent, Trooper Wooten used the PBT breath tube to collect Mr. Faust's saliva for the purpose of DNA testing, and he delivered same to the GBI. Said search and seizure was illegal, and same is the subject of a separate motion, so we're going to see more there. And by the way, this is all Ahmad Cruz's team filing these motions pre-trial. On May 9th, 2024, the GBI issued a report based upon the extraction of Mr. Faust's DNA from the PBT. So they do this all from the 8th into the 9th. Based upon said report, Agent Bingham, Miss Liz, sought and received multiple arrest warrants for Mr. Faust's arrest and for the above listed offenses. The arrest warrant affidavit contains neither information providing the basis for Agent Bingham's belief that Mr. Faust committed the above listed offenses, nor any affirmative allegation that she had personal knowledge of the circumstances surrounding the alleged commission of the crime. Now, the reason this is mentioned is because these things are, just case law, the requirements when you go to apply for an affidavit, an arrest warrant. You're supposed to do these things. You're supposed to attest to having personal knowledge and a belief that this person committed those crimes. And you're supposed to provide, like, supplemental information. Rather, each arrest warrant affidavit simply recited the statute of each particular offense with nothing more than Agent Bingham's conclusion that Mr. Faust had committed each crime. And if you guys want to take a look at that, because I was confused. It seems like she submitted a template of the arrest warrant and then got permission from the judge and didn't put much else in there, because this is the only thing I could find on the record. It just goes through charge by charge. Personally appeared Special Agent Liz Bingham, who on oath says that, now pin that part, who on oath says that, to the best of his or her knowledge and belief, Faust, and then it goes through the time frame, the crime, and the statute that crime would be in violation of, name of the victim, and that same template for each of the offenses. That's all I saw. So, back over here to this motion. So, each arrest warrant affidavit simply recited the statute of each particular offense with nothing more than Agent Bingham's conclusion that Faust committed the crime. The affidavits alone failed to provide the issuing judge with sufficient information to conduct the independent assessment required by the Fourth Amendment to make a determination of the probability that Faust committed the charged crimes. And then we have some case law, Jordanella v. United States, holding that the issuing judge should not accept without question the complainant's mere conclusion that the person whose arrest is sought has committed the crime. On May 9th, Mr. Faust was arrested, pursuant to the arrest warrants at issue in this motion, and based upon said arrest, gave an in-custody interview. Now, I saw a little bit of this morning's arguments outside the presence of the jury while watching over on Nick Starrow's stream this morning. And what's shocking to me is I heard Yalamanchili say, hey, we went through and did the redactions of this one Faust interview. And hour marker 6, minute marker whatever. And in my mind, I'm thinking the day they arrest this guy, they interview him for at least 6 hours. Yet it seems like, I don't even know that we can say Melton was interviewed for more than 6 hours over the course of two decades and change. Liz said they talked to him 4 times over the years before they got to her. And we heard some of the timestamps. I think 2 of the interviews we heard about were in the 40-minute range and a 26-minute range. But yet we get Faust, the bad guy, already pre-characterized by Liz Bingham. And I believe this is the interview that Yalamanchili is speaking about this morning that we're going to hear more about in arguments, was over 6 hours long in duration. Isn't that something? Really inspires confidence that they vetted Kris Melton real well. The arrest warrants issued for Mr. Faust's arrest were unsupported by probable cause and thus void. Furthermore, because the May 9th, 2025 DNA GBI report was a derivative of Trooper Wooten's unlawful procurement of Mr. Faust's bodily fluids, same is tainted and must be removed from the Honorable Court's determination of whether probable cause existed for the issuance of the May 9th, 2025 arrest warrants. So procuring the bodily fluids was a problem. Procuring the arrest warrants because you procured those bodily fluids is a problem. And then the statements that Faust gives in this interview where he's arrested on what is being argued as being false pretenses are also a problem. And no spoiler alert, you guys all know that the judge disagrees with all of these arguments. So they closed this one out. This was the short one. Additionally, all of Mr. Faust's statements to law enforcement after his May 9th, 2024 arrest must be suppressed because same are fruits of Mr. Faust's illegal arrest. So they want a hearing on that motion. The next is the longest one. It's an amended motion to suppress evidence obtained due to illegal searches and seizures. So let's get into this one. This one has a lot more meat and potatoes. we've got argument. Because again, we're just going to skip the stuff in the beginning. The facts, and usually, guys, if you're new to my channel, I usually read the motions in full because I love all the sass. I don't want to miss any sass or spicy footnotes. But here, because we are looking back in time to contextualize between what happened on day 7 and what we're about to watch on day 8, I thought this would be a good little Oreo sandwich cream in the middle. So, A, the facts in the search warrant affidavit failed to provide sufficient probable cause to authorize the issuance of the search warrant for Mr. Faust. Look how much they're getting on this guy. They talk to Melton on the 5th. Then they go and apply for these search warrants, looking for the frame of May 7th through May 13th. All of this stuff for Mr. Faust. Subscriber and transactional information. 2, real-time range to tower / round-trip time data at the time of phone activity. And 3, ongoing global positioning system locations. So we're going to call this all the CSLI stuff. From May 7th until May 13th, 2024, at a rate of every 15 minutes. And this gave me pause because we just revisited the Holly Bobo case, and when Holly Bobo was abducted and the 911 calls were made saying she was abducted, they're pinging her phone every 15 minutes trying to find her amidst an abduction, an actual ongoing crime. 15 minutes they're pinging her phone locations. We do the same rate here for Mr. Faust, all because we talked to Melton the other day and found out he couldn't have done it. He said that he was going to hang out with her on her birthday. And this is all just the header of this section. So they say the affidavit lacked facts asserting that the evidence of the crimes of murder and aggravated sodomy would be found in Mr. Faust's phone records. So, 2024, looking for answers to a crime that happened in 2001, we're applying for a search warrant, making the representation that evidence of those 2001 crimes would be found in his phone records. What? Or that said information was needed to apprehend Mr. Faust. Thus, the DNA evidence obtained and all evidence derived therefrom must be suppressed as fruits of a poisonous tree. And it gets worse, guys. It gets worse. We're going to go through a little case law. Once a motion to suppress has been filed, the burden of proving the lawfulness of the warrant is on the state, and that burden never shifts. And this is critical for what we're going to read in another motion for reconsideration after a hearing took place. The only burden upon the challenger of a search warrant is that of producing evidence to support his challenge, which burden is shifted to him only after the state has met its initial burden of producing evidence showing the validity of the warrant. Davis v. State. Pretty clear what that says. Before a warrant may issue, the issuing magistrate, and it's noted here as a footnote that Bingham's search warrant was signed by a superior court judge, but the legal analysis remains the same, must have sufficient reasons to believe that 1, a crime was committed, 2, that the items sought are connected with the crime, and 3, that the items sought will be found in the place to be searched. These are ands, not ors. In passing upon the validity of the warrant, the reviewing court may consider only information brought to the issuing judge's attention. So if Liz is bringing this forward, the judge has to look at what Liz is bringing forward and only what she's bringing forward. And the argument's going to be, she didn't bring Jack forward. There's a little bit of case law here. It is not merely doubtful as to whether Elizabeth Bingham's May 7th, 2024 search warrant affidavit provided sufficient probable cause to support the issuance of the resulting search warrant. Rather, the affidavit is wholly devoid of probable cause. First, it is undisputed that a search warrant was required to obtain Mr. Faust's real-time range, all the CSLI stuff. The Supreme Court of the United States made clear that an individual maintains a legitimate expectation of privacy in the record of his physical movements as captured through CSLI. So just because we have all this data doesn't mean that the government can go access it all willy-nilly. Similar to the request in the search warrant affidavit at issue, the Supreme Court held that the acquisition of the defendant's CSLI over a 7-day period was a search within the meaning of the Fourth Amendment. Therefore, The government must generally obtain a warrant supported, this is emphasized, supported by probable cause before acquiring such records. Second, it cannot be credibly disputed that the place Elizabeth Bigham requested to search was Mr. Faust's cell phone through his cell phone records, and the items that the search warrant affidavit sought to seize was location data from Mr. Faust's cell phone. Elizabeth Bingham's search warrant affidavit failed to set forth facts alleging that Mr. Faust committed any crime. Rather, the affidavit provided that the official autopsy report documented contusions around the vaginal area and anus, evidence for sexual assault kit was collected, including the collection of oral, vaginal, and rectal swabs and smears. Now remember, this is before they went and did the fixing of the mislabeling. They didn't send those samples off until September, October timeframe to Pure Gold. This is still May. CODIS provided a possible investigative lead that a partial major DNA profile from the oral swabs matched a reference sample from Mr. Faust. The state's lack of evidence regarding a connection between Miss Baker and Mr. Faust was intentionally evading law enforcement by his erratic driving and counter-surveillance methods. Now pay attention here, they are saying a partial major DNA profile. So, they're representing to this court in trying to obtain this search warrant that the CODIS hit was a partial profile, not a partial match. There's a major problem with this. There's a major problem with that. Because a partial profile just means if this is your entire DNA sequence that we would use for comparison, only like 1% of, like, for example, with like chimpanzees. Humans, we're only different by like 1% of our DNA compared to chimpanzees. If you take that 1% difference and you narrow it down to what would distinguish one human from another, it's like a certain subset of different allele sequences that DNA forensics will look at. And when you have a partial profile, that just means you only have some of the sets of alleles that would be looked at. You don't have the complete chain. But you could still match the sequence of those alleles exact if you have the same sequence part present. And that can be reliable if they're not degraded samples. If you have a partial match, however, a partial match would be, hey, if we take this sequence and compare it to the exact same sequence, some of the alleles are similar, but it's not an exact match, and these are likely two different people. So here they represent that they had a partial profile in this search warrant affidavit. Pin that, pin that, pin that. So, they say that this partial major DNA profile from the oral swabs matched a reference sample from Mr. Faust. The state's lack of evidence regarding a connection between Miss Baker and Mr. Faust was intentionally evading law enforcement by his erratic driving and counter-surveillance methods. So they're saying that Faust was trying to avoid them by employing counter-surveillance methods against them. Somehow they weren't even going to look at him until after they spoke with Melton on May 5th. Somehow between that time period, Faust must have found out they were looking for him and started employing counter-surveillance methods. That's what's being alleged in this warrant. Elizabeth Bigham is a problematic person. This is not who should be working in the capacity that she's working in. To justify a CLSI warrant, Elizabeth Bigham was required to provide sufficient facts to the issuing judge that contraband or evidence of a crime would be found within the CSLI information. Now, they got case law here. Finding search warrant for CSLI supported by probable cause, where CSLI information would provide the identities of the shooter and accomplices. Evidence of their location and communications around the times of the crime would facilitate the apprehension of the shooter and accomplices. Rather, so what they're going to say is this isn't that. Rather, what happened here, Elizabeth Bigham requested a CSLI warrant for the sole purpose of tracking Mr. Faust with the CSLI information, not for the apprehension of Mr. Faust or because the CSLI information itself contained evidence of the crime. They wanted to find a way to get a better sample. Elizabeth Bigham failed to present facts in her search warrant affidavit that established a connection between Mr. Faust's cell phone through his cell records and any criminal activity. We've got here a U.S. v. Gibson. And a search warrant affidavit should establish a connection between the defendant and the property to be searched, and emphasized a link between the property and any criminal activity. Additionally, Liz Bingham, the allegation about Mr. Faust performing counter surveillance and driving erratically, which inhibited the state's ability to conduct surveillance on Mr. Faust, is plainly put not true. Thus, the search warrant affidavit contains a material misrepresentation that must be excised, which further supports the conclusion that the search warrant affidavit was devoid of facts authorizing the issuance of the search warrant. If a court determines that an affidavit submitted contains material misrepresentations or omissions, the false statements must be deleted. The omitted truthful materials must be included, and the affidavit must be re-examined to determine whether probable cause exists to issue a warrant. I don't know why must is in brackets. We don't have a note here, so I would assume that that's in the original text of Carter v. State. Elizabeth Bingham's search warrant affidavit includes the following misrepresentation. So we have an inset quote. On Friday, May 3rd, 2024, police began traditional covert surveillance of Faust. However, traditional surveillance on Faust has been unsuccessful due to his erratic driving, counter surveillance methods, ... This misrepresentation clearly alleges that, at the time of the warrant affidavit, Mr. Faust is intentionally avoiding law enforcement. However, Liz Bingham's GBI file belies this assertion. According to Bingham's GBI case file notes, surveillance did not start on Mr. Faust until May 5th, 2024 at midnight, and they simply failed to locate him. Hello? And this is great attention to detail in this motion. Let's give a little fire and flames here. Based on the above, we respectfully request that the Honorable Court removes the false statement listed above from the search warrant affidavit, re-examine the affidavit, and find that based on the information presented in the search warrant affidavit, Elizabeth Bingham failed to provide sufficient information to authorize the issuance of the search warrant. Specifically, Bingham failed to show in the affidavit, 1, that the items sought are connected with the crime, and or 2, the items sought will be found in the place to be searched. Thus, said warrant is unsupported by probable cause. So, again, Liz Bingham's representation was, this cell phone in 2024 is going to have some evidence about this crime in 2001. And we're trying to apprehend this guy, but he's avoiding us. He's counter-surveilling us before we even start trying to find him. How can someone avoid you if you're not even looking for him yet? Let alone when you do start looking for him, he doesn't know that you're looking for him. So, this is a lot. Accordingly, because the search warrant was not supported by probable cause, and Mr. Faust's location information was used to conduct a traffic stop to obtain a DNA sample, which resulted in the issuance of multiple arrest warrants used to seize Mr. Faust, and then obtain consent for his verbal statements, we ask that the Honorable Court to suppress all of the aforementioned evidence under the fruit of the poisonous tree doctrine, which requires the exclusion of evidence later discovered and found to be derivative of an illegality. All right, so now we're going to get into more specifics. We're going to skip some of the case law in this part, but this is going to be, I think, a little bit more meat on what we read in the first shorter motion. So the search warrant provisions that authorize the search and seizure of Mr. Faust's CSLI information for May 7th, 8th, and 9th are overly broad provisions because said provisions authorize the search and seizure of said information without probable cause. Thus, any evidence derived and the fruits thereof must be suppressed as a result of unlawful search and seizure. So, let's see. The search warrant issued in response to Bingham's search warrant affidavit contained overly broad provision because the affidavit failed to provide facts supporting that evidence of a crime would be found in Mr. Faust's cell phone through his records on May 7th, 8th, and 9th, 2024. Even if the Honorable Court, they're going to say, they failed to establish the requisite nexus between the crime listed in the affidavit and the CSLI for the dates requested, the breadth of the state's request was for unfettered 24-hour surveillance of Mr. Faust through his cell phone records with location pings at a rate of every 15 minutes for multiple days. However, the state failed to justify such unfettered access with the same breadth of probable cause in its search warrant affidavit. So let's see. They're making the argument, and this is important, that the argument from the defense, from Faust, is that they wanted this information to follow him for the purpose of surreptitiously gathering his DNA from any of those places he might go to. So they don't end up stopping him until the 8th, but on the 7th, if they saw that he went to a restaurant and threw a cup in the garbage or whatever, we could go and see if we can get any saliva off of that. The search warrant itself gave the state unrestricted access and use of Mr. Faust's CSLI information for a 7-day period. However, the search warrant affidavit lacked any specific assertions in the affidavit that demonstrated that Mr. Faust's movements on the dates the CSLI were requested were somehow connected to the homicide, or that the CSLI would somehow assist in the apprehension and arrest of Mr. Faust. In sum, the search warrant affidavit failed to provide probable cause for any of the dates that the CSLI information was requested. When the warrant was issued for this search, the fears articulated by the United States Supreme Court in Carpenter v. United States regarding CSLI were realized. So they're saying this is exactly what SCOTUS precedent does not allow, does not permit, says we should not be doing. Mr. Faust's phone was transformed into a tracking device without a constitutional basis to do so. And the holding from Carpenter that they cite, when the government tracks the location of a cell phone, it achieves near perfect surveillance as if it had attached an ankle monitor to the phone's user. So thus, Mr. Faust asked this honorable court to suppress all evidence seized pursuant to the overly broad provisions and the fruit of the poisonous tree doctrine. Next, we've got the search warrant issued was overbroad because it failed to particularly describe the CSLI information seized, but permitted a general exploratory rummaging of all of Mr. Faust's CSLI information for any place and hour of the day for a 7-day period. So overly broad and anything derived must be suppressed. And then this is what I actually thought the other section was. DNA testing of Mr. Faust's saliva from the preliminary breath test tube exceeded the scope of Mr. Faust's consent in violation of Mr. Faust's Fourth Amendment right against unreasonable searches and seizures. So we are in like an era, like the landscape right now is trying to figure out DNA testing. Can we go into ancestry kits? Can we go to family members? Where do we draw the line, or what hurdles need to be overcome to show that stepping over the toes and looking at somebody's DNA or somebody's family's DNA with the purpose of tying it back to that person? Where do we say consent lies? And what circumstances would allow an exception to that general consent requirement? So I think we're in a new frontier here, and it's especially interesting to look at this in the context of a 2001 cold case. So consent is one of the exceptions to the warrant requirements, Martinez v. State. That's a Georgia case. A consent to search must be the product of an essentially free and unrestrained choice by its maker. That's another Georgia case. The scope of a search is generally defined by its express object. As with other matters of consent, the state bears the burden, pin that, to show that the search fell within the scope of consent. That's Martinez v. State again. Furthermore, it is well established that consent given for one purpose does not mean consent for any purpose. And if the purpose of the consent is exceeded, the consent given was not the product of an essentially free and unrestrained choice. So another Georgia case here that held suppressing DNA test results and finding defendant's consent not voluntary, where consent for a blood draw was premised on the incomplete and thus deceptively misleading information that the test results would be used only for determining blood alcohol or drug content, but was subjected to DNA testing. Seems very relevant, rather than blood, if we apply it to saliva in this matter. Seems pretty on point. And then we've got, with Beasley v. State here, suppressing urine test results and finding defendant's consent was not voluntary, where consent for urine was premised on the incomplete and thus deceptively misleading information that the test results would be used only for determining bond. I can't read it because of the watermark, but was used to supply evidence for a criminal prosecution. On May 8th, 2024, George, so they might have said, hey, if you're not on drugs, we might consider bond for you. And then they end up using that to prosecute him. On May 8th, 2024, this is now back to what happened with Faust on May 8th. So, past the case law, this is super, super important context with the Bigham timeline and her talking to Melton, and then ultimately the bad guy getting him arrested after we separate the good guy. Georgia State Patrol Trooper N. Wooten was contacted by investigator D. Frost with the FBI Safe Streets Task Force in Athens regarding assistance with conducting a traffic stop of Mr. Faust, using Mr. Faust's CSLI information and attempting to obtain a DNA sample during the traffic stop. So defense is alleging that that was the intent before they even go and encounter Faust, was to use these things for the purpose of getting a DNA sample. This is May 8th. They do the arrest warrants on May 9th. Using the CSLI information, Trooper Wooten waited at Lord and Stevens Funeral Home on Lexington Road when he observed Mr. Faust's vehicle drive past his waiting location. Once Mr. Faust passed Trooper Wooten's location, Trooper Wooten started driving behind Mr. Faust's vehicle as Mr. Faust prepared to make a turn. Mr. Faust appropriately reduced his speed, turned on his left turn signal, and merged into the left turn lane, followed by Trooper Wooten. Once Mr. Faust is in the left turn lane, Trooper Wooten activated his patrol vehicle's light bar. Mr. Faust slowed down, with his left turn signal still activated, and made a left turn. After making said turn, Mr. Faust reactivates his blinkers and makes a left turn onto the AutoZone parking lot. Once in the AutoZone parking lot, Mr. Faust stopped his vehicle and shut the engine off, and Trooper Wooten parked his patrol vehicle behind Mr. Faust's SUV. Trooper Wooten walked up to Mr. Faust's vehicle and requested his license. Mr. Faust provided his driver's license and asked what led to the traffic stop. Trooper Wooten advised that the traffic stop was based upon Mr. Faust's brake light not functioning, dark window tints, and post-traffic stop, Trooper Wooten's observation of a crack in Mr. Faust's windshield. Trooper Wooten advised Mr. Faust that he was going to issue him a warning ticket. While at Mr. Faust's vehicle, Trooper Wooten reviewed and confirmed the information on Mr. Faust's driver's license and requested Mr. Faust's auto insurance. While Mr. Faust is searching for his insurance information, Trooper Wooten asked Mr. Faust to step out of the vehicle and stated, "We'll write you a warning and get you out of here." Mr. Faust complied. So they don't even actually take his insurance card or anything like that. They're not even making this look like an actual traffic stop. As Mr. Faust was exiting the vehicle, Trooper Wooten stated to Mr. Faust, "I smell a little weed, a sweet smell. Have you had any alcohol today?" So he's already exiting the vehicle, and now the officer's saying, "I think I smell something." Mr. Faust responded, "I don't drink, I don't do no drugs, no alcohol, no nothing. I'll do any test." Trooper Wooten responded, "Will you blow into the tube real quick for me?" Mr. Faust responded, "Most definitely I'll do that. I don't do no drinking, period." Trooper Wooten responded, "I believe you." He's probably like, I got him so quick, this was too easy. Before administering the alcohol sensor drug test and during, Mr. Faust told Trooper Wooten that he does not consume drugs or alcohol multiple times. On a few occasions, Trooper Wooten responded, "I believe you." Trooper Wooten requested that Mr. Faust provide a breath sample for the purpose of determining whether Mr. Faust was drinking alcohol. Mr. Faust consented to blowing in the alcohol sensor to determine whether he had consumed alcohol. Mr. Faust did not consent to blow in the alcohol sensor for the purpose of providing a saliva sample for DNA testing. Thus, using Mr. Faust's saliva for DNA testing exceeded the scope of Mr. Faust's consent to provide a breath sample solely for the determination of whether he consumed alcohol. Thus, Mr. Faust asked this honorable court to suppress the DNA evidence resulting from the traffic stop. In other words, the breath sensor tests, the arrest warrants resulting from those breath sensor tests, and ultimately the statements to law enforcement as a result of his arrest of those warrants, all under the fruit of the poisonous tree doctrine. So more on this traffic stop. Next argument is Georgia State Patrol Trooper Wooten clearly diverted from conducting an inoperable brake light and window tint investigation to carry out tasks unrelated to the purpose of the traffic stop, thereby impermissibly prolonging the same. Thus, the DNA evidence obtained as a result of the illegal seizure and evidence derived therefrom must be suppressed as same are inadmissible from fruit of the poisonous tree. So 2 bases here. Like, all as a whole, there's problems with this traffic stop. But on one hand, the first argument is this was not where the consent was derived. So the consent was just, I don't drink, I'll do the breath test. Not, you can get my saliva sample to go incriminate me for another crime from 2001. Sure, take my DNA. So that's one argument relating to the same traffic stop. A separate argument is this was an improper premise for this traffic stop. So say, for example, you know, if this was just like a DUI, I would imagine a DUI attorney might argue the same thing here, right? That anything, this was a false premise. So we'll skip the case law here. But the summary here is that if an officer clearly diverts from conducting his traffic investigation to carry out a task unrelated to the mission of the stop, this traffic stop is unreasonably prolonged. On May 8th, 2024, Georgia State Patrol Trooper Wooten was contacted by Investigator D. Frost with the safe streets. We heard all that already. They use the CSLI to get there. They get behind him when he pulls into the auto zone. He walks up to Faust's vehicle and requested his license. Faust provided his driver's license and asked what led to the traffic stop. Trooper Wooten advised that the traffic stop was based upon Mr. Faust's brake light not functioning, dark window tints, and post-traffic stop, Trooper Wooten's observation of a crack in the windshield, and Trooper Wooten advised Mr. Faust that he was going to issue him a warning ticket. While at Mr. Faust's vehicle, Trooper Wooten reviewed and confirmed the information on Faust's driver's license and requested Mr. Faust's auto insurance. While Mr. Faust is searching for his insurance information, Trooper Wooten asked Faust to step out of the vehicle and stated, "We'll write you a warning and get you out of here." Mr. Faust complied. As Mr. Faust was exiting the vehicle, as a ruse to compel Mr. Faust to allow a search of his bodily fluids, Trooper Wooten told Mr. Faust, "I smell a little weed, a sweet smell, have you had any alcohol?" And we went through this. He doesn't drink. I'll definitely do this test. Here we go. I'm fine with doing this test to prove to you that I didn't drink. That's the reason. Trooper Wooten does not call in a license check on Mr. Faust, does not begin writing the warning citation, does not attempt to verify Mr. Faust's insurance, or any other action related to the traffic stop for a broken taillight and dark window tint. Instead, Trooper Wooten diverts from the purpose of the traffic stop to conduct an alcohol sensor breath sample test, which was completely unrelated to the purpose of the traffic stop. Before and during administration of the alcohol sensor test, Mr. Faust tells Trooper Wooten that he does not consume drugs or alcohol multiple times. We get the "I believe yous. Let me go write you that warning and get you out of here." Trooper Wooten does not perform a license check on Mr. Faust, nor did he ever obtain Mr. Faust's insurance and perform a check of same. Wooten abandoned the purpose of the stop, which was to address the broken taillight and window tint violation, and clearly diverted into a purpose unrelated to the traffic stop, an unlawful, warrantless search of Mr. Faust's DNA. Thus, Mr. Faust asked this honorable court to suppress. We know that the court's going to deny this. All right, and then another problem, another argument, is that obtaining this saliva through this traffic stop for DNA testing from the preliminary breath test tube constituted an illegal seizure, as said seizure was conducted without a search warrant. Thus, said DNA evidence and all evidence derived therefrom must be suppressed. So, let's get into, we know about the traffic stop. They take the saliva that was in the straw from the blow tube, and that's how they get his DNA profile. In addition to the search, the seizure of said evidence occurring without a warrant, neither exigent circumstances nor exceptions to the warrant requirement existed to justify the seizure. Thus, said seizure was unlawful, and the DNA profile obtained from Mr. Faust's saliva, the arrest warrants resulting from same, and ultimately Mr. Faust's statements to law enforcement as a result of his arrest under said warrants must be suppressed under the fruit of the poisonous tree doctrine. So, let's see. Stated if he was willing, fruit of the poisonous tree. They go into the statements. Now he's giving, let's see. There we go. The state wanted a DNA sample from Mr. Faust. To obtain said sample, Trooper Wooten led Mr. Faust to believe he was submitting to an alcohol sensor test for the purpose of determining whether he consumed alcohol. In order to provide the sample, Mr. Faust was directed to give it a good deep breath and blow it until you hear a click. Trooper Wooten instructed Mr. Faust to blow into the alcohol sensor device twice. This implicated Mr. Faust's right against self-incrimination under paragraph 16 of the Georgia Constitution. So it's undisputed that Mr. Faust voluntarily consented to submit an alcohol sensor test for the purpose of submitting a breath sample to determine his consumption of alcohol. However, he was not given the choice of relinquishing his right against self-incrimination. So another ground here, right? Like, not just we didn't consent to giving up a DNA sample, we also didn't consent to giving up the right against self-incrimination. So this is a really good motion. It's addressing all the different angles. Again, it's the same transaction, it's the same traffic stop, but they're really laying out, Cruz is laying out all of the different angles why this could and really should be looked at as problematic. So this isn't just like a, haha, we think you should suppress this because it's bad for my client. Like, this is a well-founded motion. I think it's just good to see the work that was done pre-trial. I think it puts into context some of the tension in the courtroom with trial happening now. So in essence, they say Trooper Wooten's misleading request forced Mr. Faust to remove DNA from his body and provide it to law enforcement for the purpose of law enforcement using same to charge him with the offenses that he is innocent of committing. So thus, Mr. Faust asked this honorable court to suppress the DNA, the arrest warrants, and ultimately his statements to law enforcement that resulted from those arrests. So next we have this one's, I should have said this was the shortest. This is the shortest filing, not the shortest motion, but the order. This came after a hearing. We're going to hear more about the hearing through a motion for reconsideration. I've heard rumors that there might be someone was in the court without a Rule 22 that may have just like candidly recorded some of the moments from this November 13th hearing. But it was a conversation on Facebook, and the person who said they're out there that claims to also have them wouldn't share it with the person who was asking where they could go find the clips that are out there if you look hard enough. So it's the guy that did the podcast that was telling them, if you look hard enough, you'll find it. But anyway, we're going to hear a little bit about it during the motion for reconsideration. And I'll take it at face value because attorneys have a duty of candor to the court. You're not just supposed to make stuff up in motions. So arguments might differ, but a recitation of what happened somewhere you should be able to take it at face value. So this is the denial. It's one page. The court finds that there was probable cause to arrest defendant based on the DNA match as presented in the affidavit of Agent Bingham's search warrant as presented to Judge Norris. So doesn't really address all of the issues, just says it's fine. The ultimate use at the top of the chain, the top of the fruit of the poisonous tree is okay, which is kind of a weird way to argue against the fruit of the poisonous tree argument, because the issue with fruit of the poisonous tree starts at the roots. But the judge here, Lisa Lott, she just goes, well, ultimately the arrest, we needed that arrest and the arrest was fine, so forget all of your other arguments. I'm not even going to address them in this motion. So let's see. Even worse, it gets worse than just that one-page order. And this is only 8 pages, and we're going to get into watching today's court. So, motion for reconsideration of the Honorable Court's November 13th, 2025 order denying all of Mr. Faust's motion to suppress. So, this was filed on December 10th of 2025. This is obviously after the order that we just read had come down. That was filed on November 13th. So, usually it's like a 30-day window. They're within their time frame. So comes now defendant Edrick Faust by and through his undersigned counsel and hereby files this motion for reconsideration of the Honorable Court's November 13th, 2025 order denying all of Mr. Faust's motion to suppress. In support of this motion for reconsideration, defendant shows as follows. It's timely filed, blah, blah, blah. Oh, why is it jumping like that? Let's go full screen. All right, this might be a little jumpy. Okay, so on December 13th, 2025, so the order comes down the same day as the hearing, the state conceded the issue and agreed. The state conceded the issue and agreed that Mr. Faust's saliva and the DNA taken from same should be suppressed based upon same being illegally obtained, which were grounds D through H So multiple grounds in Mr. Faust's motion to suppress evidence due to illegal searches and seizures. The defense supplied the case law that it is the state's burden. It is the state's burden. And at the hearing, the state says, they're right on several grounds. And judge says, oops, oh well, I want the arrest to stand. So in this motion for reconsideration, Faust continues, thus we respectfully request that the Honorable Court reconsider its ruling denying Mr. Faust's motion to suppress evidence due to illegal search and seizure, as the state conceded it could not meet its burden. Mr. Faust also requests that the Honorable Court reconsider its ruling on Mr. Faust's motion to suppress statements due to the discovery of a significant material omission by Elizabeth Bigham and the state regarding the GBI's policy regarding CODIS mixture results and the non-confirmatory nature of same. So remember when I told you earlier to pin that in what Liz represented to the court to obtain the CSLI search warrants, she included that there was a partial profile. Let's read more about this. And they say, which directly contradicted the state's argument in support of probable cause at our November 13th, 2025 hearing. During Mr. Faust's November 13th, 2025 motion to suppress statements hearing, the state's argument was that an unconfirmed CODIS hit alone was sufficient to establish probable cause for Mr. Faust's arrest for malice murder, felony murder, aggravated assault, possession of a knife, all of the things. To meet its burden, the state called GBI agent Elizabeth Bigham as its sole witness and introduced a search warrant affidavit to support its conclusion that the Honorable Judge Norris had sufficient information to support the issuance of the aforementioned arrest warrants for Mr. Faust's arrest. During direct examination, Ms. Bigham testified that oral testimony was not given to the Honorable Judge Norris, which would mean Ms. Bigham didn't go and give additional information to supplement her request to the judge. The judge only could have relied on what was written down in the affidavit prepared by Bigham. So she did not, at no time did Ms. Bigham advise the Honorable Judge Norris, nor the Honorable Court that the GBI has a standing policy. So Bigham doesn't follow policy in GBI. Can we trust her to vet a potential suspect? Can we trust her conclusions? So, at no time did Liz Bigham advise the Honorable Judge Norris nor the Honorable Court that the GBI has a standing policy making clear that a CODIS hit on a DNA partial match, or mixture is non-confirmatory and requires a comparison with the individual's known DNA profile. And I want you guys to remember, anyone that watched the testimony yesterday, do you get the impression that at some points when Liz didn't want to answer something, she's like, well, I can't talk about the science of that. But when she wanted to be able to tell the jury about something that she wanted to be true, she suddenly would be fine talking about the science in a narrative answer. She should know the difference between partial profile and partial match. So did she just not follow policy? Did she not pay attention to what she was looking at? Incompetence isn't acceptable. But this might have been intentional. So they go on. At no time does Liz advise Judge Norris that GBI has a standing policy making clear that a CODIS hit on a DNA partial match or mixture is non-confirmatory and requires a comparison with the individual's known DNA profile. Did that jump weird? Let me make sure it didn't jump anything. Okay, so they include as an exhibit the standard operating procedures from GBI's policy on CODIS matches. Simply put, the state was aware that a CODIS match derived from a DNA partial profile or mixture were unreliable to the extent that they required confirmation. Thus, a CODIS hit alone could not establish probable cause, which directly contradicted the state's asserted position. And two, assuming arguendo that a CODIS match could establish probable cause, the search warrant affidavit omitted this critically material information, depriving the Honorable Judge Norris of consideration of same in his determination of probable cause. Therefore, due to said material omission, the search warrant affidavit was insufficient to establish probable cause to support the issuance of arrest warrants. They cite Hester v. State, a Georgia case that says material in the possession of an investigating law enforcement agency is deemed to be in the possession of the state, whether or not it's in the prosecutor's file. So, prosecutor, just because a prosecutor could say, Your Honor, I'm not aware of that myself, it doesn't matter. Doesn't matter. Let's see. We've also got another case that says that the GBI laboratory was part of the prosecution team because it was fully involved in the investigation and the prosecutor was depending on its findings. Carter v. State, explaining that if a court determines that an affidavit submitted contains material omissions, the omitted truthful material must be included and the affidavit must be re-examined to determine whether probable cause exists to issue a warrant. So, and then more, there's more. Watts v. State. When it is alleged that a warrant affidavit contains material omissions that undermine the validity of the warrant, the state has the burden of proving that the seizure was valid by showing that no material information was omitted or that any such omission was not deliberate or reckless. On December 5th, 2025, undersigned counsel became aware of the GBI's policy regarding the required confirmation of TrueAllele mixtures and partial profiles based upon review of the GBI's policy and procedure manual after concluding review of the state's more than 25,000 pages of discovery. Significantly, based upon the GBI's own policy regarding CODIS hits on DNA mixtures and partial profiles, the case cited by the state, Brown v. State, Brooks v. State, and Lewis v. State, are irrelevant and non-dispositive of the issues of whether a CODIS hit alone is sufficient to establish probable cause on a TrueAllele DNA mixture of a partial profile. So they're just addressing the arguments the state made about, well, we have a partial profile, that's what's being represented, and that's enough. That overcomes all the other fruit of the poisonous tree issues. In Brown v. State, the witness advised law enforcement that a man was prying open her window and a white liquid substance came out the tip of the man's penis. Law enforcement found a white liquid on the windowsill, which is found to match the defendant's DNA and CODIS, resulting in the issuance of a warrant. The case is silent as to whether TrueAllele was used in Brown, as in Mr. Faust's case. Nonetheless, with TrueAllele, for forensic unknown DNA samples only that do not include a partial profile or mixture, comparison with the matching profile do not need to be conducted. So if you have a full, it's okay. Unlike our case, Brown involved a single source sperm sample DNA profile, not a mixture or partial profile. This case is inapplicable factually to Mr. Faust's case and does not support the state's proposition that a CODIS hit alone on a DNA mixture establishes probable cause in light of the newly discovered GBI CODIS policy. Oh, let's make sure it didn't jump weird. Ending with policy. Okay. In Brooks v. State, law enforcement collected DNA evidence from the rape kit of 2 rape victims. The defendant's DNA alerted in CODIS for both rape victims. Unlike our case, Brooks involved a single defendant's DNA being present in 2 separate sexual assault kits to 2 rape victims. This case is inapplicable factually to Mr. Faust's case and does not support the state's proposition that a CODIS hit alone on a DNA mixture establishes probable cause in light of the newly discovered GBI CODIS policy. And again, I think this is a great example. Like, when the judge is telling Cruz orally in court, I don't need your case law, Mr. Cruz, and then gives breaks for the state to go look up case law, and then just takes their word without them even arguing the case law. When we have it in writing and we have time to actually look at these cases, the state's naming cases that deal with a topic, a similar topic, but the circumstances and the holdings are not, they're not the same. They're not on point. In Lewis v. State, the decedent was raped and murdered. After swabbing the decedent's vagina and rectum and sending same to the GBI for analysis, sperm was found on the swabs, and it was determined that said swabs were deposited at or near a time of the defendant's death. After examination of the sperm cells, it was determined that the sperm came from one person. So again, like, this isn't similar. We don't have presence of sperm. We have 2 different contributors, but this is something that the state was relying on. Law enforcement obtained 2 buccal swabs from the defendant, which confirmed the CODIS hit. Lewis is wholly irrelevant and inapplicable to the state's position, as it involves a confirmed CODIS hit, not a CODIS hit alone. So, due to Miss Bingham's withholding and concealment of material information regarding GBI's policy on CODIS hits based upon TrueAllele DNA partial profiles and mixtures, the Honorable Court, Mr. Faust, the Honorable Judge Eric Norris, and the state, although knowledge is imputed to them, were misled into relying on incomplete information and inapplicable legal authority that, when considered with the omitted material information, does not support the state's position or the Honorable Court's ruling. And that was the only position that the state took. They conceded that there were issues with the other arguments made that they could not overcome, and yet the court ruled in favor, or ruled against the defense. So in conclusion, the Honorable Court should reconsider its order denying Mr. Faust's motion to suppress illegally obtained evidence, because the state conceded that they could not meet their burden to show that Mr. Faust's DNA was not illegally obtained, which was the subject of grounds D through H of said motion. The Honorable Court should also reconsider its order denying Mr. Faust's motion to suppress statements, because 1, the ruling was based upon the omission of material and dispositive information within the knowledge of Elizabeth Bingham, and thus the state, namely that the GBI requires confirmation of a TrueAllele CODIS hit based upon a DNA mixture or partial profile. 2, the Honorable Judge Norris was not informed of this information at any time in his determination of whether probable cause supported the issuance of arrest warrants. 3, the state relied on inapplicable case law. And 4, reconsideration of same is necessary to prevent a manifest injustice by allowing illegally obtained evidence to be presented to the jury and ensure a correct probable cause analysis under the 4th and 14th Amendments and a fair trial under the 6th. So, got a lot going on here. Got a lot going on here. That sums it up. Those are the motions I wanted to go through. There are some other arguments about TrueAllele and testimony relating to TrueAllele that if you guys want, if that witness is called later today, we could take a look at those. But I think how we got to this arrest, and again, everything that we just read about really takes place from May 5th through May 9th. That's what they did for... Oh, we can separate you, please. Please say it's been less than 10 days. Please say it's been less than 10 days. No, it's been less. Oh, you're finally going to say maybe you saw her that weekend. It could have been sooner. Thank you. Let's go get these warrants. Let's go tell the court that Faust is already counter-surveilling us to avoid us. Let's go park behind him in an auto zone. So, and we'll get caught up, you guys. Thank you for going through those motions with me. Let me change my banner. We are outside jury presence. I have day 7 in the banner this whole time. Day 8. And then outside jury presence. Get some volume. And good morning, everybody. Hello. Don't mean to be rude, just wanted to make sure we read all of that without cutting up too much time.
We're going to go on the record, and I'm going to ask the state. I know, Mr. Bolden, you're down there. Mr. Yalamanchili, are you all ready for the jury to come in?
We are, Judge. I think, though, before the jury comes in, I'd just like to put on the record the timestamps from Mr. Faust's interview that the state is planning on playing. Okay. It would be 6:03:55. That's hour, minute, second p.m. to 6:10:20. 6:14:01 to 6:15:05. 6:50:30 to 6:53:05. 7:02:45 to 7:05:40. 7:11:45 to 7:15:05. 7:16:14 to 7:16:47. and 7:08:35 to 7:11:15. Your Honor, and I believe all of those segments would comport with my understanding of Mr. Cruz's objection to certain portions of the interview that would contain information that wouldn't be admissible in front of the jury. Of course, if there are additional portions that Mr. Cruz wants to play that would be admissible before the jury, he certainly has the opportunity to do that during cross-examination. I may have a couple of questions for Agent Howell that fall outside of those timestamps, but I think he has an understanding, and he's present in the courtroom for whatever the instructions the court may or may not want to give him. But I think he already has an understanding that we can't be talking about criminal history, can't be talking about Mr. Faust having been swabbed when he went into prison. And so as it relates to the portion that we would play from 7:16:14 to 7:16:47, I will have a question for Agent Howell about a statement that immediately precedes that. In the actual recorded interview, Agent Howell makes reference to Mr. Faust of, when you get swabbed to go into prison, do you know why we do that? Then Mr. Faust's response is DNA. And so we would play from the portion that Mr. Faust says DNA. And the groundwork question for Agent Howell before that would be immediately before this response from Mr. Faust, did you ask him if he was aware?
So this is about Faust's own interviews, not the jailhouse snitch. So the state wants to be able to introduce things from this very long interview. It's at least 6 hours long compared to Melton's 46 minutes and whatever else. Nice, kind chats where people were beating you down for 46 minutes. But this 6-hour interview or more with Faust, the state wants to introduce or have, I'm assuming, GBI Agent Jeremy Howell, the cold case unit guy that isn't Liz Bigham, is going to talk about some of the things that Faust told him during this interview that helped them conclude he was the right guy. He was lying to us. He denied having any involvement in this. They want to be able to discuss certain things, but they can't just play the whole recording because Faust is the guy on trial. And there could be mentions of, we know you have a criminal record. We know you have past bad character evidence, things that just aren't allowable. So he's saying that he took the time and he was supposed to. They told him yesterday or the day before, go through and be careful with your redactions. That way we don't make any mistakes and play something that shouldn't be played in front of the jury that could cause a mistrial. So they're just going over, these are my timeline redactions. These are the things that the defense didn't agree to, and we still need the court to rule on.
That he had been swabbed with his DNA being entered in a database. And I'm going to ask that question in a leading manner to elicit just a yes or no answer to that question because of the fact that we're talking about some sensitive information that shouldn't come in front of the jury.
Mr. Would you care to respond?
Yes, I would object to, and I'm still going through the timestamps I got from Mr. Yalamanchili, but portion 6:14:21 through, 16, I'm sorry, I think I wrote this wrong. 6:14:21 through 6:14:59. I would object to that portion, Your Honor, because that portion is talking about Mr. Faust and his prior prison sentence. And I could read the portions of that unless I'm mistaken.
I think your timestamps in your transcript might be a little bit off. I can play for the court the portion that I'm talking about.
Why don't we do that first? Mr. Cruz, so you're aware of what he's talking about.
Okay, but before we play that, because I don't want to forget this point, in regards to the DNA being taken in prison, we would stipulate that, well, I'll say this. First, I would object to any discussion about his DNA being previously taken. We've made clear that we are not contesting DNA in this case. That isn't anything that we're... Let me change that statement. We're not contesting that the state took swabs from Mr. Faust and obtained his DNA. As far as previously having his DNA, I would argue, Your Honor, that is irrelevant in this case because after the arrest warrants were secured, they took swabs from Mr. Faust, and the swabs that they took from Mr. Faust are the actual swabs that they sent off to be tested by the state. So any mention of previously having this DNA or anything of that nature, because they end up getting this DNA, I think that would be cumulative and it'd also be more prejudicial than probative.
Thank you. You care to respond to Mr. Cruz's objection about that particular moment?
Yes, Your Honor. It's already in evidence in front of the jury. I think it's absolutely relevant to indicate why it is that law enforcement has contact with Mr. Faust at all. It's the entire mechanism by which he is identified as the perpetrator of the crime prior to the confirmatory testing that's done later on. So it's the way in which he is identified in the investigation. It's already been testified to in front of the jury, and I think it's certainly relevant.
That has not been testified to in front of the jury, Your Honor. The furthest they've gotten is CODIS, and that was for me a very close line, but I didn't object. They mentioned CODIS. I think we could leave it there. If the state is saying that it's already in evidence, the additional argument would be that it's cumulative, and it would be a waste of time to the jurors if this is something the state is saying they're already having. But to use a statement to put forth before the jury that the state previously had his DNA and implied due to prison, I think that would be inappropriate. So I would object under that under 404B, Your Honor, as well as 24403.
Okay, well, let me make sure I understand your argument, because the state has said they are not going to, and they would not be allowed to mention anything about any prior criminal history or incidents that may have happened in another criminal case. I mean, they're not allowed to do that. That is certainly true. But my understanding of Mr. Yalamanchili's argument was that they were excluding that.
But they would ask the witness about previously having Mr. Faust's DNA. CODIS in itself, as we know, the Honorable Court is aware of what CODIS is. But then to say 24 years later, we previously had your DNA, what do you think we got it for? And Mr. Faust's response is DNA. It's implicitly stating the reason law enforcement has his DNA is because he's been in trouble with the law before. And in Georgia, as we know, the only individuals that have to give DNA are individuals that are convicted of felony offenses.
All right, thank you. Mr. Yalamanchili, do you care to respond to that argument?
I think that the witness who would testify regarding the hit in the database has been instructed that we will refer to it as a national database of known DNA profiles. And I'm happy to ask the question in whatever manner the court instructs me to ask it in, and I'd be basically asking permission before posing the question to Detective Howell to be, or Agent Howell, excuse me, to be able to ask it in a leading manner so we don't leave any room open for the chance that any words other than the ones that are authorized by the court would be used in the asking of the question. So. And
I'm asking the opposite, that question or that area not be delved into at all, Your Honor.
Okay, Mr. Cruz, you're saying that because you're saying that it violates 403, that it is a waste of time and it is cumulative.
Not just that, but it's also more prejudicial than, the probative value is substantially outweighed by its prejudicial impact or undue prejudice. But also it gets into 404. Pretty much what I believe this line of testimony would put before the jury is an inference of Mr. Faust has been in trouble with the law before, they've gotten his DNA before. As the state has mentioned, and a portion I disagree with, a portion is the CODIS. They've already mentioned CODIS. CODIS is before the jury, right? They've already mentioned that his DNA matched or alerted in CODIS. As far as going down the line of talking to Mr. Faust, why do you think we have your DNA?
Put a 1 in the chat if you understand what Cruz is saying, that, hey, we're not getting into an issue of a mention of CODIS. It's already been mentioned in front of the jury. We didn't object, but we know, the state knows, they're not supposed to talk about criminal database. Yalamanchili just said, we'll just say national database. Cruz is also saying that's in the past. That's in the past. What we're disputing here is if we get into these snippets of this interview, these statements from Faust while he's in police custody after his arrest, and he says that he understands that by giving a swab, he's giving up his DNA. We don't want those statements coming in. There's a difference there. There's a difference there. Let's see if the judge understands this. This is the part I watched through with Nick Starro this morning. The state, you guys got it. I don't see any number but one.
It's really no other purpose of putting that information before the jury. We've already established that the state has DNA. I believe through Agent Bigham. She testified about the swabs. The swabs were admitted to evidence, which were swabs from Mr. Faust's mouth. I don't think whether or not they had DNA is going to be an issue in this case. We have some questions about the DNA, but the state's position is that they have DNA. Bring it through Jeremy Howell that they previously had his DNA, or Mr. Faust saying my DNA. I would stand by my objection under 403 or under 404 as well. But I would add that the probative value of the evidence is substantially outweighed by undue prejudice.
All right, thank you. Anything further?
No, Judge.
Okay, so this is what we're going to do. I'm going to give you all a 15-minute break and see if you have any case law this court can look at.
Sure.
I want to
we'll skip the breaks.
sort of give you a few of my thoughts
And again, I don't need your case law, Mr. Cruz. State, I'm going to give you a break to go look for case law.
About this argument. The first is that I do find it is relevant. And so that doesn't even touch 403 yet, but it is relevant. I mean, I don't think there's any question that the information the state is seeking to elicit is irrelevant, and I don't find that it's cumulative. So it's not violative of 403 in that sense. The jury selection process from both parties repeatedly referred to websites and companies that people consistently use in our country, like Ancestry.com or 21andMe or whatever, those.
Can you tell me what the difference between, let's say I go do Ancestry.com, I fill out one of those 23andMe things today. What's the difference between that and how we initially got saliva from Faust in this case? Is there a difference? Is it the same thing?
Kinds of companies. Those questions were asked by both parties to the jury. And so there is a sense of, at least both parties have inserted into this trial through their questions to the jury panel as a whole, and of course, during the entire voir dire process, both parties have inserted the idea that DNA is often these days in the mainstream of society, whether it be in a company like Ancestry.com or something like that. And so certainly, Mr. Cruz, your argument is very significant. I'm going to go look up the law, and I'll let you all look it up too, about whether it is common knowledge that a national database like CODIS is only reflective of someone being in the prison system. I'm not sure that's accurate.
This also isn't the issue. We're talking about redactions of statements that between the state and defense in this interview, there are some redactions that the defense wants that the state doesn't want to redact. They cannot come to an agreement, and they need the judge to weigh on specific statements. This is not about a mention of CODIS. And she's just saying, well, the jury already heard about, consenting services where you can submit your DNA and get your genealogy profile sent back to you. Yeah. Let me just
I don't, there hasn't been any evidence in the trial that says anything like the national database is only for people that have been in the prison system. There has been no evidence to suggest that. And so I do think the question is whether that is such a common understanding that it is a moment where when it's mentioned, the jury would absolutely know this. And I'm not sure about that. I am going to look up the law as to whether something like this is violative of 404B, and then I'll make a decision about whether 403 has actually been implicated. So it's almost 9:30. I'll be back on the bench at 9:45 and we'll discuss it. All right, thank you.
Like, it doesn't matter what Cruz says. He literally said, hey, we already let that issue. It's water under the bridge at this point. If anything, it's ineffective assistance of counsel because I didn't object to it. But what we're talking about here is the redaction of different statements. No longer about the CODIS mention. What is going on? And we get to skip this. Good morning, everybody. Good morning. Shout out to Sunshine for You saying, here's my money for the cuss jar. I think that might be very necessary today. So this is appreciated as always, but especially appreciated with that pretext that it's for the cuss jar, because it might be needed. It might be needed. We've got Not Sure Now gifting 5 memberships. Thank you so much. That's super generous. There is another, I feel like every day we're adding a new emoji. We've just got a plain old what emoji. I think we're going to have a lot of uses for it today. So it'll be the first emoji under that, if you're a member. And sorry, I can't make emojis on YouTube available to everybody. I would if I could, but YouTube locks it as a member-only feature. So if you are now a member, either because you choose to support this channel, thank you, or you got a gift from somebody who chose to gift memberships, just like Not Sure Now, make sure you check out those channel emojis. Take advantage of them. They make the chat nice and fun. So big thank you there. Also, Chrissy Bacon, thank you for sending over a tip saying doing a great job covering this Faust trial. Thank you. I think this is from yesterday evening after we ended the stream. So sorry I missed it. Just saw it now. And always love to read your name. So big thank you for that as well. We will skip these breaks. Or actually, how long was it? So they went away at like what says 2:09. All right, so they're gone for 20 already. They're gone for like 25 minutes.
All right, we'll go back on the record. I'll start with the state. Anything you would like to add? And then Mr. Cruz, Mr. Hill, you'll get to respond. Go ahead, sir.
Thank you, Your Honor. So one thing that I know that the court has already found that information related to the CODIS hit is relevant. I would also add, just to kind of support that even further, is the fact that there are particular counts of this indictment that reference that April 30th, 2024 date. And that is necessary because of tolling of the statute of limitations for certain counts in the indictment. So that is a material fact that the state has to prove as well. So that again, I think just supports the idea that this is absolutely relevant evidence related to the CODIS hit and when that hit was generated. The case that I would cite to the court is Watson v. State.
Wow.
That is 337 Georgia Appeal 16. It is a 2016 case. And just so the court understands kind of the procedure or the procedural posture in Watson, I guess the argument was that trial counsel was ineffective for not objecting to information about CODIS being brought into the trial, and which is obviously different than the situation we're in here, but I think that the language is still helpful. And Watson stands for the proposition that evidence of, that a defendant's DNA profile is included in a database compiled would reflect badly on the defendant's character if the DNA profile or references to the database linked the defendant to criminal activity. And so the state has been very clear. We've instructed our witnesses very clearly to not refer to it as anything to do with criminal activity, just that it is a known database, or let's see, a national database of known DNA profiles. Watson also says that there are other ways that a profile might get into CODIS, of missing persons, evidence collected at crime scene. So it's not just offenders whose profiles go into CODIS, but we're not even going to get into that. Just the fact, and again, our witnesses have been explicitly instructed to refer to it only as a national database of known DNA profiles with nothing further. So I think that under Watson, because we're not in any way, shape, or form attempting to link it to Mr. Faust's criminal activity, then there's no issue.
All right, thank you. Mr. Cruz.
Yes, ma'am. I would say, based on the state's case, I haven't read the case, but I think it supports our position. It is linking Mr. Faust to criminal activity. They're saying the basis of this entire prosecution is based on Mr. Faust's DNA, supposed DNA being present in Ms. Baker's body, Your Honor. The entire piece of the testimony from Mr. Howell that's anticipated is to say that we previously had your DNA, or do you know how we previously had your DNA? Prison itself is linking them to criminal activity. Well, excuse me, let me clarify that. The only reason the state will previously have Mr. Faust's DNA is through incarceration or felony conviction, as the honorable court is aware. But they are also using that DNA with the CODIS to state that, hey, this is how we connected Mr. Faust to this crime. So that's my position, Your Honor. I do not have any additional case law. I figured the honorable court would, I'll leave it to the discretion of the honorable court, but I would say without reading the case that I believe from what was proffered, it supports our position. Secondly, the standard, as the honorable court knows, of effective assistance of counsel is very, very high. So in regards to the court's ultimate finding on that case, it has to be looked at the standard. As the honorable court is aware, on the trial level, the presumptions are in favor of the defendant.
Thank you, Mr. Cruz. All right. I first want to respond to both parties this way, as I sort of did before I left the bench, and that is in the arena of this case, both parties questioned the jury about submitting DNA to other sites, right?
I did not.
Okay. You may have followed up with questions.
So I
about it.
didn't follow. I didn't
Okay.
talk about submitting DNA to sites at all with the jury.
All right. Thank you, Mr. Cruz. I'm staying corrected. Then it was just the state. There were no objections, but it was just the state. But my point about all of that is that there was discussion in voir dire, okay, by the state, that referred to whether persons had submitted DNA for well-known sites. I mentioned the ones that came to the top of my mind. I don't remember if you all did this in jury questioning or not. I'd have to look at my notes. But, of course, Ancestry.com. It's 23andMe, not 21andMe. I don't know where I came up with that number. And things of that nature. And so I say that again to I think that is a background of how it is certainly possible for the jury to recognize a CODIS database as being just a database like any other. There's been no evidence, in addition to that in this trial, that the CODIS database is necessarily only linked to persons who have been incarcerated in the prison system. All right. That being said, the reason I left the bench is because I wanted to look at what the law says. And that is what is going to dictate this court's direction. It's what the law says. The law is clear, but I want to explain what the law is. But the law is clear that it is allowed. The law is very clear in this state that what the state is seeking to introduce is permitted. That's in Scales versus the state, 310 Georgia App 48, a 2011 case. It is still good law. The interesting language in this case, and I'm reading it to all of you, and I'm going to actually read some comments from a law review article that sort of mimics this case to tell you how I'm going to tailor or order that this evidence is tailored. I'm going to allow it, but we're going to do some tailoring. This is what the case says, which is Scales. Evidence that a defendant's DNA profile is included in a database compiled by a state or federal government agency would reflect badly on the defendant's character if the DNA profile or references to the database linked the defendant to criminal activity. Therefore, we hold that evidence of a matching DNA profile in a government database does not, in and of itself, constitute impermissible character evidence when no reference is made as to why the matching sample was collected or stored, and when no reference is made linking the defendant's DNA profile to other criminal activity. Other states have reached similar conclusions, and that's the law. So in looking at the law in the state of Georgia, I wanted to just see what else was out there in the brief moments that we had. There is a law review article that is I'm looking for the date, that is from December of 2025, so a very recent article. And
we're going to read the next paragraph.
I'll just read it to you all, just so I don't have to summarize it.
She stopped at a paragraph and then switched over to reading a law review article. And Nick Starro sent over this link, so I've been waiting for her to mention this is the State v. Scales. So she read this part. Where was the mention of badly? She started right here. So, a DNA profile like a fingerprint card may contain, we're going a little bit before what she read, and we're going to go a little after. A DNA profile like a fingerprint card may contain information linking the defendant to another criminal offense. We have held that the admission of a fingerprint card that indicates prior criminal activity impermissibly places a defendant's character into evidence in violation of OCGA 24-2-2 and 24-9-20B. So state statutes. They also cite themselves, Keller v. State, and Jinks v. State. Jinks. However, the admission of evidence indicating that the defendant's fingerprints match those in a database alone does not introduce character into evidence, particularly where crime-identifying information has been redacted. So, the beginning part of this paragraph says, fingerprint card can contain information linking the card itself can give the jury information of another criminal offense or suspicion of a criminal offense. But to simply indicate that fingerprints made a match somewhere in a database might not be an issue. So a good precaution there would be, don't just introduce a picture of a fingerprint card that looks like it was taken at a police station. Right? So you remove the tangible thing that looks like it was collected in the course of some type of suspicion of a criminal activity. She didn't read that part. Let's see. Similarly, evidence that a defendant's this is where she starts. Similarly, evidence that a defendant's DNA profile is included in a database compiled by a state or federal government agency would reflect badly on the defendant's character if the DNA profile or references to the database linked the defendant to criminal activity. Therefore, we hold that evidence of a matching DNA profile in a government database does not in and of itself constitute impermissible character evidence when no reference is made as to why the matching sample was collected or stored. And remember, the state is trying to get Jeremy Howell, GBI agent, to testify and talk about these statements from an interview with Faust about the collection of this information and why it was collected and why they may have had this information already. And all of those things would be problematic with or without the mention of CODIS, but especially if CODIS is mentioned. And when no reference is made linking the defendant's DNA profile to other criminal activity. Other states have reached similar conclusions. We also don't read this next part, which seems like it might be relevant. In ruling on Scales' motion in limine, the court ordered the state not to make any statement or to elicit any testimony implying that the CODIS database information is culled from offenders or prisoners. So, state is saying we won't do that. We've instructed all of our witnesses on that. And, this part, and to redact any document, a transcript could be that same thing, that might contain such information, and the state complied. So, any such information that would relate to this is being obtained in relation to suspicion of prior criminal activity, in the Scales case, no stones were stepped on. The line was drawn in the sand, and the court found here that the state did not step over that line during Scales' case. This part is really important. Redact any document that might contain such information. We are arguing about redactions in this interview that Howell was going to testify about. And the judge didn't read this part about redactions. Like, so yeah, I'll link to this if you guys want to read it in full. We're going to get back to Judge Lott, skipping that part to go to a legal analysis that supports what she wants to find.
Article that is, I'm looking for the date, that is from December of 2025, so a very recent article. And I'll just read it to you all, just so I don't have to summarize it.
Because you can't summarize it.
In cold hit cases, prosecutors may wish to introduce evidence to the jury regarding how the defendant came to the attention of investigators. Specifically, the prosecutor may feel that the jury will wonder why a particular suspect was selected in the absence of testimony regarding the database search. This sentiment may be especially acute in long, dormant, cold hit cases in which a great deal of time elapses between the offense and the prosecution. Generally speaking, defendants have sought to preclude such testimony. Occasionally, trial courts grant such motions, typically made on Rule 403 prejudice or Rule 404B character grounds, as you have made, Mr. Cruz, and allow the prosecutor only to elicit testimony such as that the defendant came to the investigator's attention as a suspect. However, the majority of appellate courts that have reviewed denials of motions on this basis have been upheld. Scales versus the state, which I just mentioned to both of you, to all of you, is typical of the handful of courts that have addressed the issue, and that the court declared, quote, that evidence of a matching DNA profile in a government database does not in and of itself constitute impermissible character evidence when no reference is made as to why the matching sample was collected or stored, and when no reference is made linking the defendant's DNA profile to other criminal activity. And so I wanted to just read that to you. I mean, I realize a lot of your articles are not law, but it does support the case that the court feels is appropriate to rely on. So I'm going to allow the question, but we're going to limit the question in this manner. We're going to narrowly tailor the state's ability to present this evidence. First of all, the only permissible reference to CODIS is going to be with the words that it is a national database. Not a government national database, a national database. I want to pause here for a moment and also say this, that we looked at a few other cases in the country that were cold cases, as we all have been discussing, out of the presence of the jury, as to whether this issue came up. And the evidence in several of those cold cases was that the defendant's DNA profile was collected using the mediums that I have described were mentioned during jury selection. They were collected using Ancestry.com and 23andMe and other DNA, other agencies that collect DNA. And those cases were referred to as national databases, but they were not criminal in nature. They were not CODIS, but they were national databases. So I think the reason I want to mention that is I think it supports my feeling earlier that I articulated to all of you that, well, my sense of the evidence that I articulated to you all earlier, that there has been no mention that the general public understands that CODIS in and of itself is a government national database that deals only with people who are incarcerated. There are a lot of national databases, so to speak, that are in the public realm that I think it's fair to say the public can look at as all being the same. There's been no evidence in this trial to suggest that CODIS is only for defendants. So I just want to mention that. All right. So let's go back to tailoring the state's question. If the state seeks to elicit this information, it has to be as a national database, not a national government database. There will be no questioning, unless the defense decides to do it, as to what CODIS is, other than just articulating that it is a national database. I am making a finding under 403 that it doesn't violate 403. I mean, I certainly don't disagree that a lot of relevant evidence is prejudicial. I mean, that is the law. That is, there's an argument to be made that all evidence is prejudicial. The question is whether 403 is violated, and 403, of course, is relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, etc. And based on the law that the court is using, which is Scales versus the state, I'm making a finding that 403 is not violated. And so I'm going to allow you to ask that question with that instruction.
Your Honor, if I could just preview for the court the question that I would ask to make sure that I'm in compliance with the court's order. Anytime that
This could have saved us so much time.
we make reference to, and I can only think of 2 times really during the direct examination when this will come up. The first time would be when we're talking to Agent Howell about how it is that Mr. Faust entered as a suspect in the case. And then the second time would be, as I referenced earlier, during the playing of the interview, asking him immediately before Mr. Faust made the statement, did you reference his DNA being in a national database of known DNA samples? And that's the same way that I would ask that question to Agent Howell as far as how Mr. Faust entered the investigation. I'll ask it in a leading manner to try to control it as much as possible. Your Honor, I would ask Agent Howell, did Mr. Faust come to y'all's attention as a suspect in the case based on the presence of his DNA in a national database of known DNA samples?
All right. Well, before I say anything, Mr. Cruz, do you care to respond to Mr. Yalamanchili's proffer of how he's going to ask the questions? Well, and that's important, so he knows how to answer it and not violate the court's rule, but sure.
Since he knows how to answer, can we just stop it at national database?
I thought that was the end of your question.
A national
DNA profiles. But we just stop it at national database. Mr. Howell knows the testimony that's suspected.
Okay, okay.
I understand the we're just trying to limit any potential prejudice.
I understand. Would you like to respond to Mr. Cruz's request?
Well, I'm just trying to establish that it's a national database of DNA. And
I think that's the best way to say it.
Okay.
I'm going to just say this, Mr. Cruz. I'm going to grant your motion. I think the best way to say it is a national database of DNA.
My request was just stopping it at national.
I understand. So I'm sort of granting your request, I suppose, in part, and I'm granting the state's request in part. I'm not going to, I think it is appropriate to limit even the end of the sentence as Mr. Cruz has asked. You are going to say national database of known DNA profiles. The best way to say it is a national database of DNA.
Yes, Judge.
Period. All right. So I'm going to grant your motion in part and overrule it in part. I'm going to grant your motion in part and overrule it in part to elicit that information. You do have your agent here. I know that, and he's allowed to be in the courtroom based on the statutes. But I'm going to give you a second to talk to Agent Howell and make sure that you all are on the same page. And is there anything else we need to talk about though before we bring the jury in?
I need to proffer 2 things on the record if that's
Okay. Of course.
And I'm just proffering.
So what is the decision on, I mean, I guess they're not going to play these recorded statements at all then. They're just going to ask the question and not force a recording to be played or refresh a recollection. Right? Because we didn't really get an answer on the contested 6-hour and minute mark to this mark.
For the record, Your Honor. In regards to the testimony of Elizabeth Bigham yesterday, in regards to the court's ruling about Mr. Faust's living situation and the address he stayed at in the weekend of Ms. Baker's death, the expected testimony would have been that Ms. Bigham, based on her review of the case file, would have known that Mr. Faust stayed at Knollwood Apartments.
Hold on a second, Mr. Cruz. What are you proffering a question you're going to ask?
No.
Proffer for the record.
So yesterday I didn't
for
do
appeal.
it, but I was supposed to, anytime testimony is excluded or evidence is excluded, I believe pursuant to Rule 103, and I can check my notes, I'm supposed to proffer the excluded evidence into the record for appellate review. So that's all I'm doing.
Okay, well, I think that is untimely at this time. If you care to call Agent Bigham back on cross-examination and you want to bring up those comments, then you certainly can do so, but I think now it is untimely.
Okay. Question for you. With Mr. Howell, I do intend to ask him a general question. I want to make sure it doesn't violate the court's order.
All right.
Can I ask him generally, was he aware of any information suggesting that Mr. Faust did not stay at 350 Cooper Road on the weekend of Ms. Baker's death.
Okay.
Is that a permissible question for them to report?
Before I answer that, I'm going to let the state respond, if you care to respond.
As long as it's information that draws on his personal knowledge, I think that he could ask that question.
Reviewed the case file.
I mean, I sort of agree with the state. I mean, I think in and of itself, again, that question is not necessarily impermissible. If the manner in which you ask it or the manner in which the witness responds is indicative of an objection that the state needs to make, I'll hear it. But it just in and of itself, the question you've asked is not prohibitive of any ruling the court has made.
Sure.
That's what you're asking.
Yes, ma'am. And just to make sure, it's undisputed that Mr. Howell was an agent of the state. In the event that he says no, I would move to impeach him by contradiction. And the impeachment material would be the document that I showed the state yesterday. Okay. And that's why I want to ask to make sure that's
okay. Well, if we have to get to that, we'll get to that. And I'll certainly take up any arguments that may need to be.
See, I think this is a great moment for Cruz to use it to his advantage that Howell's sitting right there in the courtroom, because Howell might have just picked up, well, let me just say yes, and then I won't get impeached. And a yes will also give Cruz what he wants. So.
Taken up at the time. If I have to send the jury out, I will. I don't want to make, this is a pretty nuanced argument that you all are making, and I think it's making it in a vacuum is not something the court can consider at this time. If you ask a question that the state objects to, I'll hear it, and we'll talk about it. And if you all want me to send the jury out to do that, I'll certainly do that. But the answer to your initial question about that particular question in and of itself is not violative of any ruling the court has made.
Yes, ma'am.
Okay.
Thank you.
Thank you. Yes.
Your Honor, I was patiently waiting my turn about the DNA stuff because I also have a witness this morning that will testify about CODIS, and she's not in here right now, and I want to make sure that she is instructed consistent with the court's ruling as to how to answer. I will, again, inform her that CODIS is to be referred to as a national database of DNA pursuant to what the court just articulated. In fact, I would also intend on, just to avoid any potential for confusion, ask that in the form of a leading question to her. Now, with this particular witness, the state had intended to go a little bit further, and I would like to flesh that out before, outside the presence of the jury. This particular witness, Ms. Sims with the State Crime Lab, is familiar with how many known profiles are in the database, and I had intended on eliciting that from her. I mean, I would still intend to unless the court tells me not to. And then, so that's the first thing. And then
I'll let you respond, Mr. Cruz. Don't worry. Let me let him go through his argument, and then I'll let you respond.
And then, so Ms. Sims is the forensic biologist who obtained the profile from the sexual assault kit that was eligible to be uploaded into CODIS. And so my intended question to her would be that once an item is entered into CODIS, what happens? The answer that I expect her to give would be something to the effect of it is compared on a routine basis to other profiles found in the database, and that would be the extent of it.
Okay.
So again, I thought it made sense to bring that up now since we were talking about CODIS and DNA and all that. And I certainly want to have this witness prepared to answer in a way that would not be inconsistent with the court's rulings. I can do that. I just, again, she's not in here right now. So I thought this was a good chance to raise that issue.
Thank you. Mr. Cruz.
Couldn't we just say, Your Honor, can I step out to go and prep my witness?
I would just ask that it's similarly limited in scope. What I would ask in regards to Ms. Sims' testimony, if the state and if the Honorable Court agrees, wants to get that she made the extraction to make it an identifiable DNA profile, I have no issue with that. But once we get into that a GBI agent is uploading it into a national database, we go from, as the Honorable Court stated, just a national database that could be 23andMe and other sources to inferences that this is a government database that the GBI is using. So I would ask that is limited.
All right, thank you. I mean, I think the law allows what the state is asking, and so I'm going to allow you to do that. I think the tailoring you're asking for, Mr. Cruz, is not supported by the law. Whatever inference, if an inference is made by the jury about why an agent may have had access to the database, is an inference that is not supported by the evidence, and it's not going to be allowed by the evidence. I mean, you haven't said there's going to be testimony as to why the GBI agents, of course, had access to the database. I think that would not be something that's permissible based on this discussion and my ruling. So I understand what you're saying, but it's not supported by the law in this case. So I'm going to allow you to ask that question. I do think that that is permissible under Scales. It is important, certainly, to instruct your witness. Let me ask this question. Do you want to do that now, or do you want to wait until that witness is called?
I think we could wait, Your Honor.
Okay.
But, again, since we were all talking about CODIS and DNA,
Sure.
I wanted to have in my mind, what would be permissible under the court's
Okay.
ruling. So not only the fact that it would be routinely compared to other known profiles in the database, but the other question that I had referenced was how many known profiles are in the database.
I understand what you said. I mean, I don't find anything impermissible about that.
Making
Mr.
sure.
Cruz, you didn't respond to that, but if you'd like to, you certainly can.
Well, it was to both, but
Okay,
I understand
okay.
the Honorable Court's
Sure.
ruling.
Okay, all right, thank you, sir. I'm going to allow it. I don't find it valid in 403. But I'll let you, in one moment, Mr. Yalamanchili, I know Agent Howell is sitting in the courtroom. He's heard everything the court has said. I'll give you a few minutes to make sure that you all are on the same page about that limitation. Mr. Cruz, I certainly will hear from you, but I want to make sure I don't forget this. The state has asked twice to be able to ask one or two leading questions with regard to this issue of their witnesses. Do you have any objection to that?
At this time, I do not.
Okay.
I just want to clarify the record. The Honorable Court mentioned 403 as the ground. Our objection was also under 404B, and I understand that it was on
Understand.
both grounds.
Yes, sir, I understand. And I find that it's not violative, but I certainly want to make a finding on the record about 403.
Yes, ma'am.
Thank you. All right, is there something else you wanted to raise? All right. If you need a moment with Agent Howell, you can do that, and then we'll bring the jury in. Thank you.
All right, and then Nick Starr also mentioned the 6 hour is because the state is relying on the time of day to notate when they want to start and stop a statement if necessary. So it might not have been a 6 hour interview. It's referring to 6 p.m. like in the evening time, timestamp on the overlay of the video, which is an odd way to do it, I think.
Clear, in reference to the questions, I think that what we would ask from Ms. Sims would use the word CODIS, and then the explanation of what CODIS is a national database of DNA. Is that consistent with court's ruling?
That is consistent. And if you need to write that down for her so that she has it in a manner that would be helpful, we can talk about whether that is appropriate for this witness sitting in the witness box. I certainly think it is, but we can talk about that if you think that would be helpful for this witness. I don't know whether this witness is, testified before, and I don't want a witness who has not testified. I don't remember this witness. I have to look at my notes. But I don't want a witness who has not testified before or many times to be nervous and do it incorrectly. And so notes to that effect, I think, would be appropriate so that the ruling is not violated.
Shout
So we
out
can
to
talk about
Down
that if you
Bad
think it's
Dennis
necessary.
from
But I'll let you
the
talk to
YSL
Agent Howell,
trial.
and then we'll get started.
Can't wait to see how this goes. Can't wait to see how this all goes. And maybe we can, instead of zooming forward, maybe we can actually jump, because this might be a little bit...
Is our arms ready?
Oh,
Yes, ma'am.
All right, thank you.
That was
I
quick.
do want to mention one thing for our media persons who are here this morning, sir, and other persons who are here. There was something online that was brought to my attention by the state, and I don't know whether this happened or not, but somebody posted something that suggested that the jurors might have been shown leaving the building. And I don't know whether that is accurate or not, but I just want to make sure every media person in here understands that in no way, shape, or form can anyone identify the jurors, obviously by name, or take a picture of them or a video or anything. I mean, I know you know that, but I just want to mention that. I don't know whether that actually happened for a brief second or not, but I just want to bring to everybody's attention. Thank you very much. All right.
do you guys remember yesterday when, like, the chat was saying, oh, the reason the feed's cut is the camera, like, showed the jury while they were leaving for the lunch break or something? Is that what she's talking about? And she's construing that as definitively somebody reported that jurors were filmed leaving the building? Or is this a separate issue? Like, it seems like she could just be making it seem more nefarious, like somebody's parked outside with a camera trying to...
You can bring the jury out. Thank you.
And again, their names are public on the docket. She did not seal the jurors' names. I think that's it. She doesn't like social media. I hope they see Nick Starrow's thumbnail from this morning. Yes, they are identified on the docket. Their names are there in full. Sylvia did a recap last night. She said she'd be late to court today because Steele and Keith Adams have another. They're trying a cold case, or maybe it's hearings. I think it's trial already. So she's watching that in the morning, and then she's coming
Well,
over
maybe
to the
seated.
Athens
Thank you.
courthouse.
Good morning, ladies and
after.
gentlemen. Thank you for being back here
But
on
she did a
time.
recap last night.
We are getting started a little bit past schedule. I'm sorry for that. But as always, there are things that we need to take up outside your presence. This one took a little bit longer than I had anticipated. I do appreciate your patience. We are ready to begin. We are here to resume the trial of the State of Georgia versus Edrick Faust, SU 24 CR 0547. Is the state ready?
State's ready, Judge.
Is the defense ready?
Yes, ma'am.
All right. Thank you. You may call your next witness, Mr.
Jeremy
Yalamanchili.
Howell.
State calls Agent Jeremy Howell.
Agent Howell?
Sit under the hand. Is he bringing his reports ready to go?
Sir, I'm going to ask you to take an oath. You raise your right hand. Do you swear affirm testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear and affirm.
If you would, please take a seat, speak towards the microphone, and state and spell your name for the record.
My name is Jeremy Howell. That is JEREMYHOWELL.
Sir, where are you currently employed?
I'm currently employed by the Georgia Bureau of Investigation.
And how long have you been with the GBI?
I've been with the GBI nearly 15 years.
All right. And what is your current assignment with the GBI?
I'm currently assigned to the Office of Special Investigations Cold Case Unit.
And before you were with the cold case unit, what was your previous assignment at the GBI?
I started out in 2011 as a special agent. I was assigned to the Region 15 office, which is down in Sylvester, Georgia, which is down in southwest Georgia. I was there for
Sylvia's
about
there
2
already,
years.
I think.
Then I had an opportunity to come up to the Region 11 office, which is in Athens, Georgia, where I was a crime scene specialist for a decade.
And you mentioned being a crime scene specialist for a decade. Do you have any particular role or specialization within the cold case unit?
Yes. As a crime scene specialist and a former trained crime scene specialist, I bring those skills into assessing crime scene summaries and other things related to cold case investigations.
And how many years of law enforcement experience did you have before joining the GBI in 2011?
I've been in law enforcement since 1998, in a local level from 1998 until I joined the Georgia Bureau of Investigation in 2011.
When did you move to the cold case unit?
I joined the cold case unit at its inception, which was July 1 of 2023. That was a weekend, so our first day on duty was, I believe, July 3rd of 2023.
At any point while you were in the cold case unit, were you assigned the murder of Tara Baker for investigation?
Yes, I was assigned to assist Liz Bigham as she was assigned as the the lead of the investigation, and my responsibility was to assist her in that endeavor.
Once you were assigned the case, what process did you go through as far as your reviewing of the case file, and how did you familiarize yourself so that you could begin your investigative acts?
Our first step in the process was to partner with Athens Clarke County Police Department. We wanted to centralize all of the evidence and also all of the case file that they had. They were kind enough to grace us with a securable conference room at their West Side precinct, which is over by the mall. And we had secure access to that. So we consolidated all of their case files there, as well as all the evidence there. And the first thing we wanted to do was assess those materials. We wanted to modernize the case file, which was to scan everything and make it into a searchable format as a PDF. We also wanted to inventory all of the items of evidence and compile a list of what we had, what had been done with it, and seek other potential things that we could do with that evidence.
And was this a process that was completed in a day, or did it take longer than that?
It took much longer than this. There were multi-volumes to that Athens Clarke County file. There were multiple items of evidence. One of the things that we are graced with the cold case unit is the gift of time and resources. So we methodically and
that gift is
meticulously
the time
go
for the
through these
defendants.
items in order to catalog them and also to modernize and review them.
As it relates to the volume of the information you had to digest or the size of this case file, how did that compare with other investigations in which you had been involved previously in your time in law enforcement?
This was the largest case file I have ever been a part of reviewing. There were over 21 large D-ring binders that were associated with this Athens-Clarke County case file alone. There were over 5,600, I believe, 87 pages of material that were in those binders. There was also a separate PDF electronic copy of the case file that Athens-Clarke County provided us that was 4,224 pages as well. And there were also a number of photographs that were within that case file.
And in particular, the photographs, this crime that you're investigating took place on January 19th of 2001. Is that correct?
Yes.
Okay. Back then, when crime scenes were processed, are you aware of whether or not the Athens-Clarke County Police Department was still using, I guess, film-fed cameras? I don't know how that terminology works exactly.
Yes, they had film photography back then, and I believe digital cameras were pretty much in their infancy back then, and there were a few digital images.
Okay, so the images in this case, were there images that were not stored digitally?
Yes, there were crime scene photos that were mainly in film, and they had been printed out onto a print format and
What about the ones
scanned.
that they showed
But one of the
Melton?
things that we wanted to do with the film negatives, it was to digitally scan those so that we could enhance those to the best that we could and collect as much data as we could, transitioning or transferring those film negative images into digital images with a digital scan.
I feel like this is all just bolstering that something new came to their attention when the cold case unit that just launched, cold case unit's first day was July 1st of 2023. In tandem, we have the new Coleman-Baker Act that comes along, in part initiated because of what happened to Tara Baker. This is like a test run. This case is a test run. This trial is a test run. And we're going to go through, we digitize all of the photographs, even though some of the crime scene were already on a digital camera because we know Melton was shown a picture of Tara to ID her on the back of a digital camera like the previous screen. She's going to go through a list of all of these things to give the impression that there's a reason that they can say that this was Faust. And yet the only thing is going to be this swabbing.
Scanning device.
And was that all part of what you referred to earlier as the modernization of the case file?
Yes, that was my responsibility.
Okay. And so let me ask you a little bit about your background and training specifically as it relates to crime scene processing. Can you tell me a little bit about your background and training in that area?
Yes. When I worked at the local level, I received some training at an academy up in North Carolina. It's called Searchy. I attended Searchy, I believe, in 2007. It's a 40-week program where you learn crime scene processing, and they're also a crime scene processing equipment provider. So you learn how to utilize the equipment that they produce and that they also market. When I joined the crime scene unit, one of the things they do is they send us to a 10-week program at the National Forensic Academy. That's also known as the Body Farm, but it's much more than just the Body Farm. It's a 10-week program in which each week is dedicated to a specific discipline. It starts out with crime scene documentation. It then moves into crime scene photography. Then it moves into latent print processing. And from there, you also learn bloodstain pattern analysis, shooting incident reconstruction, utilizing an alternate light source in order to be able to detect trace evidence, which is fine evidence that sometimes needs a little bit more help with technology in order to be able to visualize. There's also a component of arson and explosive investigations associated with that. And there's the body farm component of that, in which there is a facility off campus that has multiple deceased individuals in various states of decomposition. And you learn all of the aspects of death and decomposition based upon actual hands-on experience at that facility.
In your role as it related to this case, were you able to review the documentation of the processing of the crime scene at the time of the crime?
I was.
Okay. Can you tell me a little bit about any type of environmental challenges, if any, that existed with the processing of the crime scene in this particular case, as well as the collection of trace evidence in this particular case?
Yes, this was a very dynamic scene. Short of a natural disaster or an explosive event, this presented many challenges with the aspects of the environment. One, you have a fire event that is occurring there, and that is what the initial response and the initial call is. So the initial first responders are responding to a fire incident in which forcible entry needs to be made into a residence in order to conduct search and rescue operations and also to do fire suppression activities. I have experience with fire. I was a volunteer firefighter when I worked at the Madison County Sheriff's Office. I was also a volunteer firefighter with the whole volunteer fire department in Madison County. I spent 5 years in that role.
Your Honor, something just came to my attention. Can we approach the bench?
May?
Oh. I'm looking at the Searchy site at some of the forensics courses they have coming up. It's $650. Let me pause this because we'll watch the facial expressions. But if you attend, you get this cool kit. So it's a virtual course, but they send you a fun little kit. A robust starter kit will be shipped to each student for use during practical exercises. Look at all this cool stuff you get. Super cool. Super cool. They'll give you blood evidence on plywood. You'll get a hinge lifter. Let's see, all these different color fingerprint powders. You get lifting tape. You get blood search reagent. You get some cotton balls and a zip top bag. Send these to the Commonwealth of Massachusetts. Send these to Canton PD. Oh, good times.
Can I step out and just let her know, Your Honor?
Yes.
Well, gotta let somebody know something outside. Yeah, I'm super curious what is happening. I'm always nosy, though. It could be nothing, and I'd want to know. The hand is so close to his head, guys. It is on his hair.
Agent Howell, I think where we were, I actually kind of kept up with it, I believe, is you were discussing your previous fire experience.
Yes, and when I was with the volunteer fire department in Hull, one of the things I had the opportunity to do was to attend training at the National Fire Academy, which is in Emmitsburg, Maryland. I attended two different classes there. One was fire cause determination.
So he's going to help try to tighten the state's timeline on when the time this fire started to make it fit closer to Kris Melton's possible alibi window.
for company officers, which is a basic level arson determination class in which you learn how to do points of origin as to where a fire source may be. And I also attended a week-long training in incident management for large-scale incidents. And when I was with the GBI, we also received, in addition to the training at the National Fire Academy, or the National Forensic Academy with arson and explosive investigations, we also would do training at our facility here in the state of Georgia, the Georgia Public Safety Training Center, learning how to do photography in a burned building, because it's a completely different aspect of photography, trying to photograph and document that type of environment.
As it relates back to, you were describing some of the challenges at the crime scene. That's the context in which we entered a discussion about your previous experience with fire. How does moisture, especially heavy levels of moisture, affect the ability to collect trace evidence at a crime scene?
So as a fire smolders and consumes in order to be able to fuel its existence, fire suppression activities, you need to introduce water into that environment in order to be able to suppress that fire. That's normally under a pressurized line. There will be a spraying of water within that environment, which will add moisture to that environment. That in itself will move and rearrange the environment and also provide an element of destruction to that environment.
Objection, improper expert testimony or improper lay witness testimony, either one.
All right. Any response to the objection?
Your Honor, Agent Howell is testifying within the purview of his knowledge and training and has not offered an expert opinion on anything.
Yes, sir.
I'm assuming Agent Howell is attempting to take his testimony and apply it to the scene. So if he's not testifying as an expert, the state is saying this is not improper expert testimony, our objection would be relevance. This testimony would be irrelevant if he is not trying to apply it to the scene of Ms. Baker's home.
All right. Thank you. Any response to the next objection about relevance?
I believe, Agent Howell's involvement in this case had to do specifically with, at least in part, his training and experience processing crime scenes and his determinations about what, if anything, can be done additionally, in his opinion of the crime scene, is certainly relevant to his investigation of this crime.
And based on the state's answer, my next objection would be lack of foundation. If he wants to establish that Agent Howell could testify about the crime scene at Ms. Baker's home, he needs to bring in testimony that Agent Howell actually went to Ms. Baker's home during this time.
And should I respond to that, Judge?
You may respond if you choose to do so.
Thank you, Your Honor. I believe that Agent Howell has already testified that he reviewed the initial investigation as well as the initial processing of the crime scene. Traveling to Ms. Baker's home 22 and a half years or 23 years after the crime had been committed and then testifying to that would not be relevant because it's not the same state as it was on January 19th of 2001. So I think that we have laid the foundation regarding that.
All right. Thank you. I'm making a finding that this line of questioning is relevant. I'm overruling your objection with regard to that. With regard to this witness testifying in the form of an opinion, 24-701, which rules regarding lay witness opinion testimony, allows this testimony to be presented. I'm going to overrule your objection. You may continue.
Agent Howell, we were discussing the manner in which the application of water for fire suppression purposes may impact the crime scene and the ability to process it for trace evidence. If you'd like, I can ask the question again, and would that be helpful?
I can continue.
Okay, all right.
Thank you.
Within that crime scene are going to be absorbent materials. There's also going to be building materials that have the ability to absorb moisture and to absorb water. As those materials fall on top of the scene, it becomes layered. You have a burned layer, you have materials that have fallen on top of things, and then you also have singed materials in between within that. And those are going to be wet, and that may affect the transferability of different transferable materials such as trace evidence due to absorption, due to adhesion, and also different materials within that fire scene are going to change due to the effects of heat and fire. Things of plastic will become sticky or may melt. Different things
I would give a cumulative and improper bolstering objection.
may get consumed and other materials may become absorbent of the water within that scene.
And so particularly as it relates to absorption and adhesion, I want to ask you some background questions and then ask you follow-up questions about those two things. Were you able to review the photographs from Miss Baker's bedroom from the initial crime scene processing?
I was.
Okay. Was there anything about debris that you found significant in your review of those photographs?
Yes, there was sealing material and there was insulation that had fallen on top of Ms. Baker within that scene. And in order to be able to evaluate the body of Ms. Baker, those materials needed to be removed. It was a layering process in which things that are on top need to be removed in order to have her visible.
And so when those things on top, in this particular circumstance, what were the things on top of Miss Baker?
I believe that there was a piece of ceiling or a piece of drywall that was on top of her, as well as white in color insulation.
And as it relates to absorption and adhesion, did what you see in the crime scene photographs cause you any concerns about trace evidence in it from those two things, adhesion and absorption?
Yes. I recognize that there was the potential for critical trace evidence to be commingled with those materials.
Okay. How would that affect, if it's commingled with those materials, how would that affect the ability for it to be collected and processed at the crime scene?
It would be challenging.
Okay. Let me ask you a question about a particular type of trace evidence. Are
use
hair
this to your
fibers,
advantage.
or not hair fibers, but are hairs considered trace evidence?
Yes, they are.
Okay. As it relates to hairs in particular, based on your training in
Because remember, we heard that certain hairs were unsuitable for testing. We also heard that Tara Baker's own hair on her head was still wet. But as it relates to, I think we're going to get into power transformer territory. Remember, Tara, there was a power cord connected to a printer that was tied around her neck. And there was like this power transformer box that was laid on her torso. They said there was no soot underneath it. No soot underneath it. Which would give you the impression that the cord, she was already in that position when the fire was fired up enough to start producing a lot of smoke and soot. And from that power transformer, there's a head hair. It was similar. We heard testimony that it could have originated from Kris Melton, and there were two other hairs unsuitable for comparison. I'm not sure if that's the only hair that ended up being unsuitable, but we had specific questions asked during, let's see, Larry Peterson, during the direct testimony of Larry Peterson.
experience, would you expect to find hairs from individuals in environments that they
Hey, Dolly friends.
regularly visit
Thank
or
you for the raid,
occupy?
Dolly.
Who would?
Okay. And so let me ask you this. I lost my train of thought there for a second. Let me ask you this about the processing of the crime scene in 2001. Have your tools that are available for crime scene processing changed from 2001 to now?
They have.
Okay. And so can you describe what may be referred to at times as presentism?
Yes. Presentism is one of those things that we try to keep in mind when we are looking at older cold cases. We try to recognize what the capabilities were at that time and what sort of technology they had available to them at that time. That way, when we're applying that critical lens to the case file, to the photography, to the crime scene summary, we're mindful of what the capabilities were then rather than applying presentism, what we can do now to that scene in its documentation. One of the things that we can do is apply modern techniques to evidence that's collected. So we normally try to look at that through that eyes of not bringing today's present capabilities to yesterday's casework.
In your review of the processing of the crime scene in this particular crime, were you able to evaluate the manner in which the crime scene was processed?
Yes.
Okay. And what opinion did you form about that?
I believed that they were innovative in some different techniques, especially with trying to assess and document some potential latent print evidence that was on the thighs of Ms. Baker, especially utilizing a chemical developer and a negative lift technique. that I honestly was not familiar with until I read this case file and began to educate myself to that process. It was rather novel for the time.
Okay. Did you notice any major deficiencies that you noted or anything along those lines?
No, sir.
Okay. As it relates to the processing of evidence, you mentioned applying modern techniques. Did you go back and rephotograph any of the evidence?
I did.
Okay. In particular, in this case, did you go back and photograph one of the weapons that was used to murder Miss Baker?
I did. I needed some clarification on some things regarding that particular item of evidence.
And what was that particular item of evidence?
There were two photographs that I don't want to say caused me some concern, but just I wanted some clarity on. And it was a knife that was located on the floor next to the body of Tara Baker. Due to the positioning of the knife, I noticed that the exposed side, the upward side, was light in color. Then I saw another photo in the file of a knife being held up that had a dark in color handle. And I wanted to examine that, that knife in order to get clarification as to both sides of that knife, and also thoroughly photograph both sides of that knife so that there was documentation that this was in fact the same knife. To look at that knife in the crime scene photos, it almost looks like a wooden handled knife. But then when you look at it, a knife that's being held up against the wall, I believe there's a white latex glove that's holding up that knife. It looks like a black plastic handled knife.
And remember, we had another witness where the state submitted envelopes, like packages, they're bigger envelopes, that contained the suspect, the knife that was next to Tara's body at the scene, and then the knife block taken from the roommates from their kitchen. And it was said that they were both Farberware and Farberware. So the knife was between Tara and the bed, and he's saying you can't tell from the picture what the substance of the handle was, but they're both saying that previously we heard that the knife block and the knife in the bedroom next to Tara were both Farberware. So the idea, I guess, being that the state wants to support the idea, and I don't know how this would eliminate somebody that knew Tara and just got mad in the moment and grabbed whatever was nearby, but I think the state is trying to say or argue that it'd be more likely for an assailant who didn't want to get caught to break in through the window and use a knife from the kitchen instead of purchasing a knife and having a paper trail or something. Like, the state seems to think that this knife block supports a perpetrator with a plan to break into the home and do this and assail Tara, rather than potentially a crime of passion from someone that knew her and just grabbed what was nearby in the heat of the moment.
So I wanted to make sure that that was, in fact, the same knife. So I accessed that knife and I photographed both sides to demonstrate that that is, in fact, the same weapon.
When you say you accessed that knife, where did you access it?
We went to the Athens Clarke County Police Department in order to be able to access that knife in a quality control environment.
After you accessed it and photographed it, what did you do with it?
We immediately returned it back to Athens Clarke County. We sealed it back up. We left it there at the facility.
Okay.
Yeah, I really think this is just to potentially show the jury that they connected some dots. So even though we can't connect the dots for Faust having committed criminal acts and not just having an encounter of other kinds with Tara Baker, just believe us on our gut feeling, because we were able to connect other dots on things that might not really make a difference in the factual determination. And remember, she had the one cut in the
Agent Howell, I'm going to hand you what's been marked as State's Exhibit 94 that has already been admitted into evidence.
All right, let's do a summary here from the medical examiner. Stab wound was on the right lower front. Ligature marks on neck, and I might be reversed, so I'm pointing to my anatomical right. I don't know what that looks like on YouTube if my camera's flipped. but anatomical, right? Ligature marks on neck were consistent with where the power cord was. Blunt force injuries to the neck, bruising behind lower and left ear. For the torso, the ME was weird about this, described injuries to the torso, but said specifically in the genital and anal area when asked about the torso, which is not how I define torso. The hyoid bone was broken and likely part of the strangulation process. The stab, the ME says, was consistent with being stabbed from behind. That was on direct. Incised wounds on the hands, suggestive of trying to defend. We've got, let's see. All right, we also have Baker's ears were pierced, the earrings weren't missing. Okay, so Cruz didn't really get into much about the actual injuries, just asked the ME for his opinion on drainage and gravity, and notated, got it on the record, that her earrings weren't stolen. So there we go. That is a little bit of a recall to the medical examiner's testimony about that injury.
Do you recognize that item?
I do.
And how do you recognize it?
I recognize it in a number of different ways. One is the labeling that is on it. I recognize the Athens-Clarke County, their evidence inventory ID on it, as well as their coding that's on it. It has their case number on it. It also has a description of a knife with an 8-inch blade and describes it as charred. It also has a sticker on it from our crime lab, the GBI Crime Lab, that has our Division of Forensic Science number on it as well as the submission number as number 015. And it also has our GBI evidence property tag, which is a barcode on it. And all of these labels are on this side of the box. There is the Athens-Clarke County evidence inventory sticker. There is our GBI evidence inventory sticker, and there is our GBI Crime Lab sticker here. And it also has seals on it, and where I access the box, there is my initials, my GBI badge number of 189, and the date that I accessed this as 9/14 of 2024.
All right. Do you have a pocket knife with you by any chance?
I do not.
You have
Okay.
a pocket full of sunshine
Your
from
Honor,
you?
is it all right if I hand the witness a pocket knife?
It is.
All right.
Thank you.
If you would you please unseal that box?
Let's see. Ah. Here we go.
Those inside of the box that you just unsealed, what's contained in there?
There is a sealed brown paper bag in here as well that has the item number listed and documented on there. Again, it has the Athens-Clarke County case number on there. It has the item number and the description as a knife. And it also has tape on it from where I resealed this bag when I accessed it back on September 13th of 2024. And that's up here on the top.
Okay. Can you unseal that bag, please?
I can.
Feel evidence ASMR.
And I'll take my pocket knife back from you, Agent Howell. Thank you. Sir, inside of the bag that you unsealed, what is in it?
There is a butcher knife that was located within that sealed paper bag.
And Your Honor, I'd just ask that Agent Howell be able to step down from the witness stand and just display that a little bit closer to the jury.
You may.
Yep. So now I'm convinced that what they're trying to do here is they're going to end up showing the butcher block and they're going to say, hey, the butcher block is full, except there's this specific type of knife that would be part of this collection that would come with this block was missing. So even though this is charred up, it seems logical to conclude that this knife was taken from this kitchen butcher block. I don't see how that narrows it down to being Kris or not Kris, or a random suspect that decided to break into this particular house somehow coincidentally when nobody else except Tara Baker was home. Car was in the driveway, right? Car was in the driveway, so it wouldn't be a crime of opportunity to burglarize, rob a home without confronting somebody. But they're going to say, hey, we did our homework. We connected some dots. So we want you to believe that we thoroughly and we came to good, sound conclusions. We're smart. So trust us when, even though we don't have physical dots to connect for the key facts at issue in this case, it's our gut feeling and our belief that Faust is the bad guy. This knife was found on the floor in the bedroom next to Tara.
Thank you, Agent Howell. If you could, please take the witness stand again and return the knife back to its original packaging.
We haven't heard about any DNA in the knife, but I'm assuming the argument would be that because of the fire, any trace evidence would have been destroyed, and thus we can't tell you, jury, that Faust's fingerprints were on the knife because we just can't do that. So we couldn't tell you that he was excluded or found.
Agent Howell, as y'all are reviewing the physical evidence in the case and reviewing the case file, is there ever any effort made, you mentioned modern techniques, to determine if there's evidence that it may be useful to resubmit or analyze that maybe wasn't analyzed or can be analyzed in new ways?
Yes, as we document, inventory, and assess the evidence that is in the possession of Athens Clarke County Police Department in this case, we also discuss if there's anything more that we can do with these items of evidence. And we recognized a few items within that inventory that we believed we could do some additional investigative submissions for testing at our GBI DOFS center.
Okay. And do you know whether or not that was done in this case?
Yes, it was with multiple items.
Okay. And you said multiple items, those were submitted for retesting?
Yes.
Okay. Eventually, when Mr. Edrick Faust entered this case as a suspect in the murder of Tara Baker, was it due to result from a national database of DNA?
Yes.
Overruled.
Thank you, Judge. And so after y'all received that information, did you take steps to try and speak with witnesses that were interviewed back in 2001 to re-interview them?
We did.
Okay. And I'm not going to get into every single person, but to your knowledge, were Valerie Lowe and Ashley Peavy re-interviewed?
Yes, they were.
Okay. And who are those people, in your knowledge, who are those people?
My understanding is they were roommates of Tara Baker at the time of this incident.
Okay. And was Mr. Kris Melton re-interviewed?
Yes, he was.
Okay. And who did you know Mr. Melton to be?
I believe that he was the boyfriend and in a romantic relationship with Tara Baker
Okay.
at the time of this incident.
And on May 9th of 2024, did you have an opportunity to interview Mr. Edrick Faust?
I did.
Okay. And I want to come back to that interview in a few minutes. But first, what I'd like to do is show you what's been marked already but not admitted into evidence as State's Exhibit 158. I'm showing this to Mr. Cruz first, Your Honor.
All right.
Agent Howell, on May 10th of 2024, did you have an opportunity to collect buccal swabs from Mr. Faust?
I did.
Okay. What are buccal swabs?
Buccal swabs are cells that are located within the cheeks of the mouth. They are very DNA rich and are a common method to collect cells for DNA testing in the preferred method at our state crime lab. And it's essentially get collected by utilizing a swab with a long handle, kind of like a Q-tip, but it's a one-ended Q-tip. And then you swab and you rotate within the inner side of the cheeks in order to be able to collect those buccal cells. They're then packaged in a sterile box. That box is then sealed, and then that box is then resealed into a paper bag similar to this.
Okay. Do you recognize that item that I handed you, States 158, I believe?
I do.
Okay. And how do you recognize it?
This bag is labeled with our GBI evidence property tag. It is BB 68963. And on this is also an evidence sticker that documents the date and time it was collected, who it was collected from, and where it was collected. And this has a description of a box containing 2 buccal swabs from the mouth of Edrick Faust. And this was collected on 5/10 of 2024 at 12:05 p.m.
Okay. And Judge, I'd move at this time to tender States 158.
Any objection?
No, ma'am.
It is admitted.
And when you, Agent Howell, made reference to it having been collected from Mr. Edrick Faust, do you recognize that person anywhere in the courtroom today?
I do.
Okay. If you don't mind, please describe where that individual is sitting in an item of clothing or other description.
He is sitting at the defense counsel table. He is wearing a blue and white striped shirt and glasses.
So the only witnesses in this trial that have actually made an identification in court of the defendant have been the 2 GBI cold case units that came on to this case in 2023-2024.
Your Honor, I'd ask that the record reflect that Agent Howell has identified the defendant, Mr. Edrick Faust.
So reflects.
Okay. After you collect those samples, where do you send them to?
We then send them and we submit them to our evidence receiving at our state crime lab facility, and our main center is in Decatur, Georgia, and that is our Division of Forensic Science Laboratory.
Okay.
So you send it to the crime lab and you get a hit at the crime lab. Careful how you ask the next question. No,
Agent
he's
Howell,
in custody, no bond for these charges.
I want to fast forward again before we rewind back to the interview. Are you familiar with the location at 350 Cooper Road?
I am.
Okay. What significance, if any, does that address have for you in relation to this investigation?
That was our understanding of a residence in which Mr. Edrick Faust would stay at.
Okay. And as part of the
That's the address from the aerial photo that was on the main road, on the Cooper Road. And those like side streets for the Deer Park neighborhood, Tara's house was the one with the gold star, if you guys remember. And defense is going to dispute this. Let's see if they're able to get into it on cross-examination.
Investigation of this case, was there ever a drone video created of 350 Cooper Road and 160 Fawn Drive?
Yes.
Okay. And Your Honor, at this time, I'm going to show Mr. Cruz what's been labeled
get
as
the picture.
State's Exhibit 159. I'm going to retrieve an exhibit real quick before we continue down this line of question.
Oh my God, just get the Elmo out and put it up.
Agent Howell, I'm going to display, or Your Honor, can I display a brief portion of this clip for Agent Howell in order for him to see if he recognizes it?
Yes, but I think you need to do that outside the presence of the jury or in front of him so he can see it.
Yes, Your Honor,
All right.
and I will.
Yes.
Thank you.
Also, shout out to Hospice RN Autumn, who said, hi, everyone, and said, I binge watched a lot of this trial last night to catch up. I think a lot of people are doing that, and I'm really glad that people are paying attention. And wow. Yeah, a good way to describe it is just wow. And thanks for your coverage, Kat. Thanks for checking it out. Thanks for hanging out with us, and thanks for your super.
Agent Howell, had an opportunity to review some different portions of State's Exhibit 159. Do you recognize what that is?
I do.
How do you recognize it?
I was present during that, and back on January 16th of this year, I was with another agent, Austin Bradshaw, and he flew a drone over the Deer Park area as well as the Cooper Road area in order to obtain footage.
Okay. And is this a fair and accurate depiction of the footage that was obtained on the date that you mentioned?
Yes.
Judge, I move to tender State's 159 at this time.
Any objection?
No, Your Honor.
It is admitted.
I move to publish it to the jury, Judge.
You may do so.
No, no, you're good.
Hey, Your Honor.
Podium, please, Judge.
Your Honor.
Yes, sir.
This TV turned on too?
Hopefully. If not, yes. There we go.
And publishing State's 159. Before we start that, though, what are we looking at here as the video starts, Agent Howell?
January
This
16th.
is the front side of 350 Cooper Road, and that is the front-facing side of the house that faces toward, I believe, the east and also the Deer Park subdivision.
What am I going to say? That this is his car at the house in modern times. So this is dated January 16th, 2026. Very fancy. This is really just going to be to show how quickly you could get to Tara's yard. I don't get why we couldn't discern that from the aerial photo that we've had. Thank you for becoming green again, Ali. You've been a member. Why did YouTube mess with you? And good to see you. Thanks for hanging out with us. They're like, hey, we have this budget for cool, expensive toys. We have to use it so we can keep getting our budget. All right, and then Tara's house is like one of these over here.
I'm sorry, I stopped it just a little bit too early. I'm going to let it start playing again. All right, Agent Howell, camera just zoomed in on one house in particular with a fence surrounding the rear portion of the home. What address is that?
I recognize that as 160 Fawn Drive.
Okay. And where was it that Miss Baker was murdered?
That was at 160 Fawn Drive.
Okay. Back in 2001, you already testified you had an opportunity to review the crime scene photographs. Is that right?
Yes.
Okay. That fence that appears around that property at that time, was that in existence in 2001?
That was not.
Okay. And I'm going to put up what's been marked as State's Exhibit 37 and already admitted into evidence as a overhead image of the Deer Park neighborhood from 2001, shortly after Miss Baker's murder. So if we could switch to the Elmo, please, Mr. Terrell. On State's Exhibit 37, if you could, please indicate by drawing a circle where 160 Fawn Drive is located.
And that's on, is this a touchscreen here?
Yes.
Okay.
So, again, for anyone that tuned into this trial late, because so many people have, like, what is this trying to show? It's trying to show opportunity, right? And that's why it's such a major issue that with Liz Bigham on the stand, the defense was denied the opportunity to ask about and present different information about, during the time of the crime, where Faust was actually staying. Because it's a critical part of the state's case to show that Faust had opportunity, especially since there's no other evidence from that moment in time besides his DNA, which DNA could be there for any number of reasons, and you can't get around the possibility it was there because of a consensual encounter, maybe not even a sexual encounter, who knows. But all it would take to get to Tara's house would be to go from the address 350 Cooper over here down to Tara's home through these little yard areas, getting down here this way. So, major argument for opportunity. Will the defense finally be able to confront one of the state's witnesses on, did you know he was living somewhere else and staying most nights somewhere else at the time?
Thank you, sir. And now, if you are able, please draw a circle around where 350 is located.
I think Maurice is muting any address just in case. And again, so anybody that saw a black man that day, they were walking on the sidewalks. They were walking on the road.
And
there was a witness that reported and was never asked to sit with the sketch artist who saw a white man running through this area around like 7:40 a.m. that morning. She said it was before she would have been like leaving for class. So 7:45 a.m. or earlier. White man running from the back area through this grassy area. Very different way to see somebody in the neighborhood than a black man in an orange shirt walking at a normal pace on the sidewalk where they would be seen by everybody leaving their front doors to get into their cars and their driveways and drive to work. a guy that was in a white t-shirt / maybe a white hoodie, a totally different guy, even though the sketches from those very different descriptions seem to be a sketch of a similar looking person.
How are you aware of the distance between 350 Cooper?
Yeah, they're just muting any time an address is mentioned.
Yes,
even
I
though
measured that distance
we know
as
them.
585 feet.
Okay. And if we could go back to the podium connection at this point. Thank you.
And they're supposed to be like closer to the bottom of the screen down here. It seems like there's like a Walmart over here and everybody would just cut through to get there, which seems very normal to me.
And I'm continuing to play states 159 at this point.
Thank you for the super 2, Ali. So it seems they are railroading him like they did Wolfenberger. Georgia's not doing too well with their cold cases. And again, that was another case spurred, attention was renewed because of a podcast with a tip of he was acting weird at a party. And I recommend, if you guys did not watch the Wolfenberger trial out of Fulton County, I highly recommend that. What a time that was. Judge Rachel Krause granted a defense motion for a directed verdict on a felony murder count. That was a very fun argument to watch. And Kiana, it's a little weird that they wouldn't have gone to Walmart to see if any of those guys were seen at like someone around the same time frame. If someone said someone's walking here at 8:45 in an orange t-shirt, maybe it's a 5-minute walk from this driveway area to the Walmart. Why not check who comes and goes into the Walmart entrance that was wearing a white shirt at that point in time? They didn't even investigate stuff like that. And again, I know the defense is pointing at a specific third-party culprit, but I'm not sure, well, it's not even I'm not sure, I'm positive, I'm not confident that the investigators ruled out alternative suspects that aren't Kris Melton. Imagine if Kris Melton was on trial, what he would be able to argue as a defendant about them not looking at these people that were walking the neighborhood. And the prosecution then would be like, well, they were only walking. They were different individuals. They weren't trying to conceal their face. There was a white guy running, though. Like, if the prosecution wanted to put Melton on trial, they would be completely doing a 360, a 180 with what they think is relevant and what they think is damning and suspicious. Yes, the Walmart was there back then. Yeah, I don't know. And remember, this is January 16th, 2026. Got a Tabeta for becoming a member. See, I think you've been a member. You've been green before, too. Welcome back to all the greens. Thanks for becoming a member.
Agent Howell, the drone is looking back at a residence from 160 Fawn at this point, what is the residence that it is looking back at?
I recognize that as 350.
Okay.
Oh, yeah. And while I'm arguing that, Melton would have arguments to make as a defendant, I do also think they'd have a stronger case against Melton, which is why it's unusual the way they decided who to prosecute, who to arrest.
Your Honor, that concludes the display
Thank
of
gosh.
State's Exhibit 159 for the jury at this time.
That was like 20 minutes.
And Agent Howell, if we could go back to the Elmo just briefly, Mr. Terrell.
Oh,
I think it takes just a second. There you go.
Agent Howell, obviously in that drone footage, there were some trees and things along those lines. In looking back, I've displayed State's Exhibit 37 again. What is the nature of the trees and other foliage between 350 Cooper Road and 160 Fawn Drive back in 2001 as compared to the time at which that drone footage was taken?
Yes, our understanding at the time of this incident in January of 2001 was that this was a new development. This was still in the process of being developed, that the land had been cleared, and there's very minimal trees that were present. When we fast forward to today, there's overgrowth, there are trees present, and also 160 Fawn Drive has also changed in terms of additions being put onto that residence.
Okay.
okay.
Agent Howell, I'm going to hand Mr. Cruz what I've marked as State's Exhibit 160. I'm going to hand you, sir, what I've marked as State's Exhibit 160. Do you recognize State's 160?
I do.
Okay. What do you recognize it to be?
This is the interview video with Edrick Faust.
Okay. And did you place any markings on this exhibit's tag?
I did. I initialed it.
Okay. And what did you initial it to signify?
That I had previously seen and reviewed that item of evidence.
And were there any, did it appear to be a fair and accurate recording of your interview with Mr. Faust on May 9th of 2024?
Yes.
Judge, I move to tender State's 160 and publish portions to the jury.
All right, any objection, Mr. Cruz?
No, ma'am.
All right, it is admitted. And before you publish it, Mr. Yalamanchili, we're going to take a restroom break. It's 11:15. We'll take a 15-minute break, and we'll be back on the record in 15 minutes. If you'll go into the jury room, don't discuss the case. We'll see you shortly. Thank you.
All right, let's make sure they don't say anything off the record. Looks like they go right to the seal.
And I want to go on the record just for a minute. I want to address our media, if I could, one more
Again?
time, and just be really clear about the Rule 22 that the court has provided to all of our media. There have been some concerns that I've raised earlier with you all about the jury being identified in certain ways, whether it has
Nickname
happened
SpongeBob?
completely like that or just that there are concerns. But there are concerns about that. And I want to make sure that all the media who have been provided a Rule 22 permission in this court to understand that there is to be no identifying at all of any of the jurors. And that also includes reposting comments about this trial and identifying any jurors by their facial expressions or their dress or their note-taking or not note-taking. Any of those comments are
This is bullshit. Are you serious? And notice how she tries to couch it like you're giving out identifying characteristics, but her real problem is the discussion. This is about Sylvia. This is all about Sylvia, the note-taking.
any of the jurors. And that also includes reposting comments about this trial and identifying any jurors by their facial expressions or their dress or their note-taking or not note-taking. Any of those comments are impermissible under Rule 22, and it is related directly to two things: to security issues and also to concerns about influencing the jury outside of this courtroom. And so I'm going to ask the media to definitely pay specific attention to the rule that the court provided and to refrain at all costs from identifying any individual jurors in any way. A comment about the jury as a whole, that they arrived at 9 o'clock, that they couldn't hear the evidence or something to that effect is not what I'm talking about. I'm talking about individual comments about individual jurors and their behavior. That is prohibited. All right. Thank you very much for your cooperation. All right. Is the state ready to proceed?
State's ready, Judge.
Put it in
Is the defense
writing.
ready?
If it's allowable, Your Honor, I would ask for 5 minutes. That's okay. But it's up to the honorable court's discretion.
Well, I think we really need to get started. Is there a particular reason you need 5 more minutes?
I'm just trying to find a single site, and that's it.
Okay. I'm going to let you do that while the state gets started. All right. You may bring the jury in. Thank you.
Wow. This is just crazy. And I watched Sylvia's recap last night. She mentioned that one juror seemed to be like nodding along when the state was doing questions. And then she gave a general statement that everybody seems to be taking notes. It seems like they were taking notes a lot when there was some writing on the easel, the whiteboard, the notepad. I don't think anything that she described was like, this person looks like this. This is when they leave the court every day. Like nothing like that. Absolutely nothing like that. So you can't report on what juror demeanor is like? That to me sounds close to saying somebody cannot be in the courtroom.
You may be seated. Thank you. Mr. Yalamanchili, you may proceed.
Thank you, Your Honor. Agent Howell, before we broke, I believe we had just tendered into evidence State's Exhibit 160 as a recording of the interview that was conducted with Mr. Edrick Faust on May 9th of 2024.
So this is the police custody
who was present
interview
for that
after
interview?
arrest.
I was present. Special Agent Liz Bigham was present, and Edrick Faust was present for that.
At the time that the interview was done, had Mr. Faust been placed under arrest?
Yes.
Okay. And Your Honor, for the record, at this time, I will seek to publish in chronological order the timestamps that I previously mentioned to the court and defense counsel.
All right. You may proceed.
And I'm starting at 6:03:55.
Hey, how are you? Good. Miss Faust? Hey. Hey, I'm Liz Bigham. I'm with the GBI. This is Jeremy Howell with the GBI. You want to take those off right now? We need to sit and talk to you and do some things. Are you going to act right? Are you sure? Okay. Junior, my hand keys back in there. I can go grab a few of them on you. Okay. Can you use some water or anything?
I'm cool.
You sure? You use the restroom?
I'll just use the restroom for you.
I'm sorry?
I use the restroom.
Oh, you just use the restroom. Okay.
Let's see if I think I got the right key for these. All right, let's go down this a ways. There it is. Okay. Sorry.
I agree, Kristen. The judge has lost her mind.
Here's that. Great. Just in case you want something.
And thank you for the 2. Let me move over here. Oh, sure.
All right. So there's a little bit more information first, and get some information from you, obviously name and all that stuff. And then we'll kind of go from there. Go ahead. So you've got, I think it's about 9 warrants that we've got for you today. I'll explain everything to you. Let me get this filled out and stuff, and then we'll go over everything together, okay? I mean, obviously, we're going to want to talk to you about this stuff, and we can kind of go into all that, but we've got to get through this first. All right? It's Edrick or Edrick?
Edrick.
Edrick, E-D-R-I-C-K?
Correct.
And what's your middle name?
Lamont.
L-A?
M-O-N-T.
All right. And F-A-U-S-T?
Correct.
How old are you, Ms. Faust?
I am 48.
Are you sure? Okay. And what's a good home address for you?
My home address is, well, I got a P.O. box now.
What's like your physical home address?
350 Cooper Road.
350 Cooper Road?
Correct, yeah.
Okay. That's in Athens?
Yes, 05.
30605?
Yes.
Okay. Okay, and how hard are you going to school, Mr. Faust?
I graduated from high school diploma.
High school diploma?
Yeah.
Okay.
City shows? Actually, I went to city show, but I went back to continue. I got a diploma in another school. Okay. Get another further down the road. Gotcha.
All right, you ready, right? I'm assuming? Okay, so let's go over this together. All right, it's 6:06 now. So today is May 9th, 2024. The time is 6:06 p.m., and we're at the I wrote ACCPD, but Athens Clark County Police Department. Your name is Edrick Faust, and you are 48 years old. Your address is 350 Cooper Road, Athens, Georgia, 30605, and you completed the 12th grade in school.
Yes.
You know that Liz Bigham, which is me, and Jeremy Howell over there are special agents with the Georgia Bureau of Investigation.
Okay.
All right? You have a right to remain silent. Anything you say can be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you're being questioned. If you can't afford to hire a lawyer, one will be appointed to represent you before any question if you wish.
Okay.
And you can decide at any time to exercise these rights and not answer any questions or make any statements. Do you understand all of that?
I do.
Okay. And you understand your rights and have these rights in mind. You're willing to talk to law enforcement officers, which are Jeremy and I. You've not been threatened. Has anyone threatened you in any way, shape, or form in law enforcement? Nobody's threatened you? I know you weren't there when they arrested you, so I just want to make sure that nobody out there threatened you in any way. You've not been promised anything. Has anyone ever promised you anything in reference to this? And then if you've been forced in any way to answer any questions or make any statements, maybe decide what's your name, whatever. Okay. So if you want to talk to us, you can sign right there. I'll sign underneath you, and Jeremy will sign underneath me. Thank you.
Yeah.
So let me just get a little bit of information from you first. Obviously.
And I'm pausing the video briefly at 6:08:12, Agent Howell, and I'm going to show Mr. Cruz what's been marked as State's Exhibit 161, Your Honor. And Agent Howell, I'm going to hand you State's Exhibit 161. I want you to take a moment and let me know if you recognize what that is.
I do.
And what is it?
This is the waiver of rights form that was administered during this interview with the information on it, as well as the signatures of Mr. Faust, Liz Bigham, and myself.
All right, and does that appear to be a true and accurate copy of that waiver of rights form that was executed on May 9th of 2024 during Mr. Faust's interview?
Yes.
Okay, Judge, I move to tender 161 at this time.
Any objection? It is admitted.
And, Your Honor, I'm going to continue playing the video for 6:08:12. But before I do that, Agent Howell, just to get some orientation about what we're looking at, where did this interview take place?
This is an interview room that's located at the Athens Clark County Police Department's facility, their main police building that's on Lexington Highway.
Okay. Obviously, we heard the reading of the form and it's been admitted into evidence. Based on your observations of Mr. Faust, did it seem like there was anything that was preventing him from understanding what was happening or anything like that?
Not that I was aware of.
Okay. As the interview progressed, did he seem to understand the questions and respond to them?
Yes.
Okay. And so I'm going to continue playing now, Judge.
You got Cooper Road. How long have you lived at Cooper Road?
Shit, I've been in Cooper Road about 40 years.
40 years? Okay.
40.
40?
40.
Okay. Do you own that house?
No.
Okay, who lives there? Or whose house was it?
Actually, it's my stepmom. How she passed away a month ago.
Oh, no, what happened?
She had a lung cancer or something like that.
Aw.
This is your stepmother, you said?
Yeah.
I'm sorry.
And what is her name?
Her name was Geraldine Hughes.
Geraldine Hughes? And she passed away months ago. So are you still living there? Did she own it?
Yeah, she owned her home, yeah.
Okay. Are you still living there?
I'm kind of like flow. I've been like flow hunting. I've been living with my cousin here and there, so.
Where does your cousin live?
I've been living in Overthorpe County.
Oh, okay. Where's that at?
In Overthorpe, and Marybeth in Santa Claus.
Sandy Cross and Marybeth Road? Where do you lay your head at night?
Well, I've been really just living here and there. I've been here and there and just girl house, over here and over there.
Over here and over there, the girl's house.
Yeah.
All right. So where does the girl live? Somewhere you don't want to talk about?
No.
That's fine. We don't have to. And what's your date of birth?
9675.
Okay. And you're employed, I'm assuming, in Athens Finance?
Correct.
Is that your business, or do you just work for them?
My business.
It's your business? What do you do there? Besides mobile detailing, pressure washing?
That's what I do.
Pretty much that?
Cool.
Do you have, like, regular work, or is it just contracted work here and there?
I do regular work, whatever. I just work.
Okay. All right.
How long you had that business?
I've been in business myself I've been in business for myself on my own for like 4, 5, 5 or 6 years.
Okay.
Okay. What's
And Judge, I'm stopping, as we had discussed, I'm sorry, I stopped about 10 seconds early.
Good. Better than stopping too late.
your number to get you?
This is?
That one's your number?
Yeah.
706-612-6808. That's the best number to get you?
Yeah.
Is that your cell?
Oh.
All right. Your Honor, I'm stopping at 6:10:20 p.m., hour, minute, second, and I'm moving forward to 6:14:01.
Okay, wait. So up here it says 15 hours, 32 seconds, 07 minutes. Wouldn't that be like 3:32? Is this not standardized to Eastern time or something? Did I miss him explain this timestamp at the top? And then this file name says 17 hour, 38 minutes. Thank you, Marianne, for becoming green. Thanks for becoming a member.
Who lived at Cooper Road with you?
At Cooper Road? Actually, back then, 20 years ago, May 28, 2003.
No, 23 years ago. We're talking about 2000.
Was he trying to say he moved back there around 2003 but wasn't there in 2001?
It was obviously misused, right?
I was living with her, yes. But
Okay.
I don't know what relationship I was in or who I was with back then.
Okay. So Miss Hughes lived there.
Yes.
Did you have any brothers or sisters?
My brothers and sisters.
Okay.
My dad was alive back then, yeah.
But was he at Cooper or did he live in Overthorpe?
My dad has been around. He's just been around here and there, yeah.
Yeah. Okay. Who else lived in the house with you? Who lived with y'all back then?
As far as I know of.
Just y'all two?
Yeah.
Okay. And she was your stepmama?
My stepmom.
Where's your real mama?
She passed away 6 years ago.
Oh, okay. You weren't ever really close to her. You were close to your stepmama?
Actually, I've been cool with my stepmom. She raised me with.
And Your Honor, I'm stopping at 6:15:05, And we are going forward to 6:50:30.
Thank you, Sunshine, for another 2 for the cuss jar. It is a time. I had one slip earlier calling it BS. I try to keep it mostly family friendly. I know the evidence we speak about gets into some adult terms. And mentions of an orange VHS tape in this trial too, another one. But thank you for supporting the cuss jar. I think we're getting to that point with this trial.
I'm sorry, Judge, it's not a very precise slider, so.
Were you there when they were building it and stuff like that?
Yeah, I mean, I was in the area. I'm always in that area. I go in that area every day.
Do you really?
Yeah, I call it my home. That's considered my home.
Okay.
Yeah.
Do you physically live at Cooper Road anymore?
Well, you can go there right now, and everybody will know me. They
No,
know.
I meant in the house, like at 350.
No,
you physically live there anymore. Okay. Did it get passed down to you? Or?
Well, my stepmother passed away.
Okay.
When she passed away, but she got sick. She told me she didn't need me anymore. Her niece lived in Rock Spring. She ended up getting the house. She bought the house from her, and she ended up moving up to Willow Mist across the street over here.
Okay.
And she lived over there when she passed away.
So nobody in your family lives there?
And her niece live in the house right now.
Okay.
Yeah.
Okay.
And she just passed.
Okay.
Yeah.
Okay. So when that neighborhood was being, or development was being built, I guess, did you ever go walk around there, or what was that built for, I guess?
I don't know.
Was it mostly like college students, or was it regular people, older Athens people, old
Back then it
people?
was real settled, but now it's not like that anymore. It's like real, like, right now it's like a damn the ghetto, to be honest with you.
Oh, is it really?
Yeah, it's pretty rough over there now.
Why is it rough over there?
It seems like everybody that got pulled from the other side of town, they start getting rid of like housing, the projects and all that. They give them vouchers and they start moving over on this side.
Oh, they did?
Yeah.
Okay.
So it's not like it used to be. It used to be real quiet, so.
Okay. So back then, who was moving in there? What was it primarily?
I say college students and probably some kids. I'll say that because you didn't really see a whole lot of black people in that area.
You did not back then?
Nah.
Okay.
What was there before they built all that?
It was wood. It was old car. All this on Lexington Road, Walmart, everything on Lexington Road was nothing but wood. There's a Lord Stevens, there's a church, Lord Stevens, Walmart. All that was wood when I was a little boy.
Wow, you seen some change.
I really have. And from there's another house over here in this neighborhood. All this land over here where this Dollar Tree and the skate park and all that. All that was nothing but wood back in the day.
Wow.
Yeah, all that wood.
Judge, I'm stopping at 6:53:05, and we're moving forward to 7:02:45.
Were you ever dating anybody else around that time on the side or quietly?
I ain't gonna say that. No, I ain't gonna say that.
I'm not gonna go talk to them.
I ain't know. No.
And Brenda was the primary one, right?
She was primary,
10 years, okay.
No, I don't do no
But what about anybody else, like anyone at Walmart or Conagra or the Perfect Polish? I keep want to call it sparkle, I don't know.
I don't know, man.
But-
I don't, let me tell you something, I don't have some females in my day, so.
It sounds like it. It sounds like it.
What did he
Let
say?
me tell you something, I don't have some females in my day, so.
Did he say I've had some females in my days?
Sparkle, I
I don't know, man.
But-
I don't, let me tell you something, I don't have some females in my day, so.
It sounds like it.
Like, it seems exactly like he could have been in this college town. It's a Thursday night where a lot more weekly night outs tend to take place. And whether you're actually enrolled in that college or not, that's the place to go hang out. They were the same age group. Like, hello? And we heard from Cruz, you know, he was young. He was always flashed out in jewelry. He always dressed nice. He was well put together. In the words of Ian Runkle, Cruz was showing the jury that Faust was bangable while he was in the same age group as Tara Baker. Like, the idea that people are out in the YouTube streets in these comments saying, oh, there's no way Tara and Faust would ever have been in an encounter together, is just such BS. Such BS.
It sounds like
there's
it.
more? It gets
Were you
worse?
juggling any other females around that time? See anybody on the side?
I probably would. I probably was. I don't have a lot of females in my day.
Okay. Do you date white girls, or do you date black girls, or does it matter?
When did that song White Girls come out? That was always playing. That was like this time period, right? The white girls running through my mind. That was like the 2000s. That was this time.
White chick, I had dated one white chick, but it didn't work out.
One white chick?
Yeah.
Who is she?
Her name was Rita Spears, and she's from she's from where Rita from? She's from Carnesville.
How'd you meet her?
I met her one night at a bar.
Why didn't it work out?
Because she bipolar and she wanted me to be with her and call her all the time.
Oh, okay.
And she lived up in Carnesville, Franklin County?
Yeah. I don't really, I don't have no ethic about females, the race, no color, nothing like that.
Right.
I talk to everybody. I'm cool with everybody.
Mm-hmm.
You can go there right now and ask anybody about me
chicks.
when it comes to communication. I communicate because I have a business.
Sure.
I don't mess around, man. I just treat everybody the same.
Okay. Did you ever date anyone over in that Deer Park area?
No.
Any college students, anything like that?
I ain't know nobody over there.
You didn't know nobody over there? Never made friends? You just didn't talk to everybody.
I talk to everybody, but that was my cup of tea to go over there and deal with those people. Those people up across the street. I ain't know nothing about over there.
Why not?
I ain't know nobody over there. That wasn't my thing. I wanted to see my stepmama.
Yeah.
Or whatever. That was it. That's a neighborhood that just came up. I don't know anything about that neighborhood.
Okay.
And I don't have no dealings over there, period.
Anybody from over there ever come looking for you? Just to be friends with or hang out with?
Back then, man, there was a play everybody like, man, it's just a play that came with this coming up. And everybody felt like it's high over, it's expensive. Anybody going over there, so.
That's how it was kind of perceived?
Yeah, everybody go over there.
Okay.
And Judge, we're stopping at approximately 7:05:40, and we're moving forward to 7:08:35.
Where are people getting such incorrect ideas of what's even being argued in this case? Here we have the impression that Cruz, the defense attorney, will say anything to make it look like they were a happy couple. There's been no attempt by the defense team or Faust to establish any type of dating relationship, committed relationship between Faust and Tara. So Like, your argument here isn't even founded on something that's at play. It's made up.
They are for a myriad of charges.
And I'm sorry, Judge, I think I started the sound a little late. I'm going to back up again to 70835.
We've got these warrants. They are for a myriad of charges that range from arson to murder.
What? For me?
And that's what you're talking about, this incident back in 2001. I think there's 9 different warrants, and that's kind of about this, get your side of the story, you know, kind of hash everything that happened, and you know, obviously I think you can pick up on the fact that it involves that area, that park area or whatever. But in my opinion, I mean, you can see that I've done research. Right? Like, area I know, we know about you, stuff like that. But when we're talking about that and we're talking about these charges, there's got to be kind of an explanation as to why you're there, right? And that's kind of what I'm trying to talk to you about. So tell me about why you would be there in that Deer Park area back in 2001 and kind of, you know, engaging in all these sorts of things at one of those duplexes.
I never, that spot over there, that's a place I've never been to. I've started going there throughout the years, like, when people thought, other people, when we started moving in, then. But back in the day, the only reason I go like in the evening time, and it's every blue moon, I gotta get my bike in the evening time, like 3 or 4 o'clock in the evening, I may ride through the whole, you know what I'm saying, ride from one end, the whole thing over there. I don't put it on there. I ain't no business over there. That was my turf. My turf was in our neighborhood where we used to be, because everybody in the neighborhood.
On the other side, the whole Deer Park,
all the way on East Meadow, and all the way in Morning View. I don't have no business over there dealing with them over there, but that ain't my cup of tea. They ain't gonna drink over there, and I don't drink with them, so we up here drinking. If one of my cousins don't come in and pick me up, and we go over there and ride out, they say, I don't have no business over there fooling them people that they ain't doing that to me.
And you said that you rode a bike?
Every once in a while, I may ride a bike. If I went over there, but I didn't deal with that sex.
Would you ever walk over? Just walk over there?
I have no business over there. This is my neighborhood right here. I don't know about people over there.
Across Cooper Road?
Exactly. I don't have no business over there, period.
And you said around 3 or 4 in the afternoon?
I said, yes. I went over there. If I rode a bike, I would go in. But I don't have no reason going over there and messing with them people, period. No reason whatsoever.
And Your Honor, we're stopping at approximately 7:11:15, and we're going to move forward to 7:11:45.
No, I don't do no walking over there for what? I ain't got no business over there walking. No.
Well, you would ride your bike around though.
I mean, I said if I went over there, if it just so happened back in the day, if I just rode my bike, I would ride around and see. I ain't got no business walking over there. If them people were jogging or walking, I ain't had no business singing into them and nothing.
Okay.
I don't. That ain't my gig over there. If I went anywhere, I probably would go to the back then. I would go to the hood up in the Aston Guard. That's probably where I'll be at.
Would you have cut through Deer Park to get to
No, it's not that way.
It's the other way?
Different direction. I don't go that way. I don't have nothing to do with these people over here. I go over in the hood and kick it, but I'll be in my neighborhood. I ain't got no business over there dealing with them people. I ain't getting nothing to. I don't know nothing about it, and I ain't finna mess with them.
Okay.
Period.
Okay.
So I got some warrants on me?
Mm-hmm.
Yeah.
So I'm gonna go to jail?
Mm-hmm.
Really?
They told you were under arrest.
I mean,
That's not a new revelation. They told you were under arrest.
what's a murder?
It's for
Do you remember any kind of incident that happened back then?
Man, I don't even deal with all that. I don't.
No. You don't remember seeing some police activity over in that neighborhood back in 2001? Kind of a big deal.
It was for a while, too, I think.
Yeah.
Like days and days.
You don't remember anything happening back there?
Let me see. Because I used to come over there to see my stepmama, but I ain't really, deal around too tough in it.
Okay. It's kind of like one of the biggest deals that's happened in Athens.
A murder?
Yeah.
Mm-hmm.
Oh, some girl.
Did you know her? No connection to her?
No, never. I don't know, I never saw it. The only time I see that, the only time I seen it was in the newspaper. I ain't never seen it or nothing else about that girl. I don't even know her. I don't know nothing about her.
You know what she looks like?
Sorry.
Oh, okay.
No.
You've never talked to her?
No, never. Never.
Okay.
Don't even know her. Don't know nothing about her at all. All I know is that she was a law student at the UGA, and she was on Farm Drive.
Mm-hmm.
And
Only knows what they say. Didn't even see a picture.
throughout the years, I know that right there they got that's where the rent I was at right now.
Oh, yeah.
Yeah, that's where my blood stayed right beside it.
Your buddy stayed right beside us?
That was after the fact that when we started moving in, when black people started moving in, my partner stayed right beside him.
Oh, okay.
Right beside the actual building. This right here was like in 2017 to 18.
Okay.
Not no recent thing.
Oh, okay.
No, not no recent.
Okay.
Did you know any of her roommates?
I don't know about that.
Did you know any of their boyfriends or anything like that?
No, nobody over there, period.
Did you ever go over there to buy alcohol?
No. I ain't
like that?
Bro, listen, I don't know nothing about those people over there. I don't know nothing about that. But they say that happened.
And, Your Honor, I'm stopping at 7:15:05 and moving forward to 7:16:14. And Agent Howell, kind of just before this portion of the video that we're about to play, had you asked Mr. Faust a question about his awareness of a national database of DNA?
Yes.
National database.
DNA?
Yeah.
My DNA? Man.
It's been a long time. We've made so many advancements and things.
Man.
If you can help us understand why your DNA's in that house, help us. I don't want to put your finger on the wrong. Help us. I'm here to exonerate just as much as I am to hunt.
Y'all come on, take a little deal.
And Agent Howell, in response to your request for Mr. Faust to help you with an explanation regarding his DNA, what was his response?
No explanation was provided.
Okay. And I think that's all I have for you about this interview. And so, Your Honor, if I could have just a moment to.
You may.
Oh, a new version of the Dom list seal.
Agent Howell. We are Miranda form. That's right. I'm going to show Mr. Cruz what's been marked as State's Exhibit 162. Agent Howell, I'm going to hand you State's Exhibit 162. Do you recognize what State's 162 is?
Yes.
All right. How do you recognize it?
I recognize it by the labels that are on the exterior of the envelope. It is item number 10 in Athens Clarke County Police Department's custody. It is described as a bloodstain card for Kris Melton. It also has a GBI barcode on it, evidence property tag CC36694. And it also has our GBI DOFS report number, which is 2001-1002454, and is submission item number 27. And again, it is labeled as a bloodstain card for Kris Melton.
Okay. And so have you encountered that item at any time previously?
I have.
Okay. Can you explain to the jury, well, when you encountered it, is it in substantially the same condition as when you encountered it initially?
Yes.
Okay. And Judge, I'd move to tender the exhibit at this time.
Any objection? No, ma'am. It is admitted.
Okay. Just to clarify, though, were you involved in either the collection or observation of collection of blood, the creation of the card, or any of the testing that occurred at the GBI lab?
I was not.
Okay. What was your interaction with that item?
My interaction with this item was to collect this item, transport this item to the state crime lab, and submit this item to our state crime lab.
Okay. And do you have any direct knowledge of anything that was done with it at the state crime lab?
I believe it was compared to some swabs involved in this case.
All right. And that's all I have about 162, Your Honor. Your Honor, I don't have any other questions for Agent Howell at this time.
Cross-examination, Mr. Cruz.
Jinx, Lisa, stop talking. Let's see if he can ask about other places he may have stayed at.
Good afternoon, Agent Howell. My name is Attorney Ahmad Cruz, and I have the privilege and honor of representing Mr. Edrick Lamont Faust. You've had opportunity to watch that video before, is that correct?
Yes, I have.
And we could both agree that you watched it again in court and you heard it again in court, is that correct?
Yes, sir.
Okay. In regards to speaking to Mr. Faust about the death in Deer Park, would you agree that Mr. Faust's response, as you heard here today in court, is the only time I seen that was in the newspaper?
Yes.
Okay. And he also continued, I ain't never seen that or nothing else about that girl. Is that correct?
Yes.
At that time, did anyone show him a photograph?
No, sir.
At that time or any time during the interview, did anyone tell him Ms. Baker's name?
No, sir.
I'd like to show you what I'm going to mark as defense exhibit
Very good questions out the gate.
49, 50, and 51.
The siren's right on time. All right, the siren stopped. Let's go.
And just to make it clear for the record, and from the video, Mr. Faust said he'd only seen one newspaper article about it. Is that correct?
I believe so, yes.
Your Honor, may I approach the witness?
May?
And let the record reflect that I've shown
You're going to approach with an
the
article that
state
doesn't have
what
any
has been marked
photos.
as defense exhibit 49, 50, and 51.
Thank you.
Ask him if he knows which article he saw. Yep, one has a reward with Tara's picture on it. Good question. I see it coming. Which one did he
Do
see?
you recognize the photographs?
I do.
That photo? And do you recognize those documents? Let me ask you that. Have you seen those documents in your case file?
Yes, I have.
And follow up to that, you reviewed your entire case file, is that right?
I have looked through the entire case file.
Okay,
I'm familiar with the contents of the case file.
okay, perfect.
Now we can ask about the address
do you recall
later.
seeing those documents in the case file?
I believe seeing numerous newspaper clippings and articles in it. This one specifically, I don't recall, but I do recall seeing numerous newspaper clippings in there.
Sure. And the question I have for you is about the photo. Would it be fair to say that the photo of Ms. Baker in those documents that I provided to you is the photo that's mostly used when it comes to public information about Ms. Baker's case?
I would agree with that.
Your Honor, I would move to, and just to make sure you are familiar with those documents, you looked at those documents, is that correct?
Yes, sir.
Okay. Are those fair and accurate depictions of the documents that were in your case file?
I believe so, yes.
Have those documents been altered in any way?
I don't believe they have.
Your Honor, may I approach? Your Honor, I would move to introduce Defense Exhibit 51, Defense Exhibit 50, and Defense Exhibit 49 into evidence. And I would ask to be able to publish same to the jury.
Any objection?
As to the images, no, Your Honor. I didn't read the articles themselves, but I don't think that the contents of the articles themselves should be published to the jury.
I think that's correct. I think we need to redact them before you publish them, but during a break, I'll let you do that and I'll allow you to publish them.
Yes, ma'am.
All right. But they are admitted.
Yes, ma'am. Thank you. And you would agree in your statement to Mr. Faust, you never told him that his DNA was in Ms. Baker's body. Is that correct?
I did not have that opportunity.
Okay. You told Mr. Faust to explain why his DNA was in the house. Is that correct?
Yes.
Outside of her body being in the house,
Wow,
you would agree
good
that
point.
Mr. Faust's DNA was not in the house. Is that fair to say?
Mr. Faust's DNA was inside the house.
Outside of her body being in the house.
Her body was inside the house.
But for her body, Mr. Faust's DNA was nowhere else in the house. Is that correct?
I would agree with that.
You gotta fight.
Now, you asked Mr. Faust was asked about dating, and I believe the word, and if I am wrong, please forgive me. But I believe he was asked about dating, I'm gonna use a different word, white women. Is that correct?
Yes.
Okay. And Mr. Faust's response was that he had only dated one white chick, correct?
Yes.
And I want to emphasize the language you asked him, or he was asked specifically about dating. Is that fair?
Yes.
And Mr. Faust made clear that he doesn't discriminate when it comes to dating. Is that fair?
That's my recollection.
Okay. I also want to talk about the first portion of the interview that was played. I believe the state stated on the record that they stopped at 6:08:12. Would you agree that from the first portion, the very first clip that was played for the jury, Mr. Faust had already been advised that you all had 9 warrants for his arrest?
Yes.
The second clip that was played in regards to the conversation with Mr. Faust, Mr. Faust had been advised at least twice by the time we got to the second portion of the state's clip that you all had 9 warrants for his arrest. Is that fair?
Yes.
My final question for you is on May 9th, this interview was conducted. Is that right?
Yes.
And May 10th was the date that you all collected the buccal swabs.
The buccal swabs, yes.
Read it on the board. So you take oral swabs in May 2010. Where are these sent?
The arrest warrants were obtained on May 9th as well, before the interview. Is that correct?
Yes.
Just to make sure I have this accurate, interview takes place on May 9th, arrest warrants secured on May 9th, but arrest warrants were before interview. Is that fair?
Yes.
Okay, and then after that, May 10th, buccal swabs?
The buccal swabs were obtained on the next day, yes.
Okay. Thank you so much. Those are the questions that I have for you.
Thank you.
Any redirect of this witness?
No, Your Honor.
You may step down. All right, it's 12:30, ladies and gentlemen, a very good time for a lunch break. I'm going to send you to lunch and ask you to return at 1:45, so an hour and 15 minutes. As I've said throughout this entire time, please, of course, don't discuss the case with anyone. Don't do any independent research on your cell phones or computer or any other manner.
Don't
go
talk
to
to
any
the
of the
media.
locations, of course, you may have been hearing about. Other than that, enjoy your lunch. We'll see you back here at 1:45. Thank you.
But don't let the media look at you.
It doesn't need to be in front of the jury.
All right, let's see if they come back when the jury's out. No. I guess they don't come back. I don't know what Yalamanchili wanted. And see, that's why we start late. Oh, hello? Hiding. Just going below her desk. Okay, random story, random cat lore here, because I see your favorite painter. Good to see you as always. What if he coughed on the grapes and in Walmart and she doesn't wash her fruit? When I first moved down to Cocoa Beach area. Well, that's not true. I'd been here like 4 months, but I hadn't really done anything yet because I was still traveling back and forth. I wasn't planning on working for a company permanently and didn't actually move all my stuff down, so it took a few months to go back and forth. When I settled in, first holiday really down here for me was the 4th of July. And I didn't really have anything in my apartment. So I'm like, well, let me go to Walmart. I know it's the 4th of July, whatever, it'll be fine. Go to the Walmart, and some guy has his like foot up on the little lower fridge grill where like the open air cooler is for the produce, where you get like lettuce, grapes, the jarred peach things, grapefruit. And I'm like, why is he just putting his foot up there like that? Turns out he was peeing in the Walmart on the grapes. So please wash your fruit. Please wash your fruit. There we go. Random cat lore.
Welcome back, ladies and gentlemen. We are ready to resume the trial of State of Georgia versus Edrick Faust, SU 24CR0547. Is the state ready to proceed?
Ready, Your Honor.
Is the defense ready to proceed?
Yes, ma'am.
All right, you may call your next witness, Mr. Bolden.
Thank you. State would call Xykiera Sims.
Could you get Xykiera Sims, please? Thank
Okay,
you.
this is going to be about the DNA. So there was a motion. You want to look at that motion quick, actually? So where do I have it? I have it somewhere. Xykiera Sims and Ashley Hinkle. All right. So back on October 2nd, this was also denied if anybody needed to know. Motion to exclude Xykiera Sims and Ashley Hinkle's expert testimony interpreting TrueAllele results. So on or about Monday, September 29th, 2025, undersigned counsel contacted the state via email for information related to the experts the state intended to call on this matter due to the sheer number of witnesses and scientific reports provided over the 24-year history of this case. As of October 2nd, undersigned counsel has not received a response. At this time, Mr. Faust does not have a CV on any identified expert, and some lack conclusive test summaries. Thus, as part of resolving our Daubert issues, and in consideration of the court's time and resources to preserve Mr. Faust's right to a fair trial under the Sixth Amendment, and to allow Faust an opportunity to employ an expert to meet the state's expert, so we need to know what they're going to be qualified for so we can find a counter expert. Mr. Faust respectfully requests that the Honorable Court ask the state to specifically identify the expert witnesses it intends to call in its case in chief. The failure to file a Daubert motion to said expert does not constitute Mr. Faust's waiver to challenge said expert. However, meeting the Honorable Court's timeline and addressing other issues in Mr. Faust's case does not allow for a Daubert challenge to each and every expert for purposes of credibility and effective time management. At this time, Mr. Faust must guess whom the state may or may not call as an expert witness based on its shortened witness list. We request that the Honorable Court order the state to provide written notice of the experts it intends to call and in what areas of expertise, and provide a copy of said experts' CVs. Then, more critical to what's supposed to be presented. DNA evidence in a criminal case usually consists of skin cells, saliva, hair, semen, or blood, collectively referred to as biological material, that is collected at the scene of a crime. After collection, lab technicians use a process called polymerase chain reaction, PCR, to make copies of the DNA contained within the biological material collected. Using PCR, a lab copies a short segment of the DNA of said biological material millions of times. This process results in a substantial number of specific targeted segments of DNA, which can then be typed and compared. The enlarged sample can then be compared to a direct DNA sample, such as a swab of saliva, from a specific individual for a possible match. This process becomes much more complicated, however, when the DNA sample contains cells from multiple individuals. In scenarios involving such complex mixtures of cells, lab technicians can use computer software to analyze and interpret the amplified DNA samples and compare them to direct samples from specific individuals. Hey, Baker Raid, we are just looking at a quick pretrial motion related to the expert who's about to take the stand now in this very rabbit hole wild trial against Edrick Faust in Georgia. I know a lot of you guys over in Baker's channel watched the Christopher Wolfenbarger trial, also a Georgia cold case trial. Hope if you don't know much about this one, you will be excited to see some testimony about TrueAllele and DNA and why we're dealing with this cold case in 2026. So these programs are called probabilistic genotyping software. Probabilistic genotyping software uses biological modeling, statistical theory, computer algorithms, and probability distributions to calculate what is known as a likelihood ratio. The likelihood ratio is a numerical fraction expressing the probability that the DNA mixture contains DNA from one or more specific individuals from whom a direct DNA sample was obtained. The GBI uses the TrueAllele probabilistic genotyping software. TrueAllele is a proprietary commercial computer program developed and sold by a private company called Cybergenetics based in Pittsburgh, Pennsylvania. Like other similar programs, TrueAllele applies the information derived from DNA profiles to complex algorithms. The algorithms compare different statistical models to the actual data and weigh the probability that the model matches the data. Neither Mr. Faust nor defense counsel understand how TrueAllele's algorithm works to reach its conclusions. So in other words, we need to fight a state presenting expert testimony on this. We would also need to be prepared with hiring our own expert because it's not like a layperson's knowledge. Furthermore, based on the proprietary nature of TrueAllele, the GBI has been trained to use the software, but they also do not understand or know the algorithm or source code underlying the program and how exactly it works. In fact, the results of the TrueAllele software cannot be manually reproduced or confirmed by the GBI. And as we're reading this is not the only case where TrueAllele has been contested. TrueAllele's source code is unavailable to the public and to the labs that use said software, including the GBI. When another probabilistic genotyping software is strmix, which is similar to TrueAllele's source code, was made available to experts, they found errors that affected several criminal cases. They say, see David Murray, Queensland authorities confirm miscode affects DNA evidence in criminal cases. After this, I'll OCR this link and paste it in the chat. It's not, can't click it from this document, so I'll defer on that for like 10 minutes. In this case, the state, through its lab technicians and additional expert witnesses, will introduce testimony to a likelihood ratio of Mr. Faust's DNA being included in the complex DNA mixture taken from the swabs of the victim's body, hereinafter the DNA mixture. The state will use the likelihood ratio as evidence that Mr. Faust committed the crimes against him in the above referenced indictment. Excluding the victim's own DNA, the swabs taken from her body contained a complex mixture of DNA from multiple individuals. The collection and preservation of said evidence is vital to obtaining an accurate and successful DNA profile. If samples are not handled properly in the initial stages of an investigation, then no amount of hard work in the final analytical or data interpretation steps can compensate. So you can't fix it once it's already messed up. OCGA 24-7-702B, which was updated to the 2025 version, which governs the admissibility of expert testimony, provides a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if, 1, the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. 2, the testimony is based upon sufficient facts or data. 3, the testimony is the product of reliable principles and methods. And 4, the expert has reliably applied the principles and methods to the facts of this case. In determining the admissibility of expert testimony, the Honorable Court must assess both 1, the witness's qualifications to testify within a particular area of expertise, and 2, the relevancy and reliability of the proffered testimony. So it might be relevant, but is it reliable if this expert, if their lab, if they can't reproduce these results? So we got some cases cited here. The standard proffered by Daubert, quote, entails a preliminary assessment of whether the reasoning or methodology underlying the testimony is scientifically valid and whether that reasoning or methodology properly can be applied to the facts in issue. In making a determination as to whether an expert's testimony is reliable, many facts are considered, including whether a theory or technique can be tested, whether it has been subjected to peer review and publication, the known or potential rate of error for the theory or technique. And remember, we have this other company, STR Mix, that once it becomes public, oh, we can look and all of a sudden we see the errors. But we didn't know because prior to the algorithm becoming public for that company, nobody could go and find out for themselves. 4, the general degree of acceptance in the relevant scientific or professional community. And 5, the expert range of experience and training. So then we have a cite to a Georgia case. It says, the test of reliability is a flexible one, the specific factors neither necessarily nor exclusively applying to all experts in every case. In determining the relevance and reliability of the principles underlying proposed expert testimony, the focus must be solely on principles and methodology, not the conclusions that they generate. So, as we usually see, can't just get into ultimate conclusions. Especially it's the jury's determination. Lastly, the proponent of the expert testimony carries a substantial burden. So the person trying to introduce a specific expert witness, they're the ones with the burden under Rule 702. The burden of laying the proper foundation for the admission of the expert testimony is on the party offering the expert, and admissibility must be shown by a preponderance of the evidence, which isn't the highest standard. Most relevant to Mr. Faust's challenge to the introduction of Ms. Hinkle and Ms. Sims. So Ms. Sims is who's being called to the stand that we're about to watch. I believe Hinkle is going to testify as well. Maybe they're not calling her anymore, though. Her potential expert testimony regarding the introduction of TrueAllele's interpretation of the low-grade DNA mixture is that neither Ms. Hinkle or Ms. Sims know how TrueAllele actually works. Even more, Ms. Sims nor Ms. Hinkle cannot verify the results of TrueAllele to determine the accuracy of same. Furthermore, Mr. Faust asserts that the TrueAllele DNA results should be excluded because TrueAllele, 1, lacks insufficient peer review, 2, questionable testability, 3, insufficient empirical testing for error rate, and 4, a lack of general acceptance in the relevant scientific community. So wherefore, they at least want the state to provide a copy of the CV so they can determine if they want to bring in their own expert. And then let us provide proffered testimony and exclude Ms. Sims and Ms. Hinkle's proposed expert testimony regarding same. So this was back in October of 2025. So let's see how this carries out. I will go grab that link real quick if you guys want to read the article that was mentioned in the chat. And I'm also going to drop a link to Broken Baker. So if you guys don't already follow him, check the chat for his link.
You can go ahead and have a seat. Ma'am, if you could please raise your right hand. Do you swear or affirm that your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. And if you could start by stating and spelling your name for our court reporter, please.
It's Xykiera Sims, spelled Xykiera, last name Sims.
And how are you employed, ma'am?
I'm employed with the Georgia Bureau of Investigation, also known as the State Crime Lab, and the Division of Forensic Science.
And what is your position at the State Crime Lab?
I am a forensic DNA analyst.
How long have you been employed by the Crime Lab?
Over 4 years.
And based on your time at the State Crime Lab, are you classified as a senior scientist?
Yes.
Can you please explain what your job entails?
I receive evidence from state and local agencies in which I perform DNA analysis on. I also interpret data as well as generate reports that summarize my findings and conclusions. I also testify in court when needed.
Can you talk a little bit about your educational background?
I received a Bachelor's of Science in Forensic Science, as well as a Master's of Science in Biology from Western Carolina University. I also went through in-house training at the GBI, in which we were given lectures, PowerPoints, and literature reviews that outlined the entire DNA analysis process. We also were given mock case samples in which we performed the DNA analysis process on. We had to take and pass several written, oral, and practical exams. And then I went through a phase of supervised casework.
Ms. Sims, just briefly, what is DNA?
DNA stands for deoxyribonucleic acid. It is the genetic blueprint of life. You receive half from your mother, half from your father, and DNA is unique to each individual with the exception of identical siblings.
Can you explain briefly how DNA testing is performed?
We start by taking a cutting of a sample, placing it in a tube with chemicals to release any DNA that may be on that evidence item through a step called extraction. We then figure out how much DNA is in that sample through a step called quantification. We make many copies of specific regions of interest along the DNA, and then we separate and detect those copies in order to establish a visual representation of your DNA known as a DNA profile.
Okay. And is what you've just described the well-established DNA analysis method that's been around for approximately 25 years?
Yes.
Also, let me show
are you
some respect here. I missed this while I was reading. Sheriff Chuck, thank you for gifting 5 memberships. If you guys just got a membership, you might have said thank you already. But in case you didn't, say thank you to Sheriff Chuck. Big, big thank you.
Personally certified, ma'am?
I am not.
Okay. And are you a member of any professional societies?
I am not.
Have you testified before in court?
I have.
Approximately how many times?
13.
Okay. And are those in various superior courts throughout the state of Georgia?
Yes.
Okay. And have you been qualified as an expert in those times that you've testified in court?
Yes, I have.
Your Honor, at this time I would move to tender Ms. Sims as an expert in forensic biology and DNA analysis.
Any objection?
Our objection from a prior hearing, but we respect the Honorable Court's ruling. We would have the same objection.
The same objection. Thank you. I'm going to overrule the objection and admit this witness as an expert in forensic biology and what was the other one that's
DNA analysis, Your Honor.
forensic biology and DNA analysis. You may continue.
Ms. Sims, before we get into DNA testing that you did in connection with this case, I want to kind of fast forward a little bit to August of 2024. In that time period, were you asked to create cuttings from certain pieces of evidence that had already been submitted to the crime lab?
Yes, I was.
And may I approach the witness, Your Honor?
You may.
All right. Ms. Sims, I'm going to hand you first what has previously been marked or entered into evidence as State's Exhibit 25 and State's Exhibit 143. Have you already got your gloves on? Okay, excellent. Take a look at those. You recognize those items, ma'am?
I do.
And so essentially is State's Exhibit 143 an envelope containing cuttings that you took from State's Exhibit 45 and then sealed into an envelope?
Yes.
You recognize that by the unique DOFS case number as well as your initials on State's 143?
Yes, the unique Division of Forensic Science case number as well as my initials and date.
I'll take those back and swap some out. Same question here. I'm handing you what's been previously tendered into evidence as State's 26 and State's 144. And ask you the same question. Do you recognize those, ma'am?
I do.
And just as before, Ms. Sims, did you take the contents of States 26 and make cuttings of that, which you then placed into States, I believe, 144?
Yes, I did.
And just as before, do you recognize that by the unique Division of Forensic Science case number as well as your initials and date of August 30th of 2024?
Yes, I do.
So now I do want to go back to earlier in 2024. In, I want to say, February or March of that year, was certain DNA analysis requested on the case involving a victim by the name of Tara Baker.
Yes, our first service of male DNA screening.
Okay. And can you briefly describe how that testing was performed?
We took a cutting of the swab submitted within the kit. We placed it in a tube with chemicals to release any DNA that's present. We then figured out how much DNA, specifically looking for the presence of any male DNA within that sample.
And I don't want to get too in detail about it, but what was the testing kit that you used to screen for the presence of male DNA in this case?
We used the Quantifiler Trio quantification kit.
Okay. And if you know, ma'am, how long has that particular kit been used by the GBI Crime Lab?
The GBI validated in 2017 and started implementing it in 2017.
And Ms. Sims, is that particular kit more sensitive than testing that existed back in 2001?
Yes, it is.
And when you used that particular kit, did you do so on 3 separate items that had been submitted from the sexual assault kit collected at the time of Miss Baker's autopsy?
Yes, I had 3 items. I had item 2B, rectal swabs. I had item 2J, oral swab B, and then 2I, oral swabs B, and then 2J, oral swabs A.
Okay. And can you please tell the jury what, if any, results you had when you screened for the presence of male DNA in those 3 pieces of evidence?
Those 3 pieces of evidence all revealed the presence of male DNA.
May I approach, Your Honor?
May?
May I hand you what's been marked as States 1, 3? Do you recognize that, ma'am?
I do.
What is it?
It is the male DNA screening report that I generated.
Okay. Does that report accurately summarize the results of the male DNA screening test that you just described to the jury?
It does.
163, Your Honor.
Any objection?
No, ma'am.
It is admitted.
Okay. Moving forward, after you had determined that there was an amount of male DNA present in each of those items, 2B, 2I, 2J, what was the next step that you undertook, ma'am?
All 3 of those pieces of evidence items went on to a DNA typing request service.
Okay, and if you could briefly describe how that test is performed.
We took a cutting of each of those evidence item samples. We placed it in a tube with chemicals to release the DNA. We used a specific DNA extraction method that allowed us to separate into 2 fractions, one of which is non-sperm fraction, and then the other sperm cell fraction. We then figured out how much DNA was in those samples. We then made many copies of specific regions along the DNA, and then we separated and detected those copies and established DNA profiles.
Okay. And so you spoke a little bit about fractions, and I want to talk just a little bit more in detail about that. Can you describe how this particular step in your analysis is able to separate, I think you said sperm cells from non-sperm cells?
Hang on a second, Mr. Bolden, if you'll just wait for just a moment. All right, you may ask that question again.
Ms. Sims, I believe my question was if you could speak in just a little bit more detail about how this differential extraction step is able to separate, I believe you said sperm cells from non-sperm cells.
It's called a differential extraction, and it utilizes the structure of sperm cells to its advantage. So we start by taking the cutting, putting it in a tube with chemicals to release the DNA. This will be any non-sperm cells. Then we are able to move that to a separate tube and categorize that as our first fraction or our non-sperm fraction.
All right, hang on just a moment, please. Yes, sir.
We may need to send the jury out for this one, Your Honor.
All right, ladies and gentlemen, I'm going to send you into the jury room. Please don't discuss the case.
Sorry, guys, I'm sending a link to Ali from Defense Diaries. Let's see. Get this jury out, get my picture up.
You all may be seated. Before we get started, I just want to make sure that everyone in the courtroom
Oh my gosh.
has their cell phone put away and off. There's a lot of distraction going on from people coming and going in the courtroom to the outside and back again, and it is very distracting. And so, first of all, I'm going to ask everyone who's in the audience if you can remain seated as much as possible. That would be incredibly helpful. But also, our bailiff is doing a really good job of making sure that people are not using their cell phones, and I appreciate that very much. But she's in charge, and you cannot have your cell phone on or out. And so I ask everybody to cooperate. If you don't, you're not going to be able to stay. Thank you very much. All right, Mr. Cruz, go ahead.
Sure. So the testimony from Ms. Sims is extremely prejudicial because GBI, as a policy, they do not refer to second fraction cells as sperm because second fraction could be skin cells, it could be saliva, it could be sperm. But the testimony that Ms. Sims has given is outside of the scope of what she would be able to testify to as a GBI agent. She just looked directly at the jury and told the jury that she has non-sperm cells as well as sperm cells. And there is no evidence in this case, but it has been put before the jury at this time that the DNA that was found was sperm.
All right, thank you. Mr. Bolden, any response to the objection? All right.
Yeah, I disagree. I think that
The witness is Ms. Sims, is there a GBI policy that you...
Mr. Cruz, we're not going to go there.
I'm sorry,
Okay.
I'm sorry. But this is...
So I'm making a ruling about your objection. We have had a hearing outside the presence of the jury where this court ruled that this testimony is admissible. We've gone through a lot of this, and I'm going to overrule your objection.
Well, I'll ask you this, Your Honor. We didn't get into sperm at the... I'll say this. I don't think I'm asking for at this time is an instruction to the jury. But if it's if you're saying you're denying my request, I accept that ruling. But I would ask if I could have the opportunity to flesh that issue out for the purposes of the appellate record if need be.
Not at this time, Mr. Cruz, and I'm overruling your objection.
Yes, ma'am.
If you would like to
can't
submit some
proffer?
sort of jury instructions that we can talk about in terms of alerting the jury to your issues, we'll do that at charge conference. But this testimony has already been ruled admissible by this court at a previous hearing, and I'm not overturning that order. So
Yes,
that'll
ma'am.
be all. Thank you.
Not with the
Anything
issue
else
to the
before I bring the
sperm?
jury in? All right, you may bring the
This is
jury in. Thank you.
crazy. Nope.
You may be seated. Mr. Bolden, you may begin. If you
Thank
want
you,
to
Your Honor.
ask that question again, you may. We were, I've distracted you all from an announcement, so go ahead.
And Ms. Sims,
What?
basically what I want to get to is in the process.
What was that commentary?
We were, I've distracted you all from an announcement, so go ahead.
And Ms. Sims, basically what I want to get to is in the process of this differential extraction, does that always result in a perfect separation of male DNA from female DNA?
No, it doesn't.
Can you speak just generally to how, I guess, there might be some, it's a horrible word, but I can't think of anything else, commingling of those after a differential extraction?
It is sample dependent, and it can be how much male DNA or female DNA we had to begin with. There could be some carryover between both of the fractions.
Thank you. Now, after you perform this differential extraction on these three pieces of evidence, I think we talked about 2B, 2I, and 2J, were you able to obtain a DNA profile from the first fraction of all three of those pieces of evidence?
Yes, I was.
And in all three instances, to whom did the DNA profile belong in that first fraction?
The DNA from the first fraction of 2B, 2I, and 2J all match the profile of Tara Baker.
Now, as it relates to the second fraction of each of these pieces of evidence, I think maybe we should go one at a time. So I want to speak first to item 2B, which is the rectal swab.
You may.
All right, so this is technically, oh, we don't get to hear this. Yeah, I think the chat's all on the same page in agreement here that the jury's getting a lot of exercise. Does anybody dispute that? I always, when we're quiet like this, I always feel like I can, I'll get a hint of what's happening, even though we never do. Co-counsel's arguing up there. Oh, they're going to kick the jury out, aren't they? It looks like they're going to kick the jury out.
I need to take care of a matter that is unrelated to this moment, but I need to take care of it now. And so I'm going to ask you to go into the jury room and not discuss the case. I'm going to let you step down and have a seat outside and stretch your legs and things of that nature, and we'll be with you as soon as possible. Thank you very much. If you'll go into the jury room, don't discuss the case.
Is this like,
And
I
you
don't
may
want you
step
to,
down.
I don't want you to think there's an issue with the line of questioning, even though that's exactly what we're going to take up when you leave.
May I be seated? Thank you. All right, everyone be at ease for a couple of minutes.
Oh, Okay, I guess it is a separate issue. Well then. Or not, because then they all come back at the bench. Great view. Bring back the Dom Whiz. Money Sunshine says her fringe is cringe. I don't think they want the media hearing whatever they're talking about because the jury's out, but they're still approaching. Not the hokey pokey in and out of the courtroom.
Ready?
Yes, ma'am.
All right, thank you. You may bring the jury in.
All right, jury's coming back in, whatever that was.
So there's nothing. Y'all may be seated. Thank you. All right, ladies and gentlemen, thank you for your patience. We're ready to resume. Mr. Bolden, you may continue.
Thank you, Your Honor. Ms. Sims, I want to, okay, we were talking, if I remember correctly, about what data or conclusions you were able to make related to the second fractions on each of these three items of evidence, 2B, 2I, 2J. Does that sound right?
Yes.
Okay. I'm going to go a little out of order, and I want to start with item 2I.
Now we're switching. We're not starting with the rectal swab.
Two I, is that you have that marked as oral swabbings B?
Yes, that's what it was labeled as.
Okay. And so in the second fraction of item 2I, were you able to develop a partial major DNA profile in that particular fraction?
Yes, the DNA was obtained from at least two individuals, and a partial major DNA profile was developed that could not be contributed to Tara Baker or Kris Melton.
And was that partial major profile obtained that you said did not belong to Tara Baker, did not belong to Kris Melton, was that eligible for entry into CODIS?
Yes, it was.
Okay. Is CODIS a national database of DNA?
It is.
And are there approximately 23 million samples in CODIS as of December 25?
Yes.
Okay. And once an item is entered into CODIS, is it compared on a routine basis to other profiles found in that database?
Yes.
Okay. Okay, now I'm going to go back to 2B and 2J. Did you obtain information related to DNA profiles or potential DNA profiles in each of those items?
Yes, DNA data was obtained from the second fraction of both of those items. However, due to a complex mixture and low-level data, it was sent off to TrueAllele analysis.
Okay. And would that be for each of those, 2B, which is rectal swabs, and 2J, which is, I believe, this is where I get really confused, oral swabbings A?
Yes.
And you mentioned that those were forwarded over to TrueAllele. Ms. Sims, are you trained in TrueAllele?
No, I am not.
Okay, and so that data, then just to be clear, was forwarded, almost dropped my pen.
Oh my God.
Forwarded to another scientist who is trained to use TrueAllele?
Yes.
Okay. And just like before, Ms. Sims, as it relates to the DNA typing that you were able to do in this differential extraction process, did you create a report to summarize your findings,
Yes.
just like before?
Yes.
Okay. I can approach, Your Honor.
You may.
I'm going to hand you what's been marked as 164. Is that just a copy of the report that you generated summarizing the findings that you just discussed with the jury?
Yes, it is.
Any objection?
No, ma'am.
It's admitted.
All right. Ms. Sims, lastly, at some point after doing the DNA typing analysis that you just described, were you able to conduct DNA analysis with the partial major profile that you just described in item 2I, comparing that to a known sample of a DNA obtained from Edrick Faust?
Yes, I was.
Okay. And from where did you obtain that DNA profile of Mr. Faust?
It was from a known reference sample that was submitted.
Were those Buccal swabs?
Yes, those are Buccal swabs.
Okay. And particularly as it relates to any analysis that you were able to perform between that partial major profile in item 2I and the known Buccal, known profile obtained from the Buccal swab of Mr. Faust, what were the results of that comparison?
The DNA that was obtained from item 2I, the partial
Did he word that as his own, as her analysis, his question?
reference sample that was submitted.
Were those Buccal swabs?
Yes, those are Buccal swabs.
Okay. And particularly as it relates to any analysis that you were able to perform between that partial major profile in item 2I and the known Buccal, known profile obtained from the Buccal swab of Mr. Faust, what were the results of that comparison?
The DNA that was obtained from item 2I, the partial major profile was compared and it was a match to Edrick Faust, and the frequency in which we would expect the particular DNA profile, the partial major developed, is 1 in 800 quadrillion, and that's 800 followed by 15 zeros. And that's how often we would expect to see that particular partial major DNA profile in a given population.
So 1 in 800 quadrillion, did I get that right?
Yes.
And if you know, ma'am, approximately how many people are located on the planet?
Approximately 8 billion.
So I kind of have a problem. We didn't get an objection from the defense, but his question said any analysis you were able to perform, and then she recites the conclusion, but this is really TrueAllele. This likelihood ratio comes from TrueAllele.
Ms. Sims, those are all the questions that I have for you. Defense counsel may have some questions. Thank you, ma'am.
Cross-examination, Mr. Cruz.
Good afternoon, Ms. Sims. How are you?
Good, how are you?
I'm doing well. Thank you so much for asking. My name is Ahmad Cruz, and I have the privilege and honor of representing Mr. Faust. Is it okay if I ask you a couple of questions?
Not the authority.
All right. I want to go back to something you mentioned on direct examination. You mentioned a non-sperm fraction and a sperm fraction. Do you remember making that statement?
Yes.
Did you test the DNA for sperm?
No, it's not a confirmatory test. The extraction method itself theoretically separates into those fractions.
Were you aware that GBI did conduct a sperm test?
On the
Swabs. Correct, that you had.
I was not aware.
Okay, so you're not aware that the GBI determined that those swabs did not contain sperm?
I was not aware.
And just to make sure we're clear, you didn't test it for sperm, is that right?
I did not.
There you go. Cleared that
and the
up.
swabbings that you tested, is it fair to say that you tested 2 oral swabs?
Yes.
Okay, and 1 anal swab?
Yes, labeled as rectum and oral A and B.
And pursuant to GBI policy and your testing, it is common to receive 2 or more oral swabs. Is that fair?
I think it depends on the specific kit, what you receive within the sexual assault kit.
Sure. What do you typically receive?
We typically receive orifice swabs. We do see oral swabs.
How many? Just typically, on average.
On average, I usually see 1.
Okay. How long has the GBI had access to TrueAllele?
I'm not sure. I'm not trained in TrueAllele.
Okay. In this case, was it uncommon to receive 2 oral swabs?
I couldn't say.
Well, you said on average you receive 1. So you don't know if it's common or uncommon if you see 2?
I wouldn't say that I haven't seen 2 before, but I also, on average, I typically see 1 oral swab package labeled, but it is case specific and kit specific what they collect and how they label them and what they submit.
Sure, that's fair. You've seen kits where you've had 3 oral swabs, is that correct?
Not that I recall.
Never?
Not that I recall.
And how long have you been with GBI?
Approximately 4 years.
How long have you been in the division dealing with DNA?
4 years.
Course indulgence. No further questions, thank you.
Any redirect, Mr. Bolden?
Yes, Your Honor.
Go ahead.
I forgot. My apologies. We were talking about the DNA analysis that you performed on that partial major profile from item 2I with the known reference sample of Edrick Faust. Just like before, did you reduce your findings that you just testified to in the form of a report in that case as well?
Yes, I did.
Yes, freedom ring.
Approach the witness, Your Honor.
Okay.
This is stage 165 in Sims. Is that just a copy of your report related to the comparison that you did between that partial major profile and the known sample from the defendant, Edrick Faust?
Yes, it is.
Any objection?
No objection. I think I have a continuing on the record regarding the reports with hearsay, but otherwise, no objection.
All right, it is admitted.
So this is just, that was just Bolden forgetting to admit the report.
Any recross, Mr. Cruz?
No, ma'am.
May this witness be excused?
Ask that she be excused, Your Honor.
Any objection from the defense?
No, ma'am.
You are free to go.
All right, and so we're going to get another, I think Ashley is up next. We'll see. But great reaction from Freedom Ring, and I feel like it's been confusing on purpose. Freedom Ring says, wait, it's only non-sperm DNA in the mouth that pertains to Faust? We have no semen, positive test for semen on the, what was believed at the time to be the oral swabs. And I put it in the chat, but didn't say it out loud because we were listening. But if you want to go back and watch the testimony of the person who did the testing in 2001 on these swabs looking for the presence of seminal fluid, that was Jennifer Corsi, GBI agent, did the test, tested the swabs. They were negative for semen, negative for partial semen. So, and then Freedom Ring's like, well, dang, the state has nothing. Because the way that this type of DNA can be found with this new and improved technology, which is why it's interesting that Jeremy Howell was up there. We have him in the interview saying the technology is so good, it can detect like anything. Well, it's not DNA from sperm. That DNA could have gotten there because someone shared a drink, or they were making out at the Thirsty Thursday night at this Mexican restaurant. No sperm. And I still think there's a huge burden for the state to overcome, even if it had been sperm. How do you say it wasn't consensual? The best way to say it was not consensual is suggest that Tara was in a committed relationship that wasn't falling apart with Kris Melton, and that she wouldn't have been out trying to have other hookups with other men. And a combination of hoping the jury can't picture that Tara Baker would hook up if it had to be a sexual interaction with somebody outside of her own race, which doesn't match the evidence, the testimony about Tara Baker's character. She liked everybody. She had no racial bias. So, and we also heard through Faust's own interview, he doesn't discriminate, and, you know, he dealt with a lot of females or whatever. So there's that. Next witness, yeah, they could have smoked together. And so, yes, the defense is still disputing whether or not this other swab is actually a vaginal swab and not an oral swab.
Ma'am, if you could raise your right hand, please. Do you swear or affirm your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can have a seat. And ma'am, if you could start by just stating your name and spelling it for the record, please.
Ashley Hinkle, ASHLEY, HINKLE.
And how are you employed, ma'am?
I'm employed at the Georgia Bureau of Investigation in the Forensic Biology Section in Decatur, Georgia.
How long, or what is your position at the GBI Crime Lab?
I am a forensic biologist. Technically, I'm called a Crime Lab Scientist 3.
And how long have you been employed there?
It will be 20 years in July.
Can you please explain what your job entails?
Primarily, my job entails examining evidence for the presence of bodily fluids. If those are there, I attempt to attain a DNA profile from the evidence, and then I compare that to a DNA profile obtained from what's called a reference sample, which is a sample collected directly from an individual. I then write reports and peer review the work of other scientists. I'm also trained in a computer program for complex mixtures called TrueAllele.
And we'll certainly talk more about TrueAllele in just a few minutes. Can you speak a little bit to your education and training that qualifies you to perform those tasks that you just described?
I have a Bachelor's of Science in Biology from East Carolina University and a Master's of Science in Forensic Science from Marshall University. I also have extensive in-house training at the Georgia Bureau of Investigation and the National Forensic Science Technology Center in Largo, Florida. And I participate in continuing education on a yearly basis, as well as proficiency testing.
Ms. Hinkle, briefly, what is DNA?
DNA stands for deoxyribonucleic acid. It's found throughout our bodies in what's called our cells. It gives us unique characteristics, such as the color of our eyes and the color of our hair. And no two people have the same DNA except for identical siblings.
Okay. Can you speak a little bit to how DNA testing is performed?
The DNA testing, the traditional DNA typing service, is a small cutting of evidence is taken. It's added into liquid chemicals that help separate the DNA from the other biological material that's present. A robot is also used to assist in the separation procedure. When the clean DNA in a test in a tube is the end product, and that is quantified to determine how much human DNA and male DNA is present. Those values are then used for the next step, which is amplification, where copies along the DNA strand of 21 locations plus 3 for gender that we use to compare between individuals. These copies of DNA, which are small fragments of DNA, are separated by size on a genetic analyzer, and the output from this instrument is used in a software program called Gene Mapper IDX, where the profile is typed. And the profile at the 21 locations should have no more than 2 pieces of genetic information, or 1 piece of genetic information in the form of peaks. 2, if the information is different, that is inherited from a mother and a father, and just 1 peak if you inherit the same piece of fragment of DNA from the mother and the father.
And so is that the process by which you obtain a DNA profile on a piece of evidence or from a known reference sample?
It's the same for a piece of evidence, which we call an unknown, as well as a reference sample called a known. The extraction for the unknown samples and the reference samples take place at different times.
Ms. Hinkle, I do want to turn now to TrueAllele. You mentioned that earlier. What is TrueAllele?
TrueAllele is what's called a probabilistic genotyping software. So it breaks down complex DNA mixtures into possible genotypes for individual contributors. The possible genotypes are giving a probability at each of these 21 locations along the DNA strand. This information, the genotypes and the probabilities, are compared to a reference sample of the individual. Then there is a result in the form of what's called a likelihood ratio. An individual can be included, not included, or there is a area between a match and a non-match, which we consider inconclusive.
I think you may have touched on this briefly in one of your earlier answers, but what would prompt one to use TrueAllele, or when is it appropriate to use TrueAllele to analyze DNA obtained from a piece of evidence?
We use TrueAllele when the other methods we have to separate DNA into individual contributors, we're not able to do that. In order to separate a DNA mixture into individual contributors, there must be an imbalance between how much of DNA each person contributed, so that these little peaks that we look at are different in size. This difference in size can allow us to separate a complex mixture into individual contributors. We can also up to 3 individuals in a sample. If there is 1 major contributor, we can separate that major contributor. But if those methods don't work, then we can use the TrueAllele software system.
Gotcha. Can you talk a little bit about any TrueAllele training that you've had?
My TrueAllele training started around 2017. We implemented TrueAllele in 2018, but it consisted of reading background information on TrueAllele, a small weekly presentations by the individual who developed the software and the company called Cybergenetics. We also practiced with mixtures where the contributors were known. These mixtures consisted of a mixture of DNA from individuals, most of them employed in the lab. So practice and literature review because this was the first time we were using this software in the lab.
Has TrueAllele been validated by the GBI Crime Lab to interpret low levels and or mixtures of DNA collected from items of evidence?
Yes, it has.
And has it also been subject to validation studies and peer review outside of the GBI Crime Lab?
Yes, it has. It's been used by other labs, so there have been other validations before they
Are they all
must use
state
it.
labs?
Before they're allowed to use it in casework.
Do you receive ongoing training outside of anything that you already spoke about as it relates to TrueAllele specifically?
The TrueAllele people, not everyone in the lab is trained in TrueAllele. So our group, we do meet and have, we discuss any kind of issues we have, our suggestions for improvement, and also new literature we read and discuss.
Have you used TrueAllele software to interpret DNA samples?
Yes.
Any idea how many times?
Oh, hundreds.
Ms. Hinkle, have you testified in court before in the fields of forensic biology, forensic DNA analysis, and TrueAllele or probabilistic genotyping in general?
Yes.
Approximately how many times?
Approximately 300.
Your Honor, at this time I would tender Ms. Hinkle as an expert in forensic biology, forensic DNA analysis, and TrueAllele analysis.
Any objection by the defense?
No, ma'am.
All right. This witness is admitted as an expert in the areas of forensic biology, forensic DNA, and TrueAllele analysis. You may continue.
Thank you, Your Honor. Ms. Hinkle, before we get into TrueAllele, I know we just spent 10 minutes or so talking about TrueAllele, but before we get into that, I want to ask you about something else. In this case involving a victim by the name of Tara Baker, were you recently asked to review a report that was generated by a former GBI forensic biologist by the name of Cynthia Wood, specifically DNA analysis that she conducted on certain pieces of physical evidence back in 2010?
Yes, I was.
Okay, and if I didn't make it clear, is Ms. Wood still employed by the GBI?
No, sir. She's no longer in the state.
What actions did you take to review Ms. Wood's analysis?
I reviewed her data, and I used it to write the report. So it was just a paper review of what's the information in our computer system that was available to reach my own conclusions and write a report.
And just so the jury understands, what items of evidence were analyzed by Ms. Wood back in 2010?
There was a ligature, which is item 6. There was a knife, item 15, as well as a bloodstain card labeled Tara Baker.
Okay. And did you have the opportunity to review the data that Ms. Wood relied upon to form her conclusions as to those pieces of evidence?
Yes, I did.
And based on your observations of her data and results, were you able to form your own conclusions as to DNA analysis that was performed on both the ligature and the knife?
Yes, I did.
Was a DNA profile obtained on both the ligature and the knife?
Tara's.
Yes.
Were you able to determine whose DNA was present on both?
Yes.
On each of those items, how many profiles were present?
Just one.
And to whom
I'm a little confused why we're hearing about this when Jennifer Corsi already told us about this.
did that profile belong?
Tara Baker.
Maybe different tests.
Did you make a report that kind of summarized your observations and review of Ms. Wood's data from back in 2010 that you used to come to your own conclusions?
Yes, I did.
If I can approach Your Honor.
Okay.
This is stage 166. Is that the report that you generated after kind of going through the process of reviewing Ms. Wood's work?
Yes, it is.
Stage 166, Your Honor.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
Ms. Hinkle, now we will go back to TrueAllele. Were you asked to perform TrueAllele, excuse me. Bear with me. So let's put aside the review of Ms. Wood's report now. In this case, were you also asked to perform certain DNA analysis using TrueAllele that you described just a few minutes ago?
Yes, I did.
Could you please explain what data you received and how you used that data to run it through TrueAllele?
First, I received the data from the second fraction from the rectal swabs, oral swabs B, and oral swabs A that were from the sexual assault kit of Tara Baker. I used reference samples to make a comparison, and those were of Tara Baker, Kris Melton, and Edrick Faust.
And then actually, I think, was there a time that you used TrueAllele to interpret this data, but without the known reference sample of Mr. Faust?
Yes, my first report was issued without having the reference sample of Mr. Faust.
And in that first report, I want to talk specifically about the partial major profile obtained in the second fraction of item 2I. Did you compare that profile against the known profiles of Tara Baker and Kris Melton?
Yes, I did.
And what, if anything, were your results?
For the second fraction from the sample from 2I, there was a major contributor. Kris Melton is excluded. He was approximately 300 duodecillion times less probable than a coincidental match to an unrelated person in the population. Tara Baker was also excluded, 1 tridecillion times less probable than a coincidental match to an unrelated person in the population.
Okay. And what was that report dated, Ms. Hinkle?
That report was dated May 2nd, 2024.
Okay. And so lastly, Ms. Hinkle, I want to turn your attention to a time when you used TrueAllele to analyze pieces of evidence. However, this time with the additional, I guess, information that was in the form of a known DNA profile from Edrick Faust.
Okay.
Were you able to run a subsequent TrueAllele test, excuse me, involving items collected from Ms. Baker's sexual assault kit, 2B, 2I, 2J, with the known reference samples of both Kris Melton and Edrick Faust?
Yes, I used the information, the data that was already generated when I wrote the first report. All I had to do was compare it to the reference samples.
Okay. And we'll go through each item of evidence and talk a little bit about the, is it likelihood ratio? Am I getting that terminology correct? The likelihood ratio that was reported for each. Let's start with item 2B, which is the...
For clarification, when they are saying, like, the language of there was a major contributor that was not Melton or Baker, they're saying that there's at least 3 major contributors identified. The first fraction is Baker. That's like the biggest contributor. And then when they get into the others and they're saying there's at least 2 other contributors, they're saying, hey, we've identified that one is Melton, but there was this unknown on May 2nd. There was this unknown on May 2nd, 2024, when she generated this first report. They still don't know who this profile belongs to. And then she's going to do this report again once she gets the known sample from Faust, And she's going to fill in the gap and she's going to identify it alongside that undesignated profile.
Rectal swabs. Can you tell the jury what information that you were able to learn about the second fraction of item 2B?
The second fraction from the rectal swabs, 2B, there was a match between the data from the second fraction from the rectal swabs and Kris Melton. This match is approximately 60,000 times more probable than a coincidental match to an unrelated individual. And the comparisons between Tara Baker and Edrick Faust between their reference profiles is inconclusive because meaningful match statistics were not obtained. That's just our way of communicating that their results fell within an inconclusive range, where during our validation we had false matches and false exclusions. So in between this range, we do not report a match or an exclusion.
Gotcha. Ms. Hinkle, based on your training and experience and coupled with the results of TrueAllele on item 2B, the rectal swabs that you've just described, is there anything in your opinion that might be significant in finding someone's DNA being present in this particular piece of evidence aside from that individual engaging in anal intercourse?
Besides from anal intercourse, it is
Drainage.
not unusual for there to be drainage from the vaginal area into the rectal area. Also, wiping from one area to another can transfer the DNA so that even though there's not anal intercourse, an individual's
I still don't get how this isn't a problem for the state, though, because why wouldn't any DNA from Faust also transfer? If it's present on the same tiny swab that's supposed to now be correctly labeled as a vaginal swab, why didn't both profiles transfer?
profile can show up in the second fraction of a rectal swab.
Is there anything else based on casework that you've done that might be significant in, again, finding someone's DNA in this particular orifice?
There's another way for DNA to be transferred from the vaginal area to the rectal area. That would be transferred by another individual. For example, I worked a case, and that has already gone to court, but it involved an individual who was tied down and sexually assaulted a female. And then her girlfriend knocked on the door to find out where she was, and she was dragged in and sexually assaulted. So even though these two females never had contact with each other, the female who was tied down in the bed, the other victim's DNA was found on her.
So this makes to me it seem more like if we're supposed to have severe degradation, we're supposed to be having less presence of Melton's DNA because it's not supposed to last this long, yet his is the only one where there's enough for it to be transferred. It seems like he would be the one doing the transfer after the person who contributed the other profile got their DNA there. And again, no semen for Faust. No semen on the swabs. Like, to me, this does not help the state's theory that Faust came in after and Melton's DNA was just hanging out for 6 to 10 days.
Ms. Hinkle, I want to move now to TrueAllele analysis as it relates to item 2I. Can you describe for the jury the results of your DNA analysis using TrueAllele on that particular piece of evidence?
For the second fraction from the oral swabbings 2I, there was a major contributor. The match with this major contributor data from the second fraction from the oral swabs and Edrick Faust, This match is approximately 30 octillion times more probable than a coincidental match to an unrelated person in the population. And due to limited data, no conclusive determinations could be made about the minor evidence genotype from the second fraction from the oral swabs. And there were at least 2 individuals in that DNA mixture.
To include, as you just testified, the likelihood ratio, one of those being Mr. Faust, am I understanding that?
Correct. The major contributor was a match 30 octillion times more probable to Mr. Faust.
30 octillion, can you speak a little bit to the size of that number?
Octillion is 27 zeros, so 30 would be an extra zero, so 28 zeros. It's a large number.
Lastly, Ms. Hinkle, I want to move on to item 2J. Can you speak to the results, if any, that you obtained using TrueAllele on item 2J?
For item 2J, there was a match between the second fraction from what was described as oral swabs to Kris Melton. This match is approximately 8 octillion times more probable than a coincidental match in an unrelated person in the population. There was also a match between the second fraction from the oral swabs and Edrick Faust. This match is approximately 70 billion times more probable than a coincidental match to an unrelated person in the population.
And notice how the statistics are actually very different there. Scale-wise. And these ratios all come from TrueAllele. But listen to that again.
Only 30 octillion.
And 2J, by the way, is the one that was oral swab labeled for years until we send the swabs to Pure Gold in September of 2024 and find out that 2J, according to Pure Gold, has the presence, maybe because there's no confirmatory test, of vaginal epithelial cells.
2I, there was a major contributor. The match with this major contributor data from the second fraction from the oral swabs and Edrick Faust. This match is approximately 30 octillion times more probable than a coincidental match to an unrelated person in the population. And due to limited data, no conclusive determinations could be made about the minor evidence genotype from the second fraction from the oral swabs. And there were at least 2 individuals in that DNA mixture.
To include, as you just testified, the likelihood ratio, one of those being Mr. Faust, am I understanding that?
Correct. The major contributor was a match 30 octillion times more probable to Mr. Faust.
30 octillion, can you speak a little bit to the size of that number?
Octillion is 27 zeros, so 30 would be an extra zero, so 28 zeros. It's a large number.
Lastly, Ms. Hinkle, I want to move on to item 2J.
So I rewound too far, but now, so we just heard super big number for the known, like the oral swab, that the defense isn't really saying that oral swab 2I is not an oral swab. I think they're really taking an issue with the post-arrest relabeling and fixing the problem of having 2 oral swabs and suddenly sending it to a lab out in California with this 2J swab. Look at the difference in the statistical probability for 2J between Kris Melton and Faust, and between the likelihood ratio for Faust in 2I and the likelihood ratio for Faust in 2J.
Can you speak to the results, if any, that you obtained using TrueAllele on item 2J?
For item 2J, there was a match between the second fraction from what was described as oral swabs to Kris Melton. This match is approximately 8 octillion times more probable than a coincidental match in an unrelated person in the population. There was also a match between the second fraction from the oral swabs and Edrick Faust.
Yes, billion.
This match is approximately 70 billion times more probable than a coincidental match to an unrelated person.
So, as in terms of scale, the match for Melton, according to these likelihood ratios, is like exponentially more probable that it belongs to Melton rather than any other individual out there. Very, very large shrinking of the scale when it comes to Faust and to Jay.
In the population. And there was a third person in this mixture. It was a mixture of 3 individuals. And again, I could not make the results for the comparison to this minor contributor, and Tara Baker fell within this inconclusive range.
I think it's also worth highlighting that we have the presence of other DNA profiles in this oral swab. Like, it's not just Tara, Kris, and Faust. There's other DNA profiles present in 2I.
May.
Ms. Hinkle, I'm showing you what I've marked. It's 167 and 168. It states Exhibit 167, a copy of the report that he generated on May 2nd that involved TrueAllele analysis without the known reference sample of the defendant, Edrick Faust.
Yes, it is.
It states 168, a copy of the report that you've just most recently been testifying about, which is your TrueAllele results with the added known reference sample from Mr. Faust.
Yes.
Any objection?
No objection.
They are admitted.
Yes, Faust is in custody.
Just a few more questions, Ms. Hinkle. So, ma'am, based on your training and experience, can you speak a little bit to the amount of time that a forensic biologist might reasonably expect to find DNA present in, say, an oral swab versus a vaginal swab?
For an oral swab, based on the literature I've looked at, 24 hours is around the maximum time. 5 to 6 hours is more credible as far as there still being enough male DNA present in the oral cavity for us to test. As far as vaginal swabs, 7 days has been the reported max. We like to see the kits collected within 72 hours, though, for best result.
But 77 days or a week would be like the far end?
That's at the far end, yes.
Okay. And can you speak a little bit as to why the detection
not
period
3
for
or
these
4.
two places in the body may be different?
The oral cavity individual is going to will spit out the sample, possibly, or brush their teeth, or drink before the sample is collected, and that decreases the detection of the male DNA in the oral cavity of a living individual. For the vaginal area, it survives longer in the vaginal canal, but that does vary. Because it's of the conditions in the vaginal canal, and because of the sperm themselves have a protective layer that help them to survive in.
He's relying on sperm. Let's run that back. Ooh, my eyebrow. Oh, I would be so happy if I was Cruz and I heard this bit. Let's cross her.
In the vaginal canal, and because of the the sperm themselves have a protective layer that help them to survive in the vaginal canal. They are there for a longer.
This is not good for the state. So you just gave a max window of 7 days for like survival of DNA in the vaginal area. And you're qualifying that by saying one of the ways that something can be more likely to hit that maximum range of survival is, for example, a type of cell, semen, they have protective layering. Well, we don't have that present here as an excuse for it to last as long. So how do we explain that drainage?
Time.
Ms. Hinkle, based on your training and experience, coupled specifically with the TrueAllele results that you obtained on, I think, June 11th of 2024, specifically as it relates to items 2I and 2J, do you have an opinion, ma'am, as to whether or not those items were collected from the same part of the body of the victim?
Yes, I do have an opinion.
What is that?
Well, the profiles that were obtained from these two items were distinctly different. One was a major contributor and a minor contributor. So the 2I was at least 2 individuals, a major contributor and a minor contributor. The 2J, though, was at least 3 individuals, and 2 of those individuals were able to match. But there was also the presence of a minor contributor. So if the same cavity is swabbed, we would expect similar results in the DNA typing.
Based on I think you said nearly 20 years that you've spent at the GBI Crime Lab, am I remembering that right?
Yes.
Would it be unusual to you in your training and experience to not receive vaginal swabs if there was suspected vaginal penetration?
It would be
assault.
It would be unusual, yeah, and especially coming from a sexual assault kit of a deceased individual, when they don't know what type of sexual interaction occurred, they will sample the 3 orifices.
And those would be, just to be clear,
Oral, rectal, and vaginal.
Ms. Hinkle, those are all the questions I have for you, ma'am. Defense counsel may have some questions. Thank you.
Cross-examining.
I forget the day the ME did I feel like he said it was Saturday, but I'm not remembering. And I don't think I have it in my notes, at least not in a way that I can keyword search real quickly, but I feel like he said that Saturday he did it. So crime is supposed to have happened Friday morning. I do believe that ME did his work on the Saturday, the day after. But we have an additional element here. Don't forget all of the heat exposure we have because there was a fire in the room. So would that impact any rates that we just heard Hinkle talk about? So let's get to cross, you guys. I am ready. Are you guys ready?
Mr. Cruz.
Good afternoon, Ms. Hinkle. How are you?
Thank you.
My name is Attorney Ahmad Cruz. As you know, we've had opportunity to speak, and I represent Mr. Edrick Faust. Is it okay, Ms. Hinkle, if I ask you a couple of questions?
Of course.
Okay. We'd agree that you've been with GBI for 20 years. Is that correct?
Almost, yes.
Okay. And you have a supervisory position. Is that correct?
No, I do not.
You mentioned that you oversee, I thought I heard on the rec that you said you oversaw or you reviewed others' work. Am I mistaken on that?
That's a process called peer review, and all the scientists in the section, we report DNA services, but we also review the services that other individuals complete, just to have a second set of eyes on the results before they are released.
Okay, but that's pretty much your coworker would do the same thing. It's not a supervisory process.
Correct.
Okay, perfect. In this case, you reviewed 2 oral swabs and anal swab. Is that right?
The key point there is it stays within the house. Any supervisory, like, quote unquote, peer review of the lab work is just more GBI reviewing the lab work.
That's what they're labeled, yes.
Okay. And is it uncommon to receive 2 oral swabs per GBI policy?
Sorry.
Is it uncommon to receive 2 oral swabs per GBI policy?
2 separate sets. It's not really a GBI policy because it's collected by other individuals, but it would be unusual to receive 2 sets of oral swabs and no vaginal swabs.
Is it possible that the vaginal swabs may have been, well, you wouldn't know. What year did you test these items?
It was recently, so the TrueAllele was in 2024.
Okay. So you don't know if the absence of a vaginal swab is due to a loss?
I can't say. I wasn't there.
That's fair. That's fair. But you have seen cases where you've seen 2, 4 oral swabs, things of that nature?
Usually if there's multiple swabs, they're within the same envelope and not in separate envelopes.
These were in separate packages that you received them, A and B?
Those, yes, separate envelopes.
I'd like to talk to you about the DNA obtained from the second fraction from the rectal swab. Is that fair?
Yes.
I believe your testimony on direct examination, you stated that there were, let's see, at least 3 individuals
Correct.
in the DNA mixture?
Correct.
And Mr. Melton's DNA profile was the only identifiable DNA profile. Is that correct?
Correct.
And 1 in 65,000, that's still a strong likelihood ratio. Is that correct?
It's 1 in 60,000, and based on our validation, any match over 1 in 10,000 times more probable is what we report, because we observed no false matches over 10,000 times more likely. So, yes, it is a match. It's on the lower end, but it's still, based on our validation, should not be a false match.
Okay, that's fair. And you stated that in regards to the inconclusive range, you can't give an opinion whether a person is present or not present there.
Correct.
And is it fair to call Mr. Melton's DNA that was identified in the anus as male second fraction DNA? Is that fair?
It was in the second fraction, yes.
Excellent. And you didn't test this fraction for sperm, is that correct?
Correct.
And is it fair to say that second fraction DNA could be sperm, skin cells, blood, or saliva?
The aim is to obtain only a profile from the sperm, but there can be some crossover of other types of DNA.
This isn't good for the state. So you want to test sperm if you have it. So now crews own this. Own this. So you had to test something else because you didn't have sperm.
DNA, other types of cells into that second fraction, so it's difficult to say.
Yes, ma'am. Was it difficult to say that the second fraction could be skin cells, blood, and saliva? Are you saying that's difficult to say?
We're told not to say that it.
Well, I don't want you to say anything you're told not to say.
Yeah, we don't say it's something unless we know it's something.
Certain.
So I don't want to go out.
Okay, understood. That's fair. That's fair. Are you familiar with the Journal of Forensic Sciences article entitled "The Persistence of Sperm and the Development of Time Since Intercourse Guidelines in Sexual Assault Cases"?
That's one, yes.
Are you familiar with that one?
Well, I've recently reviewed.
Yes, ma'am. I would like to show you that document if it's okay. Okay, I'm going to ask you some questions off of that document. Let the record reflect that I'm showing the state what has been marked as Defense Exhibit 52. Let the record reflect that I am showing the witness what has been marked as Defense Exhibit number 52. There you go. And Ms. Hinkle, please take your time, review that document. Once you're comfortable that it is accurate, it hasn't been altered in any way, please look up for me. Okay. Is that document a reliable authority in your field?
The journal is.
Yes, ma'am.
And they would not accept a paper without a review before it's published, so it would be reliable.
Yes, ma'am. I would like you to look at page 588 of that document. I'd like you to look at the last paragraph on the left column.
It's 588?
Yes, ma'am, 588.
Okay.
All right, and then we're looking at the left column and the last sentence on the left column. You'd agree that it states, in general, sperm can be detected in the anus up to 24 hours time since intercourse. Is that correct?
That's what it states, yes.
Okay. And it says sperm can persist for over 2 days after intercourse. Is that correct?
2 days after anal intercourse.
Yes, ma'am. And then at the top, we have table 8. Do you see table 8 at the top on the right column? And there were 5 anal swabs, and I'm sorry, we're looking at the 96 hours to 120 hour range. Do you see where there was 5 anal swabs tested in that 5-day range?
There were 5, yes, that were tested after that range.
Okay, and all 5 came back as negative for the presence of DNA. Is that correct?
Yes.
In the middle of that paragraph, and we're on the right side now, it says the expectation.
So 5 to 6 days, no longer present. DNA no longer present after anal intercourse.
I'm sorry. We're at the. I'd like you to go to the 4th sentence, the first paragraph on the right side of the document.
And that's a test with sperm, which has the protective cell wall that helps it survive longer, you know?
It starts with the expectation of finding. Do you see that, Ms. Hinkle?
Yes.
It says the expectation of finding anal swabs positive for, and I'll just say DNA instead of that word, at a time since intercourse of less than 48 hours can be considered low. And the expectation of finding DNA at time since intercourse greater than 48 hours can be considered extremely low. Is that correct?
Oh, it was expectation of finding sperm greater than 48 hours can be, yes, that's what it says.
In 2 sentences down, it says, our experience at FSI, which is the journal, is that it is unlikely that sperm would be detected on internal swabs beyond a TSI, which is time since intercourse, of 24 hours. Is that correct?
Their experience at the institution that did this study, correct.
Are you also familiar with course indulgence? The Canadian Society of Forensic Science Journal article providing evidence-based opinions on time since intercourse based on body fluid test results of internal samples. Are you familiar with that document?
Yes.
Okay. Court's indulgence. And I am marking this document as defense exhibit . Can you say the number of the exhibit that you have?
52.
52. So this would be marked as defense exhibit 53.
I should be more precise. Negative for semen and negative for partial semen, not just sperm, according to Jennifer Corsi. Mrs. K. Griff says objection, Canadian.
Oh, that is the wrong copy. I am so sorry. That is my copy. Yeah, that's the wrong copy.
What, did he just give his copy with the notes to the
This
state?
is your copy. There you go.
Yeah, absolutely no tadpoles or little swimmers.
Is it okay if I approach you, Dr. Ms. Hinkle? I want to call you doctor. Please forgive me. And please take your time and look over that document. And once you've had opportunity to look over it and make sure it hasn't been altered in any way, and you recognize it, you can look up.
Yeah, good question. How do the science doesn't lie crowd get around this math and the Kris Melton presence?
That article that I just handed you, is that established as a reliable authority in your field of work?
Journal, yes, and they wouldn't accept an article, an item for publication unless it is valid.
Yes, ma'am. 1 second, Ms. Hinkle. Thank you for your patience. And you're familiar with the Canadian Science of Forensic Sciences, the Canadian Society of Forensic Science Journal article providing evidence-based opinions on time since intercourse based on body fluid testing results of internal samples. Is that correct?
Yes.
I would like you to look at page 61.
Just Do the Right Thing is hanging out while getting ready for work. Perfect name for this trial.
I would like you to look at the last paragraph on page 61. And would you agree that the first sentence of the last paragraph of page 61 states, in the literature review, the maximum reported time frames from the detection of spermatozoa were 7 days for the vaginal cavity. Is that correct? 3 days for the rectal cavity, is that correct?
Correct.
And less than 24 hours for the oral cavity, is that correct?
Correct.
Court's indulgence.
So the state has to say it was in the vaginal cavity for 4 days, and then it got moved to the rectal cavity and survived the maximum known time possible. Because it couldn't have been Kris. He's writing it on the board.
Were you asked to conduct any DNA testing on hairs found on Ms. Baker's body?
I was not.
Is that a capability that GBI has?
It is one, yes.
Oh,
Thank you. I have no other questions.
beautiful.
Any redirect, Mr. Bolden? All right.
I saw a lot of people confused. They believed that when Peterson was not here. They believed that what Peterson was testifying to, again, he's a GBI employee as well. He did the microscopic, the ocular hair comparisons, which are supposed to say, hey, if we think we need further testing, we can then send it somewhere else for, whatever type of testing. Obviously, at this point in time, really the only capability would be mitochondrial testing, with issues of degradation still being in play. When he was asked about, hey, the pubic hair collected from Tara Baker's left hand, there was a bunch of hairs recovered from her left hand, several head hairs, and a pubic hair. Was that pubic hair ever compared to the known pubic hair collected from Kris Melton? He tried to say that it was. Well, where is it in your May report? Oh, it was in a different report. So Cruz gives him all of his reports. He looks at them, can't find it. Did you actually test it? Well, we indirectly eliminated it. So there was no need to test it. But his testing, his reports document the microscopic analysis and comparison. So he was saying just by, if I had 2 strands of hair right in front of me and I go, yep, not going to compare them. These are 2 pubes. 2 pubes. He says he just looked at them, so I'm not even going to compare them. He didn't put them under a microscope. He didn't put it in his report that he put it under a microscope. And he's saying it was eliminated. Then there's other issues with things that they say, hey, we can't say that this hair didn't come from Tara or that it didn't come from Kris Melton. They didn't then send those hairs after looking at them under a microscope for this DNA testing on the hairs. And even though there might be some issues with the degradation from the fire, the hair was still collected very close in time to the time of the crime back then. So that would have been the best time to do it, to see if there was anything viable, suitable for testing. They didn't do it. And if you're somebody that's accused 20 years later of a crime, do you think you have an equal opportunity to choose to do that testing? So I think Peterson's testimony was one of the most infuriating for me. That's the guy that Cruz ended his cross with the, did you test it? Yeah. Did you put it in, is it in your report? No. That's that guy. If you missed that, go rewatch that. Highly recommend.
Ms. Hinkle, you were asked several questions on cross-examination about the detection period. Come over here to the microphone. Of the detection period for male DNA in a rectal swab after anal intercourse. Going back to the case that you specifically referenced on direct examination, where an individual was able to transfer DNA from one victim to the next, in that context, would that reset, or not even reset, would that start the detection period for potentially DNA being located on an anal swab? Does that question make sense?
Yes. I mean, it's possible for an individual to transfer fluids from the vaginal into the rectal area if there is insertion in both areas. So it would kind of restart the clock, so to speak, as far as
What?
the time frame.
Is this real? In what world would that happen? When we hear something has a half-life, and it's already gone through several cycles of a half-life, if you move where that thing is stored, does it just go back to full life and start all over? This is crazy. What
Vaginal.
are we doing?
Reset, or not even reset, would that start the detection period for potentially DNA being located on an anal swab? Does that question make sense?
Yes. I mean, it's possible for an individual to transfer fluids from the vaginal into the rectal area if there is insertion in both areas. So it would kind of restart the clock, so to speak, as far as the time frame.
That's all I have, ma'am. Thank
I
you.
call bullshit.
Any,
Where is that in the academic
excuse me, any
literature?
request, Mr. Cruz?
No, ma'am.
May this witness be excused?
I would ask that she be excused, Your Honor.
Any objection, Mr. Cruz?
No, ma'am.
You are free to go. You may call your next witness.
And again, if the only way, this is what I was rambling about earlier. I don't get how the state thinks this helps them anyway, though. They're trying to explain how his stuff could be there for so long. But why would only Kris Melton's DNA be detectable on the anal swab, even if you say that it's only present there because of drainage and it's resetting the clock? And then Faust DNA isn't there, which would be fresh, actually starting the clock for the first time. Like, logically, that doesn't compute for multiple reasons. What are we doing? Is this like a thing that every trial we watch, it gets worse? Like, this is crazy. This is crazy. Shout out to Not Sure Now with the 5 saying, I'm curious if these detection dates are post-mortem or from a living individual who was then red-rummed. Yeah, so not much on the circumstances. But I think that anything that you're thinking about in your thought process, to me, creates reasonable doubt in a way that, any defendant on trial here could argue, like, as far as timeline of when this stuff occurred. Like, you really just can't control all the variables. So I think your thought process, if anybody's sitting on the jury thinking about the same thing, it's kind of like, how can you actually even refine? We're already pushing the limit of the 7-day max from the vaginal, if it's sperm, which has protective, like, walls around the cell, so it doesn't degrade as fast as something that would just be regular DNA from other skin tissues, whatever other tissues. Then we have the 3-day max from rectal, and we have this weird redirect testimony that insertion would make that clock reset. Like all these other variables, the ceiling is the maximum in the best known maximum ceiling that we have. So this happened. There was a fire in the room, high heat, potentially an anaerobic environment, because remember, the state's trying to tell us that the fire, there was probably ventilation issues if the HVAC wasn't running and the door of the bedroom was closed. And the fire might not have spread as quickly as you would think if there was a ventilation issue. So the state is arguing a low oxygen environment, which would bring me back to what you're getting at. Not sure now. Like, how does the vaginal cell culture post-mortem, how is being in an anaerobic environment or a low oxygen environment? We don't understand how the flora works, and they're not even trying to add that variable in to their timeline here. They're just clinging on to the absolute maximum window possible. It's ridiculous. It's ridiculous. So, oh, thank you for the super. Thank you for the opportunity to rant. Martina says, reset the lost clock. Yeah. So we're talking about this clock timer, and then we have this whole other side story debacle in this case where the clock was stopped at 9:32, which is helping us pinpoint when the fire would have gotten so bad that the clock, by whatever mechanism, we don't know if it was electric powered, we don't know if it was like battery, and the state's theory is if it stopped because of the fire at all. That it stopped because the heat was so bad at that point in time and the flames were going up the wall that it melted the batteries or the plastic to make it inoperable. Like, this 9:32 clock thing that the state is focusing on, we've got all of these issues with different clocks in different ways. Like, oh man. And thank you for being a member for 18 months. Oh, this is just a time. I don't even know. I think we unlocked something that is more frustrating than I thought we would be down a whole TrueAllele rabbit hole. Can we trust TrueAllele? Will the juries just take it at face value? This was a whole nother box that got opened up. And yes, just in general, Blind Hog says, you know what else is anaerobic? The colon, the inner rectum. Like, guys, this is crazy. This is crazy. I couldn't be a trial attorney because I would just be sitting there like, my questions would be what? Let's see what they do next, guys.
All right, ladies and gentlemen, I'm going to take up some matters outside your presence. If you'll go into the
Kick 'em
jury
out.
room, don't discuss the case. We'll be with you shortly.
Kick them out and go marinate on these maximum minimum reset windows. Yeah, I really think it was worse than, I mean, I was expecting a mess from TrueAllele, and I just never expected this. We'll zoom through this quick.
For 6 days, 5 days. The swabs wouldn't last that long.
All right, the state rested. Mr. Faust, I'm going to address you. You don't need to respond to the court.
Directed verdict?
I'm going to
or-
address you, and then I'm going to take a break. And Mr. Cruz, you let me know when you're ready to proceed.
Yes, ma'am.
All right. Mr. Faust, the state has rested. And what that means now is this, that this is the opportunity, if you and counsel want to present evidence. The burden is not on the defense. It's always on the state. But most importantly, I want to speak to you about your right to remain silent. You have the absolute right to remain silent under the Constitution of this country and, of course, the Constitution of Georgia. And that means exactly what it sounds like, that no one can make you take the stand and testify against yourself. Even your lawyers. I always tell persons that I'm speaking to
The
speak with
poll
their
is
attorneys and to listen to their advice. But ultimately, at the end of the day, the decision as to whether to testify in your own defense is yours and yours alone. I want to make sure that's clear. But you have the absolute right to remain silent. I want to make sure you understand, Mr. Faust, that if you decide to take the stand, that you will be cross-examined by the state, and you need to understand that. But you have the absolute right to remain silent, and again, no one
not
can force you in
testify, my
any way
guy.
to take the stand and testify. Mr. Cruz, do you have any questions that you would like the court to ask your client at this point?
Not at this time, Your Honor.
Okay.
We'll talk.
I'm certainly going to give you time to talk. Take as much time as you need. Let me know when you're ready, and then we'll address any other matters.
Yes, ma'am.
All right, court is adjourned until that time. Thank you. You can just let us know, Mr. Cruz, by letting the bailiff know, and we'll come back upstairs.
Yes, ma'am.
All right, thank you.
We have a room to speak in. They typically let us use this room down here. Can our team go to the room and talk with Mr. Faust?
Certainly happy to facilitate that. I'm going to leave that up to the sheriff's department. You know what? I think this would probably be best. I'll give you the courtroom.
Okay.
And I'm going to tell everybody who is in the courtroom to vacate the courtroom until we start court again. So I'll give you the courtroom.
Yes, ma'am.
All right, thank you. If everyone would please leave, and we'll let you know when we are ready to resume court. Thank you.
All right, so the poll is up, you guys, as you know, and we'll do other polls as well. But when the state rests, we do a poll. Has the state met its burden? Right? So this is not your personal belief. You can express your personal thoughts on the specific guilt or innocence of somebody, whatever, in the chat. But as far as the question, the state has the burden here. They just rested their case in chief. Have they proven their case beyond a reasonable doubt? So answer that poll, participate in that poll. And again, I understand that's a different question than whether you think the guy on trial actually did it. Did they prove it? Did they prove it? So there we go. Gonna also, let's see, looking at some feedback in the chat. Everyone's saying, don't do it, Faust. Don't take the stand. James says this is one of those cases where a directed verdict on several counts is deserved and also one of the least likely to get any of them dismissed. Right, both of them. Yeah, they didn't call Cedric Jeffries the jailhouse snitch. You know, maybe they thought they'd call him and didn't expect that Ahmad Cruz would put up like a formidable, like the ability to cross-examine a jailhouse snitch. I think the way Cruz approached the jailhouse snitch in opening statements might have put the state on their toes, pushed them back a little bit, and made them reconsider calling the jailhouse snitch. So either that or they let him stay on the witness list just to make Cruz do a lot of prep work and divvy up his priorities. So Trenton says they didn't show anything except the DNA. And we tried to have that hanging on with the, with Jeremy Howell, GBI Agent Howell, who took the stand this morning. His DNA was in the house. Well, outside of the DNA swabs from Miss Tara Baker's body, was there Faust DNA anywhere else? No. So you can't even show that he was in the house. Oh, I gotta update my banner. My bad. My bad. Let's see. State has rested. Yeah, we have a lot of people. I'll do a poll on should he take the stand, but only if he doesn't come back with a decision before we let this poll run up. Yes, Strother says I would rest the case. I mean, maybe the one thing I would do is if I have like a DNA expert witness to give some, if I think I need any more clarification. I don't know. I think my personal opinion, if I'm on the jury and you tell me to go deliberate, I don't think there's anything you could tell me that would change my vote from not guilty to guilty. Nothing. And I don't think that I'm in the norm, I mean in the like minority in holding that opinion. The state ended up down bad. Down bad. All right, let's do 60 more seconds on this poll. So if you want to get your votes in, get them in. Again, the question is, has the state proven its case beyond a reasonable doubt? Have they met their burden? Yeah, they didn't call the ex-girlfriend who, if they did call her, we were going to, I don't think the state wants the jury to have any idea that Faust might not have been staying right down the road during that year, during that time frame. Because it would ruin they're hanging on the DNA was there and he has the opportunity because he lived in close proximity. Or an address associated with a family member was in close proximity. So they spent like 20 minutes showing that drone footage from January of 2026. Where's Happily Angry Lawyer? He would be pissed if because he's talked a lot about the drone and the budget considerations that they're expending on this technology. Jim, the state played like 24 minutes worth of drone footage from houses that are like a street away from each other, just lingering in the air. Like, that's the state. They're like, look how hard we worked to investigate this in 2026. So, let's see. All right, we're going to close up the poll. I know I said 60 seconds, letting it run in quick. All right. So we are ending. All right, the final breakdown with 244 votes is no with 95% and yes with 5%. So that is the cat chat. And I really hope there's not a guilty verdict. I don't know if I could speak if we watch a verdict come in and it was guilty. I'm not sure I'd be surprised. I'd be disappointed by a hung jury. And I'm hoping for a not guilty. Yes, Hal says it's been a while since I made fun of Pat Labette's drone obsession. All right, so let's jump ahead a bit and see. All right, we do have some action. The jury sends in a question. Can we find someone else guilty? Oh, man. And I wonder if you know, Faust is considering, like, do I need to explain how I might have encountered somebody, anybody,
Do
while
one more
being
time,
out?
as I said earlier, hope you've had sufficient time to speak with your counsel. I want to make sure you understand that you have the absolute right to testify, but you also have the absolute right to remain silent. If you choose to remain silent, I will instruct the jury that they are not allowed in any way to use that against you or to hold that against you or to consider it in any way. All right, thank you. Mr. Cruz, anything you'd like to articulate to the court?
A couple of things. Before we get into the case, Sharon, I want to let you know that I just found out my wife is in the hospital, so we'll need to address that shortly.
All right.
But to take care of Mr. Faust's matter, I've advised Mr. Faust he doesn't need to testify in this case.
Okay.
So I'll stop there for now.
All right.
I also have a motion as well.
All right, go ahead with your
Directed
motion.
verdict motion.
Your Honor, we're going to move for a directed verdict in this case. The law provides that on a motion for directed verdict, the evidence must be construed in the light most favorable to the party against whom the motion is sought. So, as the Honorable Court is aware, the evidence has to be viewed in the light most favorable to the prosecution in this case. A directed verdict is authorized only when there is no conflict in evidence. So, as the Honorable Court is aware, if I present evidence of one thing and the state presents evidence of one thing to that count, there cannot be a directed verdict. It has to go to the jury. And that's as to any material issue and the evidence introduced with all reasonable deductions therefrom demand a particular verdict. So the counts that we were asked for a directed verdict to, first we'll start with burglary, Your Honor. In this case, and I believe that is count, burglary is count 6, Your Honor. And in the indictment, Mr. Faust is charged for the said accused in the county of Clark and state of Georgia on or about the 19th day of January 2001 did unlawfully and without authority enter into and remain in the dwelling house of Tara Baker with the intent to commit a felony therein, to wit, aggravated sodomy and rape in violation of OCGA 16-7-1. The evidence in this case presented in regards to the burglary count, as Honorable Court is aware, none of the state's witnesses have disputed that outside of Mr. Faust's DNA being in Ms. Baker's body, there was no evidence connecting Mr. Faust with the home. In fact, the state mentioned in opening that they can't present evidence of how Mr. Faust got into the home. So in regards to count 6, our position is the evidence does not conflict. The evidence is actually favorable to the defense, even if viewed in the light most favorable to the state, because there is no evidence presented that puts Mr. Faust in the home or shows that Mr. Faust was in the home at any time. In regards to aggravated sodomy, Your Honor, all the testimony in this, and let me make this specific, the aggravated sodomy count involving the anus of Ms. Baker, which is count 10. So far we've done count 6. Next is count 10. All the evidence in this case, in regards to aggravated sodomy, it is undisputed that Kris Melton's DNA profile is the only identifiable DNA profile in Ms. Baker's anus. Dr. Falzone testified that based on her injuries, they were consistent with sexual assault. Ms. Hinkle testified that the anal DNA only lasts for according to the articles, 2 days to 3 days at most. The state asked her a question, their very last question to Ms. Hinkle. They said, could the timer reset? As the Honorable Court is aware, viewed in a light most favorable to the state, we have to accept that Mr. Melton last saw Ms. Baker on Sunday, last had sexual intercourse on Sunday. If we give Mr. Melton the 3-day window, that puts us at Wednesday with his DNA in Ms. Baker's anus. However, the DNA wouldn't still be present because the state's allegation is that Mr. Faust committed these acts on Friday. So there is no evidence that the state has presented or that could be construed even when construed in the best light, even when construed favorable to the state, there's no evidence that would support or that conflicts in regards to Mr. Faust being in Ms. Baker's anus. So we ask for a directed verdict on that count. In regards to count 11, arson in the first degree, we're also requesting a directed verdict. Again, it flows, the state has presented no evidence whatsoever that Mr. Faust was in the home. The closest the state came to that is, if we view the evidence in the light most favorable to the state, is that African Americans were seen walking around the Deer Park neighborhood on the day of Ms. Baker's death.
That is really what
but
the
state has
state's
presented
hinging
no
on.
evidence. There's no conflict in the evidence. There's absolutely no evidence supporting that Mr. Faust started a fire in Ms. Baker's home. And again, what we rely on is the evidence presented through the reports as well as the testimony that law enforcement officers did not find anything connecting Mr. Faust with the home. The only place Mr. Faust's DNA was located, again, Your Honor, was Ms. Baker's body. That same reasoning flows to count 12, possession of a knife during the commission of a felony. There's been no evidence presented that Mr. Faust had a knife or possessed a knife in this case. As well as count 9, count 8. Excuse me. So count 9, not count 8 or count 7. Count 6, we've discussed. And counts.
Count 9 is aggravated assault. Count 7 is aggravated sodomy, committed sodomy with force.
1 through 5, which are
Felony
malice murder, felony murder, felony murder, felony murder, felony murder. And just for purposes of the record, I address count 7 and 8. The evidence viewed in the light most favorable to the state, Mr. Faust is, and obviously we disagree with it, but we have to view it in the light most favorable to the state. DNA is in Ms. Baker's mouth and in Ms. Baker's vagina. And again, we disagree with that, but I understand the standard. We have to view it in the light most favorable to them. And the state's position is the reason it's there is because of rape and sodomy. There is a conflict in evidence there, so we're not requesting a directed verdict on those 2 counts.
Which 2 counts?
That is 7 and 8. 7 is the aggravated sodomy involving the mouth. 8 is the rape. And of course, Your Honor, our position is there was no rape that took place in this case, but I have to,
Not asking for a directed verdict on
based on the law and viewing the evidence in the light most favorable to the state. But in regards to the murder counts, again, there's been no evidence presented by the state that Mr. Faust was responsible for Ms. Baker's murder. Outside of just his DNA being present. And as Honorable Court is aware, when it comes to murder, malice murder, they specifically state on or about the 19th day of January 2001, Mr. Faust did unlawfully and with malice aforethought caused the death of Tara Baker, a human being, by strangling her with a cord and stabbing her. The only evidence in this case regarding forensic material related to the murder weapon, which is the cord, is that Mr.
All right, not to interrupt, but we have a special guest. Are you ready, Ali? Give me a thumbs up. All right, big welcome to Ali. We are watching the defense's motion for a directed verdict.
So we missed all the DNA experts. I figured when I heard that.
All right, chat, you let Ali know. We were waiting to hear about some hot mess about TrueAllele, and there was some flubbing where the witnesses, at least the first witness, they called 2 witnesses that do DNA forensics for GBI. And the first witness they called, Ms. Sims, kind of was glossing over, and it was with the help of Kris Bolden, the prosecutor's questions, kind of making it seem like they did the testing themselves and kind of jumping the gun that they send it off to TrueAllele and can't go and validate this work or reproduce this work on their own. So that was a bit messy. But ultimately, I think there were worse issues with the DNA forensics. We pretty much heard, and I don't know if you know the background on this case, there were 2 oral swabs originally. State, after arresting Faust, ends up going, well, this is kind of weird. There's no vaginal swab. Sends the swabs out to a lab out in California called Pure Gold. And they just do Lugol's iodine testing and the RSID saliva tests. And they come back, their conclusion, even though the sample size that we saw, there's like 3 specks, not a very good sample size, that are dyed a color. They're like, hey, well, the first swab seems to have epithelial cells from the cheek, the inside of the cheek. And the second seems to, as a presumptive test only, have what could be vaginal epithelial cells. So the state introduced that to suggest that, hey, we actually do have a vaginal swab. And then there was an anal swab taken, and only the third-party culprit has an anal, is detected.
Right, that part I did know that. But by the way, I have had a case where presumptive, at least presumptive semen ended up not being semen. So it's not, it is not unusual. I actually haven't had one. Bob and I didn't really, was sort of like, I don't want to take certain like sex offense cases. So we didn't do a whole lot of them. But there were, we did have a few where we thought it was worthy, you know, whatever. Everyone deserves a defense. But in any event, so I haven't done all that many, so I don't have a situation where I know about.
If you feel the ick about a defendant, I don't feel like you could
I feel
advocate.
the ick about people and do it all the time. I just always had, like, I was like, I won't do like child predators. And Bob's like, you've represented a child murderer, but you won't represent a child sex offender.
It is what it is.
Right.
It is what it is.
So I don't know about vaginal, but because I know that those presumptive tests, I mean, shit, once we had literal mints presumptively test for methamphetamines. So the presumptive
like
tests,
breath mints.
yes, the icebreakers ones. Like the cop went out to his car. He didn't believe us. He went out. He's like, I have one in my car right now. He went out to his car. He got it. He brought it in, and he's like, they're right.
Oh, very hilarious. I'm
So
sure.
okay, so the presumptive test was all they had then, is to say it was vaginal.
Even worse. So And that's just doing the Lugol's iodine, and both parties said that they're not aware of any court that submitted a Lugol's iodine test in court before. And the purpose of this was just to fix the mislabeling of what looked like 2 oral swabs. So the defense is, of course, saying that that's only the state's theory, that the one is actually a vaginal swab. It's not actually conclusive because there's no confirmatory testing. But then when they do the DNA testing on the swabs from the clippings from these swabs, regardless of whatever they're supposed to be, there's no dispute that the rectal swab's the rectal swab, and that Melton's profile there's a match. They don't find a match for Faust, but the state's theory is that Faust was the last person. So drainage or a different insertion is their theory of how something that was only
On
with
the sheets, on the
Chris
clothes.
Melton says he maintained, I hadn't seen her in 10 days. I hadn't
Saw
seen her in
that.
10 days. I hadn't seen her in 10 days. They asked him, GBI asked him in 2024, 4 days before they do the arrest, the traffic stop and arrest warrant for Faust. We need you to we need to separate you from the bad guy. And as soon as he says, well, it might have been that Sunday, which is like a 6-day window from when they say the murder occurred.
Then they're like, it's possible for semen to last that long, so it works.
And the state's witness from GBI says, well, semen, sperm has a protective layer around it, so it can last towards that maximum sealing in the vaginal cavity of the maximum 7-day window. Well, the GBI employee that tested the swabs back in 2001, no semen, no presence of semen, no partial presence of semen. So we remove that thing that helps us get towards that maximum window for the vaginal cells. Then the state gets this witness to say, well, is there a reset? And this witness ends up saying, well, insertion could cause a reset and it would start the clock back over. So she says that there's a 7-day max for the vaginal cavity, and I forget her exact time frame on the anus. It was like 3 days for rectal. And that's somehow supposed to explain how, even if Chris Melton, it wasn't 10 days, it was only Sunday, which would be about 6 days prior, because he said Sunday morning before she left, not Sunday night. How do we reset the clock if something had to have been in the vagina for 4 days and then gets moved over?
I have never heard of that. And at least my understanding of how long it lasts, at least, it was always like 3 days. And I think like something like if you're stretching,
The maximum.
right, to but I think like typically that they will say it's 72 hours is what it's supposed to be. And it makes zero sense how transfer could revive something. Like,
reset the clock.
It makes zero sense. I don't understand what maybe I'm just dumb, and I'm not seeing it. Clearly they had to make some sort of scientific argument to this extent in the courtroom, but how, if you've got something that's on her bed that is only good for, let's just say 6 days, but on the 5th day it gets inserted into the vagina or the anus through contact in the bed, that now the clock starts over? It doesn't even make any sense how that scientifically could make sense.
And we have a fire, and the state has argued that the fire might not have scorched up into this ravaging, blazing fire that the neighbors would have seen because of low ventilation, low oxygen. So it's high heat, low oxygen, potentially an anaerobic environment, and all of these, they didn't ask about any of these factors impacting the possible maximum survival time for this DNA. I thought TrueAllele was going to be the problem in this case. I really don't think that was the issue. I think the state has a lot more of an issue with how they need to make this timeline fit to say that it couldn't have been Chris Melton. And for their mechanism to be that insertion, there is no DNA from Faust on the rectal swab. So if Melton's DNA was lingering for days and is supposed to have only gotten there through insertion, because without sperm, without semen, without that liquid draining down, drainage kind of becomes less likely as an explanation if you think it was likely anyway.
Right, like if she's taking a shower, it's not draining 5 days later.
And they said her hair was wet. Like part of that, when the firefighters go in, they smelled the shampoo and her hair was intact, her head hair was intact.
Right.
So it just seems wild.
So what is the defense's theory about the defendant's DNA? Did they challenge whether that was an accurate, because mixed samples are really, really hard. So did they challenge whether that's really his DNA in her mouth?
So since we're on the motion for direct, I think they're challenging more. So 2I was the swab identified. There were 2 swabs identified as oral originally, 2I and 2J. 2J, after going to pure gold, the state's arguing was really the vaginal swab that the ME says they collected. And the defense seems to be fine dealing with potential DNA because it could be from anything. There's no presence of semen detected with the oral swab. And I don't know if they're going to put on a case in chief and call their own expert.
But they didn't really
address some of those
challenge their
issues.
expert on the other possibilities, is that this is a mixed sample, that it was degraded, that it had to be, it had to be amplified more than typical, that it's hard to tell, it's hard to decipher a clear profile when you have multiple contributors.
They did, and they were very careful to ask for some of the swabs. There's also other minor profiles that are present that there's been no match to those individuals. And then for 2J, the swab that I would say is in dispute, where defense is saying it still could be an oral, state saying it's obviously a vaginal swab that was mislabeled. They had the match, and then there was another profile present that they didn't end up
I didn't
IDing
think the
anywhere.
presumptive test was even admissible in a court of law.
I think this is the first time. The Lugol's iodine and the RSID for saliva. So that might be good testimony for you to go check out. It was Marissa Lycon. They vaudeered her at the end of maybe day 4. Let me see when she was vaudeered. Yeah, she was vaudeered at the end of day 4, and then she was the first witness on the stand on day 5.
I know with drugs, the presumptive tests, like those are not allowed in. And I just can't, because I've never had a situation where they didn't do the follow-up test. Usually they do the presumptive. If it's negative, they don't do the next. If it comes back, then they do the conclusive. So, they always do the conclusive. But I know, like in drug cases, the presumptives aren't allowed in, like the street tests, which we can tell from those icebreaker mints. Doesn't work.
Well, I love to know that. I never actually knew that. I knew like chewing gum can throw off some like oral reads and breath readings, and like the alcohol sugars or whatever can throw off the alcohol reading on the field tests. Never thought about the like other types of drugs though.
So they're this is his motion for directive finding. I had it on in the background while I was headed down here. So I heard about the knife. What makes them, was the body stabbed? Is that why they say that whoever the killer is had a knife?
There's one stab wound, and I always think, I don't know what side it shows on YouTube, but the anatomical lower right side of Tara's neck, that was it. And then there was a knife found like between her body. She was on the floor and the bed. And then there was a Farberware knife block in the kitchen. And they think that the knife was Farberware, the block in the kitchen's Farberware.
And an expert testified that the wound on the neck was consistent with a knife?
The ME that did the autopsy said it was consistent. I don't know if he got into the knife, just sharp object, and that it could be consistent with somebody doing the stabbing from behind. That's what we got from the medical examiner.
I mean, to me, the knife, possession of a knife, I feel like she could actually,
throw him a bone.
Right. Right. But it sounds
and
like
there was no like DNA found on that. It was only Tara's blood. So
no, I've heard this judge in the way she's dismissive towards him, like so dismissive towards him, even when I've heard him right and her wrong. So I venture to guess she's just going to scoff at whatever the hell he has to say right now. Whatever the defense, whatever the prosecutor says is right. Like I was screaming yesterday at the TV about the prior consistent statement. And I'll say this last thing and then try not to get you guys too far off track. But a prior consistent statement is admissible when it predates the motive to lie. His motive to lie is the murder. The whole statement of Faust that they were impeaching was the statement he made to police that he was repeating on the stand. That is not a prior consistent statement. Now, had they talked to the law school, people at law school, and they were like, oh, she was real excited. She thought he was going to come. Or I know that, anyone who said before the murder that he told, Faust told them, or even, that Faust told them we had these plans, we were going to do that. That's
Melton.
prior. Right. But she's literally saying the actual statement he was impeaching, his 2001 lies that he repeated on the stand, at least that's the defense's theory, were a prior consistent statement. That was so outrageous. And to tell you the truth, he didn't say the right magical words, but he said close enough to the magical words. Like, wait a minute, that's the statement at issue. And I could see if it was a different statement. So he said way more accurate stuff than she did. And then she read the statute and said, you're wrong. And I was like, no, he's not. You're wrong. That is
There was another day where she's like, I don't need your case law, Mr. Cruz.
Yeah, well, it sounds like you do. Oh, God. All right. So how much has he gone through so far?
Yeah, and it's Melton. She meant Melton. But
Melton.
That's just telling.
Sorry.
Like, we hear so much about Melton in this case that when we're discussing, it's hard to remember which one's the actual defendant.
Right. Sorry, guys, because I have not been watching this. Like, we watched your coverage on it once, and I was like, oh, this is pretty interesting. We should watch more. And then we turned it on like another time. And then when they were doing when Melton was on, I was like, holy shit. How did we not cover this trial? What in the hell is going on? Like,
do another rewind. You have time.
Yeah. So far, what has he argued?
I think he just got to counts, the sodomy and rape counts.
Okay.
And we're about to hear that, but I think he's gone through most of the burglary.
Sodomy seems off the table.
His DNA's not there.
Right. Like the evidence of sodomy. Oh, well, no, because the Melton says they've never had anal.
And I guess they said bruising in the anal area.
Okay.
So yeah, so let's see what he argues. And he's doing all of this after getting the news that his wife went to the hospital.
One of the deans of the University of Georgia School of Law is on the jury.
Yeah, Dr. Waller or something. The names are public on the docket. The jury's names are not sealed. Wow. So I think that's who Aaron's referring to. Oh, also, Judge Lisa Lott addressed the media and said that you can't comment on if jurors are taking notes or what their facial expressions might be. So there's that. Very open, transparent courtroom.
Yeah.
All right, so let's see what he continues here. We were on the sodomy and rape.
Got you guys all sidetracked.
No, thank you so much for all of your insight.
Melton's trace evidence was...
Oh, did it just refresh? Oh, they must have ended for the day. Sorry, guys. That tends to happen. We'll go to here.
Not find anything connecting Mr. Faust with the home. The only place Mr. Faust's DNA was located, again, Your Honor, was Miss Baker's body.
Mouth.
That same reasoning flows to count 12, possession of a knife during the commission of a felony. There's been no evidence presented that Mr. Faust had a knife or possessed a knife in this case. As well as count 9, count 8. Excuse me. So count 9, not count 8 or count 7. Count 6, we've discussed. And counts 1 through 5, which are malice murder, felony murder, felony murder, felony murder, felony murder. And just for purposes of the record, I'll address count 7 and 8. The evidence viewed in the light most favorable to the state, Mr. Faust is, and obviously we disagree with it, but we have to view it in the light most favorable to the state. DNA is in Miss Baker's mouth and in Miss Baker's vagina. Again, we disagree with that, but I understand the standard. We have to view it in the light most favorable to them. And the state's position is the reason it's there is because of rape and sodomy. There is a conflict in evidence there, so we're not requesting a directed verdict on those 2 counts.
Which 2 counts?
That is 7 and 8. 7 is the aggravated sodomy involving the mouth 8 is the rape. And of course, Your Honor, our position is there was no rape that took place in this case, but I have
Just not asking for a directed verdict on
based on the law and viewing the evidence in the light most favorable to the state. But in regards to the murder counts, again, there's been no evidence presented by the state that Mr. Faust was responsible for Ms. Baker's murder, outside of just his DNA being present. And as Honorable Court is aware, when it comes to murder, malice murder, they specifically state on or about the 19th day of January 2001, Mr. Faust did unlawfully and with malice aforethought caused the death of Tara Baker, a human being, by strangling her with a cord and stabbing her. The only evidence in this case regarding forensic material related to the murder weapon, which is the cord, is that Mr. Melton's trace evidence was found on the charger block that was next to Ms. Baker's head that was connected to the cord used to strangle her. In regards to felony murder, burglary well, it should be burglary in a dwelling. Here it says burglary to a dwelling. Again, there's no evidence that a burglary occurred. The state admitted in their opening that they can't present evidence of how he got into the home. In regards to count 3, felony murder, aggravated sodomy, again, the basis of that felony murder is to strangulation, and I've already provided the Honorable Court the facts and evidence that came out in this case in regards to the strangulation in count 3. And count 4, felony murder as related to rape. The felony murder piece of it, again, there's no evidence of murder. And I emphasize, I know the court is aware, we disagree that a rape occurred. We disagree that that aggravated sodomy occurred. But understanding the law, we understand we have to accept that evidence and say it's favorable to the state's position. But in regards to the murder piece, there's no conflicting evidence on the murder piece. In fact, there has been no evidence presented by the state that Mr. Faust committed this murder again, but solely that his DNA was present. So we would ask the Honorable Court to grant our motion for directed verdict on all counts, excluding count 7 and 8. We believe those matters are appropriate for the jury based on the conflicting evidence.
Thank you, sir.
What is 7 and 8?
State here to respond.
The sodomy and rape.
Yes, Your Honor. I mean, I'll be brief. The court has sat on the trial of the case. You've heard all of the evidence, but certainly not only has the state carried its burden to provide evidence sufficient to get this matter to a jury, but the state's carried its burden of proving guilt beyond a reasonable doubt that Mr. Faust committed all of the crimes that are named in this indictment. I'm going to start at the top and work my way down, but in some ways, the evidence of Mr. Faust's guilt applies to each of these offenses. So I think that the evidence as shown at trial shows that an individual matching Mr. Faust's description was seen in the area of.
So a black man. That's meeting his description, right? A black man? Because I didn't hear anything else.
That's the state's theory. And mind you, any witness that saw, they were asked after the fact. It's not like they called and said this morning, hey, there's somebody running while black out here.
Right.
It's after this fire actually takes place. They're canvassing the neighborhood, and there's 3 different witnesses that describe different clothing and different appearances for different black men. They are sent to meet with the same sketch artist. And they all describe whatever they saw. The individual was walking. Neither of them were wearing hoods. They all had facial hair and head hair, so you would think that there'd be hairs left behind.
Right.
If those individuals were the person. One was wearing a bright shirt. Nobody was trying to conceal who they were.
Right. He stopped for her as she was backing out. So did they make the one sketch based on all of their descriptions?
There were different sketches. There were 2 sketches and 3 sketches, and the sketch artist didn't do like at the end of sketching, they have the witness say like, hey, I'd rate this like this out of this.
Right.
As far as how much it looks like what I think that person looked like, and they only accepted if it's an 8, 9, or 10. And they didn't do it for one of the sketches. And then the sketch artist couldn't distinguish, which sketch was which description. And then they had this report of a white guy running earlier in the morning before 7:45 a.m., running from the back area of the house where Tara Baker stayed. And they don't give that witness a time to sit with the sketch artist, and they don't show her any pictures of Kris Melton.
Wow. And how, so is the way that they decided the time based on when people saw a black man, like that this happened? Did she talked to
To
people?
that,
Yeah.
they have a clock that they said showed 9:32, and the clock was never recovered. The defense asked for it, and it was denied because the state said they didn't have it. And they, on redirect of one of the roommates who was friends with Kris Melton before knowing Tara, on redirect, Chris Bolden gets up there and, hey, I have 2 questions I forgot to ask you about yesterday on direct. And he goes, do you remember anything about a clock? And she's like, yeah, there was
Oh, yeah,
a
I saw
clock.
that.
It looked old, but it was new and it worked.
And it's nowhere. No one knows where it is.
Yep,
right?
yep.
All right. So, and just for the last thing, because I hear people complaining about commentary, for burglary can also involve the either the unauthorized entry or remaining, like afterwards. So I think that under the law, they would say if someone's raping someone, they're remaining there beyond what the person would want them inside, the
Yeah,
house.
and I
But
mean,
technically, you don't know whether he gained entry with. In theory, you could have a situation, and I'm not saying this is the case here, but where someone goes into a house of someone they know or somewhere they're invited, and then, something
snaps.
transpires that wasn't right. So, I mean, I do think he does have a point there that they honestly don't know and they can't establish, and they don't need all of these charges, but let's see how he responds.
Mr. Yalamanchili, and this is the DA. The DA.
Of 160 Fawn Drive, and in fact disappeared.
Wait a second. Not as bad as earlier today. Go ahead.
That was much faster than earlier today, but there was an individual matching Mr. Faust's description that arrived in or was walking in the immediate area of 160 Fawn Drive and then was seen to disappear in such a manner that that individual's only route of travel would have been between the homes immediately around 160 Fawn Drive. Further, there is obviously evidence that a murder was committed. There is also obviously evidence that a rape was committed, as well as aggravated sodomy, both orally and anally, is evidenced by Dr. Falzon's testimony about the forceful nature of both the vaginal sex and the anal sex, as well as evidence giving proving Mr. Faust's guilt beyond a reasonable doubt, much beyond the necessary standard for a directed verdict, especially when viewed in the light most favorable to the state. There are only 2 DNA profiles found within the home in Miss Baker's body. One of them is from her boyfriend, who had been in a loving relationship with Miss Baker, and whose DNA was found within normal detection window, as testified to by the GBI witness in Miss Baker's vagina, and then explained as far as the presence in the anal swabbing at a much reduced match or frequency rate due to either drainage or transfer from the period of time in which Mr. Faust raped Miss Baker, orally sodomized her, anally sodomized her, and then murdered her by stabbing her and strangling her with a ligature, Your Honor. And so when we're talking about directed verdict, the manner in which the court views the evidence, as well as considering the significant evidence in this particular case, the state's met its burden as it relates to counts 1, 2, 3, 4, 5, 6. The defense is not moving for a directed verdict on counts 7 and 8. If they were, the state would have met its burden there. As to count 9, the state has met its burden. Count 10
and 11 as well, and count 12. Obviously the knife was possessed during a commission of a felony of, as evidenced by the fact that Miss Baker's blood is on the knife itself, and it was a major contributor or the cause of death, along with the ligature strangulation of Miss Baker. And Detective Leadall testified as to the length of the knife being sufficient, being greater than 3 inches in order to satisfy the requirements of the statute, and as well as the arson being committed by the individual who had raped and sodomized and murdered Miss Baker, which would be Mr. Faust, as shown by the evidence in this case. I'm not going to go through a further recitation of the evidence because I know the court has sat in the trial of the case, but certainly the state
she's on your
has
side.
Yeah.
presented more than sufficient evidence both to survive a directed verdict and convict Mr. Faust as to all of those counts.
All right, thank you. Anything further? This is your motion. All right, thank you, sir. All right, so I know all counsel is aware of what this moment means and what the court's responsibility is, but I'm going to articulate it anyway. This is a moment where the court has to consider this statute, OCGA 1791, when direction of verdict of acquittal authorized. When there is no conflict in the evidence and the evidence introduced with all reasonable deductions and inferences therefrom shall demand a verdict of acquittal or not guilty as to the entire offense or to some particular count or offense. The court may direct the verdict of acquittal to which the defendant is entitled under the evidence and may allow the trial to proceed only as to the counts or offenses remaining, if any. That's the law. That's what, Mr. Cruz, you have asked the court to grant under 1791. And at this stage of the game, the court is not making any comment on the evidence. I want to make that clear. But what I am going to comment on is whether there is a conflict. That is what I have to find out. And if the court finds there is a conflict, the court has to deny defense's motion. I mean, that's just where we are. And so I want to just lay that out there. This court is not making a comment on the evidence, on the strength of the evidence, on the credibility of the evidence, on the lack of credibility of the evidence, the believability or not believability of the evidence. This is just a moment for the court to talk about whether there is a conflict. Both parties have articulated many times throughout the last 2.5 weeks the
conflicts.
Indisputable comment that this is a cold case. And in so articulating from both parties that this is a cold case, the parties have described in their ways why the evidence is or is not what it is. And a cold case, particularly one like this, is based on circumstantial evidence. And therein defines, in many respects, what a cold case is. And
still need evidence beyond a reasonable doubt.
Yeah, I'm losing it here. And let's bring Bob on. Let's see what Bob's take is. You ready, Bob? Thumbs up. All right, everybody say, hey, oh, we're tiny. I'll make us bigger. Get rid of this. Good
What's
to
up?
see you, Bob. We
Hey,
are about to hear her decline the directed verdict.
No, I'm still reeling from listening to that prosecutor say the word home.
And before she
Bolden.
says this, I wanted to ask
Go back
you.
and listen to it. It was fucking insane. I'm like listening to him make his argument, and then all of a sudden, and Allison had said something about like his speech pattern 2 days ago. She's like, "What the fuck?"
Like, because he's off
for
screen a lot.
Bolden.
He's off screen a lot. So when he got on screen, I was like, what? I was expecting some country guy in his hat,
All laughing aside, this case is a fucking nightmare. Like, I feel like I'm watching, like I've gone back into a time machine and I've landed again in the days of To Kill a Mockingbird. And it's just like, what in the fuck is happening here?
Did you hear the prosecutor argue that he met the description of the assailant?
Yes, I heard it. They're literally trying this guy on TrueAllele alone. because there's nothing
not
else.
even really. It gets worse in TrueAllele, but that might be. I think you need to watch that and see how it gets even worse than that.
Hume.
All right, we got to listen
Hume.
because the people are getting
They're gonna get antsy.
Yeah.
I want to make a
fine.
comment.
You guys will be fine. You'll be fine.
It's like the judge is leaning into, this is a cold case. We all know it's a cold case, but there is a very real reason. And I know murder doesn't have a statute of limitations, but statute of limitations exists for a reason. Sometimes even with murder cases, there's dismissals, judicial dismissals for want of prosecution, or prosecutors decide not to try something because so much time has passed from the time of the crime that the evidence is degraded, it's unreliable, it's no longer available. And here she's kind of working, it's a cold case, so I need to latch on even harder.
Right, like I'm giving the state more of the benefit of the evidence, which
That's not how it's supposed to work.
No. And what is the evidence of oral sodomy? His DNA wasn't in her anus. So what's the evidence of didn't he say she say oral sodomy?
She might have just flubbed.
Oh, or not
like how she was
I thought
speaking,
somebody
or-
said oral
Or
sodomy.
Yalamanchili.
Okay.
Because there was the sodomy, there was aggravated sodomy with force. How was it worded? I have it right here. Aggravated sodomy, commit sodomy with force, and it's cut off what I copy and pasted. But
Is
maybe they're
Dancing
saying something with
Gold
the weapon.
making a Seinfeld reference? He didn't have the laptop, or is that something to? I'm thinking of that episode where it was actually Larry David, where they thought the black guy took the laptop, but he returned it. I'm sure that's not what she meant. Ignore me.
And I do want to give Chrissy a shout here saying thanks for having Mr. and Mrs. Defense Diaries on. They are legit. I love them both. Thank you for the super, and thank you for
Chrissy.
Thank you so much.
everyone with a warm welcome
wait,
to Bob and Ali.
There's one thing I want to ask, and then we'll keep it rolling. I mean, y'all realize she's denying this shit, right?
Yeah, and I think that's how they end anyway.
Yeah,
it's about to be over.
As far as this case,
Well, do you want to let her finish and then we'll rant and rant?
Yeah, okay.
About to
Let's do
end,
that.
yeah.
Yeah, it's gonna be quick.
Let's do that. Sweet.
When the court charges the jury with the law that they must apply, one of the charges relates to circumstantial evidence. And juries are authorized to consider circumstantial evidence in making their decision. They don't have to, but they are authorized to do so. And they can give it whatever weight they care to. The court also charges the jury about circumstantial evidence, and in doing so also says that circumstantial evidence and direct evidence have the same weight, if any, and that one is not greater than the other. And any weight that is given to evidence is solely on the jury's shoulders. They get to decide whether they believe or they do not believe circumstantial evidence, whether they believe or they do not believe direct evidence. And that's the law that the courts give to every jury. That's your basic, obviously I'm paraphrasing. I'm not going to go back and read the whole charge to everyone. And I know counsel understands this, but I want to remind counsel that that's what the law is. And so based on all of that, and based on the law 1791 that says when there is no conflict in the evidence, I'm going to deny your motion, Mr. Cruz, for those reasons. This is a circumstantial case, and the argument that you have made relates to evidence that is direct evidence. This is a case that is not really direct evidence, although you all can argue however you choose to about what the evidence actually is. But this is a case about circumstantial evidence, and the evidence that has been presented, therein lies the conflict. Both parties have had the opportunity to direct and cross-examine, and the evidence that has been presented to the state is the epitome of conflict. And so for those reasons, I'm going to deny your motion, Mr. Cruz, because it is the law. All right. We've gone through that. Let me have counsel at the bench, and let's talk about some scheduling matters. And so, thank you.
All right, so this might be, so Bob, if you didn't hear, Cruz's wife just went to the hospital. So he's been carrying out the end of this day with that on his shoulders. So there might be some scheduling needs here. It seems like they're going to say something.
Yeah, obviously the state is rested, right?
Yep.
So does it appear that the defense is going to put on defense when the attorney is able to do so in terms of his wife's health issues? Do we know?
I don't think they need to, but it seems like if they want to deal with scheduling, sorry, I'm not an attorney.
Well,
but
I mean, at least I would be putting on
DNA
someone to
person.
explain the DNA, right?
Got to have one person to do that.
Because the prosecutor argued just now that there were only 2 profiles, and you definitely just told me that there were some other minor profiles that were unknown, right?
Yep.
So and when you get mixed profiles, when you get degradation, when you get over amplification, those change things. But Bob, I don't think they caught anyone from TrueAllele. So I don't even know, did TrueAllele have any role in this at all?
So they had the 2 GBI employees testify that they submitted test or swabs clippings to TrueAllele, and TrueAllele sent it back for the likelihood ratios.
So did they?
No.
Who identified the profiles? They sent known samples, unknown samples.
Both.
No, so it wasn't.
They didn't have FOSS. They didn't have FOSS right away. They sent out some samples, and they didn't know, like, one of the unknowns that became known once they had FOSS sample after doing a traffic stop and arresting him, after speaking to Melton and getting him separating himself. Then they capture that profile and they compare it. What was her name? Ashley Hinkle says that she compared it to what they already had returned from TrueAllele.
In CODIS, but so CODIS wasn't involved? Like, did they have they had his profile in CODIS from a traffic stop?
So with CODIS, they ended up, that was the first witness that testified about that, and they got there before getting a better swab, a better sample from Faust.
I need a lot more information.
We're gonna have to watch.
I'm on one right now. I'm not sure what happened here.
Yeah, because we had heard that they had a CODIS hit on April 30th to Faust. Then they go and interview Melton on May 5th. That's we need you to explain this away. We need you to separate yourself from the bad guy. 10 days is too far. And then on May 9th, they do a traffic stop and pull him over and do the breathalyzer test, get the saliva from that.
Wow.
Use that to get the arrest warrant affidavits the next day, arrest him, interrogate him.
Ladies and gentlemen, I'm going to release you for today. It's 4:20, and we're not going to start tomorrow until noon. It is possible that we actually may have all of tomorrow off. It's just going to depend on some circumstances. So if that is actually the case, you're going to get a call from the clerk's office, and they will tell you as soon as they know whether tomorrow is a free day for you.
Ooh.
In the meantime, I want you to expect to be here at noon tomorrow. When I release you, of course, the same prohibitions apply we've been talking about for 2.5 weeks. I know you've been paying attention to that. Don't discuss the case with anyone. Don't do any research. Do not go to any of the locations that you may have heard about. Certainly try to avoid all social media that may have anything to do with this case whatsoever. Other than that, thank you for your patience today. I'm going to release all of you, and we will hopefully see you at noon tomorrow, but make sure that you pay attention to your telephone just in case. Thank you. You are all free to go.
You quit being a horrible fucking person.
She is so hyper aware.
Real quick, babe, someone in your chat, Kat, said they have oral sodomy in Georgia. So I looked it up, and sodomy in Georgia is when he or she performs or submits to any sexual act involving the sex organs of one person and the mouth or anus of another. So
well, that's probably the part that I didn't copy and paste properly.
Different. Yeah. And then I saw someone else said, I thought sodomy meant anal. Maybe I'm not that smart. No, that's what we all thought.
Yeah.
Yeah. So that's what they were talking about.
That's what I've always
thought. For the anal.
That's what I've always thought sodomy was. All right. So I'm trying to wrap my head around this the TrueAllele thing. So are you telling me there was no representative from that company?
Nope. Just GBI. So state agents.
No Mark
really.
Perlin, none of those motherfuckers from True. So there was no explanation. put forth to the jury on how this black box shit worked? Nothing. Like no one
Well,
said this is how it works.
Well, what I still don't get is it sounds like they're saying they ran it through they sent the unknown sample to TrueAllele, and TrueAllele created a profile, and then they ran that profile through CODIS without even knowing or suspecting Faust at this point. Is that right?
So they got it. He had priors. So they run it through CODIS in.
But they run the profile TrueAllele gave them through CODIS, or a different.
That I'm not actually sure. How
I'm
they
just
ended up
trying to
getting
figure
the
out
CODIS hit.
if TrueAllele gave them an answer knowing who they wanted the answer to, or happened to have just given them all the profiles I found in here, and then they ran it through and found it on their own, because that just makes one difference, like, in my mind. But I've seen the way the TrueAllele printouts work, and some of them will say if it's 2 people, the thing is this, but if it's 3 people, the thing is this, and it can be really complicated. And then I've seen one where I'm like, so basically this report is saying it is a 50-50 chance that it's 1 in a billion. It was like 50-50. If this happened, then it's 1 in a billion. But if it's this was a 50-50 chance.
So it's like the old Anchorman, 65% of the time it works every time.
Fox Panther. Listen, here's my thing, babe. It seems like what they're trying to do now with TrueAllele is backdoor it in. So they're really using it as an investigative tool. So it's what it seems to me, and I might be wrong because I'm not 100 on all the facts, but it seems to me that they did have TrueAllele develop a profile, and they're like, okay, this profile came back a fucking gazillion to 1 to this guy. And at that point, they use that as a tip, like IgG. Like they keep trying to use the shit with IgG by referring to it as a tip. I'm like, it's way more powerful than a tip.
But then someone still needed to run the the ratio.
Yeah, but what I'm saying, so when they come back with this huge number, they're like, all right, well, TrueAllele is saying that it's this guy by a gazillion, but we understand the problems about getting TrueAllele in, at least how it's been nationally, just because you can't challenge it. Like, you don't know what the algorithm is. So how the fuck are you supposed to Daubert the thing? You can't do it, right? So what I'm saying is I think that they figured out a way to use it as a tool to narrow down to one person when it comes back with a crazy number. Like, all right, this is the crazy number they came back with, and it just happened to be Faust. And that's when they like, because and that's how they're avoiding not putting TrueAllele on. But it still doesn't get rid of the problem that it's a mixed sample. That's the whole thing.
There's samples that aren't matched to anybody that are not these 3 individuals that are at play. And then there was even one swab where I thought the likelihood ratios there was such a disparity between the likelihood ratios. I believe it was for what's in dispute, 2J.
It's really scary, man. It's really, really scary. Because Kat, I missed it. What did they come down? Like what was the testimony at the end of the day in terms of the match? Like what figure did they attach to it?
Well, so there were 2 oral swabs originally. We end up getting in 2024, after Faust has been arrested, they send the 2 labeled oral swabs off to Pure Gold to do a Lugol's iodine test and the RSID saliva test to say, like, hey, this actually looks like it could be a vaginal swab and you guys mislabeled it. They say that they didn't tell the lab pretextually why they were sending 2 oral swabs. They just let them figure it out on their own. That's what they said. And this second swab that was originally labeled as oral, but now the state's arguing is actually a vaginal swab because they don't have a vaginal swab otherwise, that for Kris Melton, the likelihood ratio was 1 and whatever in the octillions. And for Faust, it was only 1 and in the billions. Which to me is like, I get that billions is still a lot, but that's just such a like order of magnitudes of difference in those likelihood ratios.
Yeah.
And I would think that you'd want the person on trial to be the one that's the magnitudes higher.
For sure. Yeah, and it sometimes,
but
depending on
Chris
how
Howell's
much it
right.
had to be amplified, it could show that there was a stronger presence of Milton, and he's supposed to be a very minor presence because so much time has passed and it was transfer or it was drippage or so. But
And especially if they're only trying to use limited clippings because they only have one swab to preserve. Is that what you're getting at? The partial profile, they might only be comparing it to certain sequences of alleles.
right, and that's what we need to know. Like,
Were they using like
They-
snip testing? Like, but
It's snips of the swabs. They don't really get into detail beyond that. They basically just ask this witness, like, do you guys validate yourself? Do you
did
use peer
Cruz
reviewed-
challenge it? Like, did he
A little
challenge it
bit.
enough?
I think he did. We can watch it. We can watch it.
No,
if you
I don't
want.
want to torture people. Look, man, here's the thing. That fucking Chris Melton testimony was like appointment television. That fucking creep. Like, I don't know if he killed her or not, but he sure seems like he did.
Oh, that would be if he was the defendant and he took the stand,
Oh
that
my
would be when
God.
people would be like, "Oh no."
I'd be like, wait a second. I mean, that guy was the squirreliest motherfucker I've ever seen on the stand. And look, I get that that's an uncomfortable position to be in, right? Yeah, like he is not sitting up there ignorant to the fact that there's a lot of people that think that this guy murdered her. So like that adds a lot of pressure to the situation. And you're probably overthinking like everything in terms of how I should be acting on the stand. You know, it's like it's that micro, like you're just like everything's going through your mind and they're asking these fucking questions and you're trying to be super careful. So I'm taking all that into consideration. And he's still a really squirrely motherfucker, man. Like he is and I didn't know there was a podcast. And it was frankly, it was your tweet. You're like, oh, you're like podcast and like DNA solve this
I love
shit.
a cold
I'm
case
in.
that's reignited by a
Right.
podcast.
So like that sucked me in, and I actually Googled. I'm like, wait, so like some pod like helped solve this shit, and I Googled it. I haven't listened to it, but it seems like. Have you
I'll
listened to
say
any
it.
of it?
I think just by their face, I haven't listened to it, but based on the podcast Facebook comments, which seems like it's one person running the face, just on the semantics of how they're writing their comments,
Yeah.
it seems like a Melton protector.
Oh,
That's my
that's what I was
impression
afraid of.
this podcast.
That's what I was afraid of. Like I'd hate to think that was a driving force.
Well, it's very similar if you're familiar with the Wolfenbarger trial. That was, don't look at the family of the victim where the father was known as the Flint River Killer. Just look at the guy that had a relationship with her years ago.
Yeah.
So, and what revived that is somebody came forward to the podcast and said that at a party, the defendant in that case, Wolfenbarger, had made some odd comment and that it was like bad character. Like somebody just said he was weird at a party and said something that might have been incriminating. And they couldn't use it at trial, but it got the Fulton County District Attorney's Office ready to try the case. And
All right,
he was
Kat,
acquitted.
in a world, let me ask you this, Kat. In a world in which the DNA doesn't exist, what other evidence do they have that puts Faust in?
Black man walking.
Yeah. In the Jason Autry voice, innocent man walking. But they've got that, I guess, and they have an address that's on the main street near where this Deer Park residential neighborhood where a bunch of college students were renting student housing.
Mm-hmm.
A family member has an address there.
Okay.
One of his
And-
family members has an address there?
Yes.
Okay.
Yes.
And that's close to her house, is what you're saying?
Yep. Yep.
And that's it?
What the fuck's that have to do with anything? Like,
That's it. I think
went
it's
to a
worse
high
because
school like in the first suburb out of Chicago.
they're saying it's opportunity.
Well, right, because it was like West Side kids, West Side Chicago. If they could get like an aunt that was living in Oak Park, then they can go to a fucking infinitely better high school. You know what I mean? So yeah, like, and I was down with that. You know what I mean? So it was not unusual to have people live in Oak Park, like family, in order to kind of get the benefit of whatever may come with that. And in Oak Park, it happened to be you got to go to OPRF, you know.
I mean, but
Chicago
for opportunity, the I walk to the Walmart is just as much opportunity, I guess.
Yeah, well, I mean,
yeah, and the state was trying to object about Cruz like asking witnesses, like, were you aware that there's a Walmart over there? Did you observe a lot of foot traffic? Like,
so when we heard from the one witness who testified that he's in his house, this is at least what I remember him saying, and that his roommate alerted him to something. What did he alert him to? A black man on the street.
But they didn't call it in. They didn't
call
that report in.
How does that warrant alertion? Like, what are you? I was shocked that the defense attorney didn't say, wait, can you back up? What did your roommate alert you to? You just testified he alerted you to something. What specific? That a black man was on the street? Like, that was the extent of needed. Hey, Joey, oh my God, you got to see this thing. There's a black man on the street? I don't know if I missed something. That seemed like exactly what he testified
that's what it
to.
was. That's what it is. And I think there's an issue because in this case, you have witnesses that want to cling to the idea that what they saw matches the state's theory because this is, first of all, I don't think anybody wants to get on a stand and be outed as having some type of prejudicial views towards somebody that's walking in their neighborhood. Otherwise, inconspicuously, if you remove any prejudice views from the table. But then this is a televised trial, where everyone can look up your name and start commenting on your social media like, oh, you were warned by your roommate that someone that was black happened to be walking outside on the sidewalk, not with a hood up, not doing anything weird.
That alone should discredit him 100%. Well, now we know he was heading to the window as a racist. Like, well, I mean, like, and I don't know if they use, I don't know if this prosecutor is always on, but I heard somewhere some people thinking that he's black when he's clearly of Indian descent. And I wonder if they chose their darkest colored prosecutor to handle this case.
This is the best we've got for the optics.
Of course they did. I mean,
people can't tell the difference.
It's the Chris Darden shit. You know, it's like that was well documented in terms of when they moved Darden into position on OJ. You know, it was like, that's some circus bullshit. Like, that's carny tricks. And you know, it's like, this case stinks like fucking Delphi in the sense that, like, you've got some bullshit DNA evidence,
sketches,
and you've got the sketch, but he's like a specter. Like, they have mere presence by way of a fucking address that a family member happens to, you know what I mean? It's like
in an area with a lot of foot traffic.
Is there any real connection between the two?
Thanks, guys. He's the elected DA. All right.
Nope.
None.
And honestly, I think having a house, having a house nearby, Thirsty Thursday, college town. Like, I used to work in nightlife. We would want to bring all of the college kids and all the non-college kids together because you fill up like little restaurants. We would do these weekday nights.
How close is this
smaller
house?
Places.
Is it like 3 doors down?
I think, shout out to the band 3 Doors Down. Didn't that guy just die? Shan Pickle, I think earlier said 585 feet was the measurement. I didn't pick up on the detail.
Man, that is like some real shitting where you eat.
But like
that is shitting.
Her car was in the driveway. If this was a robbery gone wrong, why would you keep that house on that night?
Well, where's this stepmother? Did he come over your house a lot? Was he ever there?
Oh my God.
Well, yeah, we'll see if the defense calls him, but the state sure didn't.
Wait, am I in fucking crazy world? Like, who robs a house 500 feet away from where they're staying at? No one does that. No one does that.
With a car in the driveway, and then they only take a laptop. They don't take any jewelry, nothing. Nobody went into the other girls' bedrooms. Like, everything points to, I don't know, 2001. And Chris Melton tried to call her 5 times, according to landline phone records.
So what did the ex-girlfriend say? That the ex-girlfriend said some crazy shit, right? Like, is that like
the roommates?
Whoever? No, like, I thought that.
Oh, no, they didn't call. They didn't call. There was mention of a Brenda Swinney coming in, and Brenda Swinney is the one that after a long interview, and she has health issues, so like a long interview is going to be especially taxing on her.
Yeah.
She's had a stroke in the past. She ends up saying, You know what? Yeah. God came to me and he showed me what he
Right.
did.
Yeah, that was the shit.
He
All right,
set
so
a house
Frank-
on fire and took a TV, and nobody stole a TV.
So that did not make it in, though. At least.
No.
All right, thank
No.
God. Like I saw, I don't know if it was some shit you put up or like where I saw that, but I'm like, what?
It is a what moment. It is a what moment.
Oh, it's crazy. That's crazy. So I'm relieved at least that didn't get in. That would have
Well,
been.
I'll tell you, I'm gonna have to dig into the DNA because to me,
I want answers, babe.
defense doesn't challenge the DNA. He's done.
That's
Well, I think they are going to call an expert. I mean, looking at the docket, I mean, I've seen so much commentary that this defense attorney is unprepared, that he should have filed motions before court started. There's a whole docket full of motions that either went ignored or went ignored for weeks and then were denied with one big wall. As some of the suppression motions, the state didn't even oppose, and so I didn't get to see the hearings. But there's reconsideration motions like, hey, the state has the burden here, and they said they conceded on these points, and yet you still, like,
It'll
what are you
be
doing? Can you
super,
reconsider?
super interesting to hear what the jurors have to say afterwards about their feelings of the lawyers, of the judge, because Bob and I were like, oh, hell yeah. Like when he was doing his cross-examination and was started with, why aren't you crying? You
Why
know?
didn't I see any water drop from your eyeball?
Right. And
like,
then
oh,
like
go,
it's
man.
like we're thinking as soon as the guy says, well, I had to be there for the people who needed me, I'm thinking, who the hell needed
Then
you?
why
And then he
wouldn't you
says,
go to a memorial service?
right. And then he says, who needed you? I was just like, there's like so many, like
I'm still reeling from the devastation that I may have caused or whatever the fuck he said, some version of that. I'm like,
Yeah,
who
to me it
rewound
doesn't.
like 5 times. They're like, what?
To me, it doesn't matter if he said I or they. It still just seemed like a rehearsed Bumble stepped on a beeline.
It does.
Yeah.
It does,
Like-
man. Hey, it sounds like a flat out confession to me. I'm like, oopsies.
God help
Oops.
me.
It's
Jesus.
hard to be honest.
Yeah, I would
I'm
say
being
this
strong.
could be it too, because he did have a prior where he got in a fight with somebody that was someone that he knew that there was an ongoing lingering dispute with over the course of a couple weeks, and he ends up stabbing this friend. So there is a prior with a stabbing of a friend, I think, in the neck area. So I feel like GBI was like, hey, this is the perfect way to tidy up and close this case. Let's run some tests. Let's get a hit into CODIS on April 30th. And let's figure out how we can get a swab from Faust to confirm. Run
But
another
they weren't
test.
on to Faust until they got the CODIS hit, right?
That's their representation.
So, and Cat HID 71 just reminded me that of a point I wanted to make. The whole drainage thing, like a normal person's going to say dripped. It dripped from the vagina towards the anus.
Well,
Like,
speaking of Cruz Cross, I love his. Interesting that you say drainage.
right. Yeah.
Drainage.
It reminds me one time, like Bob and I are in a trial, and it was like when we first moved here from Philadelphia and started practicing here, and the cop's on the stand, and he says, "Well, your husband, da da da," and I was like, I said, and this is in front of a jury. I said, "Excuse me, do we know each other? No. Have we ever met? No. Do you know
looking me
him?
up?
No. I'm like, so are you out there? Or is this something you guys are out there talking about? You conversing about, what's going on in the courtroom, who the lawyers are, because it was like off-putting. So." And then he did the thing that we've also done many times. Are you looking over there for a reason? And then we'll step in front of the person and be like, you can just stay focused. We're asking you questions. But yeah, that was like so prepared. And then he did answer at one point. So is all the questions asked of you today, you knew were coming? And he said, yeah.
Cruz better put a fucking DNA person on.
A lot of hyperventilating.
I think he will.
He
I
has
think he
to.
will.
I've been telling y'all from the beginning, as soon as I saw the word TrueAllele in whatever form or fashion they got that shit in.
But if he had an expert, babe, sorry, go. No, I did my typical. No, finish.
I mean, I already forgot what I was saying.
If he had an expert, as soon as he saw TrueAllele.
Right, as soon as he saw TrueAllele.
It's done, because when a jury doesn't have anything else to hang their hat on, okay, and that's like, honestly, if you're looking at it with just complete intellectual honesty, you can't look at this case and say that they have other things to hang their hat on. It boils down to the DNA. And when you come with a fucking number like that, that's it. It's fucking done. Like, he's got to do whatever he can to challenge it. Whether it's going to be effective, I don't know. but to not do it at all is a massive, massive mistake. It'll be ineffective. He's got to do it because it's really the only thing. And like I'm sitting here right now, Faust is fucking done. This is going to be a 20-year fucking battle for this poor guy to try to fucking fight his way out, you know? And it's like, thank God you're on it, you know, and Mel's on it. Like I slept on this shit. Like I didn't even know.
Oh, I think it's made a difference because you could, like, the judge just seems to be hyper aware of what's going on in social media world.
Yeah, I mean, it's like I'm hoping that your coverage and Mel's coverage is enough to get somebody to fucking take a peek at it in terms of the appellate side and the post-conviction shit, because he deserves it. Like, this is fucking outrageous.
Yeah.
It's scary. It scares the shit out of me, frankly. All jokes aside, like, this is not a fucking laughing matter, and it's terrifying. You know, we live in this country where this shit is just, this is not the exception. It's just not. It's like we're always sitting here just shocked at how this shit's working. And man, I'm here to tell you, it's been like that from the get. It's been like that from the fucking get.
Even if you think the jury isn't buying it, of course, do it anyway for the sake of your client. But there's things like, and I think a lot of Brian Steele, when I think of relishing in the moment to have the chance to argue something in court. Like, he loves to get up to that lectern, that podium, and make his argument. He loves to argue in front of the Georgia Supreme Court. And Ahmad Cruz, apparently he said in an interview that Brian Steele is his mentor. So I can imagine, even if you think that this case is so shaky, even with the DNA, because you can't say that there wasn't a consensual encounter, and it's not semen. There's no semen present. It's just DNA from another source. And the idea that an attorney might just want to get up there to also stick it to this TrueAllele company and how it's being used in courts when it's admitted, I think that might be in play too with this type of attorney. If, you know, someone like Brian Steele is his mentor, who I know just looks for those opportunities to push the opposite.
But yeah, I hope you're spot on with that. You know, I mean, it's like, but not everybody's built like Brian Steele. You know, it's like I was watching
a very fractional amount of people.
Yeah, right.
Minuscule.
So it's like I happen to be married to one of them. That woman right there is a bad bitch. But here's the deal. As far as highbrow shit, and Kat, like, one of the reasons we were late today is because, like, we watched the Murdoch arguments before the Supreme Court of South Carolina.
Did you stream that?
No, we did not. We just wanted to fucking take it in because it was some super highbrow shit. Like that Supreme Court in South Carolina are some bright people up there. And I just love it. Like, if you love true crime, and I know that you enjoy, you know, the kind of erudite argument, like you like.
Yeah, I like the appeal.
Yeah, it's like, I mean, it's beautiful. That's why.
Especially with a good, like, auditory environment.
Yeah. When you're getting the back and forth, you're getting the law. You know what I'm saying? It's like you're stripping all the facts away and you're getting the nuts and bolts of it. We're definitely going to cover it on our channel because it's like I want people to watch it for what it is in terms of the beauty of the process, because the back and forth with the hot bench where you've got, you know, judges that are firing back and forth and you can just feel the weight of it. But above and beyond all else is that everybody that was involved with it, from the judges to the attorneys, love them or hate them, they're all fucking great lawyers. And they're all up there prepared and they're all making their arguments. It was a beautiful thing to watch in terms of the process. That being said, that fucking dude's getting he's getting a new trial. You know, like, you would think they'd be
but you got to separate the process. I like the arguments, the law, the process. I mean, it really, it's just a byproduct. I mean, the UCLA guy, it's unfortunate that all of the victims with that doctor are going to have to live through another trial for that. But what the heck was the court thinking by not disclosing that jurors, the foreperson, sent a note saying that the alternative juror that was swapped in, the rest of the jurors had concerns that he could understand what was being said during deliberation, which means he couldn't be a properly participating, deliberating juror. And you don't disclose that to the defense attorneys?
That's crazy.
Like, why wouldn't you want that to be an overturned? Like, I'm sorry that the specific overturned case is this UCLA doctor that victimized dozens of people.
Yeah.
But what?
I mean, you would also think, because like you're saying, we hope he's got an expert, but if he had an expert, you would have expected the cross-examination to highlight very technical issues and it doesn't sound like, just from your reaction, Kat, that it seemed like he did that he challenged whether there was too many contributors to fairly identify a major and a minor contributor, that there was
So
how
he
much
got clarity on, he didn't really get into amplification that much, just briefly, and I think with only one of the GBI experts. Although there was I stopped quick to make a quick phone call, but I think it was beyond the part where I think it was during direct anyway, and not when Cruz was questioning. Because I plan things.
You can
if I need a break, I try not to leave during cross. So.
You can kind of tell by the cross-examination whether he's had an expert help him with his questions, you know?
Yeah, I'd be interested. I mean, he did get into the different, there are profiles that you didn't identify that were also found to be present. And I think that might not even be important to get into, like, TrueAllele and the testing, but just the idea that there's other potential suspects. So the defense has chosen a third-party culprit, and he's barely been able to mention. He got objected to in openings when he said the state can't rule out that the two of them had an encounter in a public place. So he's hamstrung, even though he's put the court on notice that he has.
They could have had a public encounter within 5 days, 6 days. How many ever days that they're stretching it
right,
to?
A wide possibility.
Right. So, I mean, did he say that? Did he say, do you know that 7 days prior that they didn't have an encounter? Did you know 3 days prior they didn't?
When
have
you
an
guys are
encounter?
using the word encounter, what does that mean exactly?
Like sexual encounter.
Well, so that's
a
the point.
sexual encounter.
I don't even think it has to be that necessarily, because there's no semen.
So
was
there
DNA
in the mouth
issues in their relationship? Like, were they on the rocks? Like, what the fuck was going
Depends
on?
who you ask.
State says they're fine because he got her a Christmas gift. He
I
was
don't
the
care about that.
fiance. The defense says there was a fight, that somebody reported to detectives that Tara had gone to his house and left a written note. Like, sounds to me like you're trying to break up with somebody.
Yeah, Dear John.
And the only person that claims to have birthday plans with her is Kris Melton. When the roommates were on the stand, they're like, hey, I had an equestrian competition. I felt really bad that I wasn't going to be here on Saturday, her birthday. And I was trying to figure out, like, what can we do to make up for that? She was not on the stand mentioning, but at least I knew she'd be with her boyfriend, Kris Melton.
Which is
And
significant.
to me,
the
that's
defense didn't ask you.
That's
She didn't
super
tell you
significant.
about any plans that she had with, like, there were no questions from the
There
defense.
was no
about,
one to corroborate that Kris was actually doing something with her on her birthday. It's
right?
just-
But was there anyone to say they were having
awareness that
issues?
she would be alone.
Right.
So on cross-examination after directive of the two roommates, with cross-examination we get to, but didn't you say to so-and-so, whatever, who did the interview with you, that you think they had a tiff? Oh, and then they were fresh, and then that came out on cross, which was very different than the direct where everything was honky-dory and that they loved each other. So I think there's evidence on the record that they were on their way out, and to me, it put me in the picture of imagining you're mad that somebody's not picking up their phone when you know it's birthday
Right.
weekend. And
A whole
if we
different
were
thing.
dating and you don't want to make plans with me for your birthday, I know that's it. You are out of my grip. You are moving on.
Right.
I don't have that special time with you anymore. You're going out with your work coworkers, and then on the day of your birthday, you're not agreeing to let me come over.
That's
And
huge.
Yes, I can
It's
picture someone
everything.
snapping. I can picture somebody
Yeah.
snapping.
Especially that fucking unsteady motherfucker. You know what I
Mhm.
mean? I mean, like, that dude's like, I mean, I'm watching him 25 years after the fact. Everything, the breathing, the eye clothing, like, everything was so bizarre. I'm like, it took us like 3 nights to watch him. You know,
Just
it was
having to
like we
react
kept
and
laying in
process it.
bed, and we're like, like the first night, I'm like, in like
If
7
you
minutes.
guys end up streaming this trial, it'll be my 4th time watching his testimony. So
It's-
don't think I won't
man,
come running to watch it another time.
It's crazy. It's crazy. It really is. Oh, it's so scary. Freedom Ring, throw his question up, Kat.
Sweet. Thank you, James, here. And I think we all agree, if it's not clear, this is why forensic science needs to be exposed for the quackery it is, the most harmful grift going, especially when the conclusions are being slung way outside the bounds of what could be
Right.
suggested by data. And that's always the issue. The state wants to stretch it so far beyond what maybe could be
Right.
helpful.
Just admit its limitations on the front end. You know, quit making it be the end all be all. You know, it's not the solver of the case, you know, but they represent it as it is, you know, and that's what the problem is. And you know, because look, is there science out there? Yeah, forever. You know, and like trying to get your hands on evidence, you know, from these courts, like after the fact and post conviction world, where you're like, test the evidence, man. like what are you doing? Like, why does there ever exist any scenario in the world in which, for everybody involved, the victims' families, for the defendant, for everybody, where if you have evidence that you test it, we want to get it right. That is
no court has heard this piece of evidence before.
It's crazy.
Give us a hearing.
It just exactly. It's so like I don't understand it. And we were in it. I was in it for a long time. It was the frustration is real. It really
and thank you, Freedom Ring. Question for Bob says, Bob, why isn't Melton's DNA grounds for reasonable doubt? I don't think Faust's attorney has a DNA expert.
Well, I hope you're wrong about the no DNA expert, but it is. It absolutely is grounds for reasonable doubt. The problem is jurors. It's always the juror. It's like the way that number is going to resonate with the jurors, and having it go unchecked is going to be the death knell for I'm just telling you, because like you walk away from Melton like, all right, I mean, number one, they've got the DNA dripping or the drainage from that, you know, whatever the case may be. You knew that he was with her. Like that stuff that you're talking about, Kat, is so critical. Like I need to know what the actual state of that relationship is at the time preceding, you know, the week, 2 weeks, a month preceding the homicide. Because it's highly probative. I can't think anything more probative.
I do think Kris, oh my gosh, I do think Cruz got that out, not just through some of his questions with Chris Melton, but also through the roommates.
I mean, he's a compelling third-party suspect. He just is.
Wait, I want to know what Kate's saying. What kind of encounter, Kat's saying, what kind of encounter could they have had where his DNA ends up in her mouth?
I don't know, like, why couldn't they just be out at this Mexican restaurant at night? It seems like her law firm friends were maybe getting together, like, you know,
sucking off the same straw, drinking off the same cup.
Because there's other DNA in the oral swab as well, other profiles that they don't identify.
Well, if that's the case, maybe. But to me, without challenging,
and I would say a hookup is totally on the table too. Like, I'm.
But
not
if that was
that
the case, he needs to have asserted a defense of consent, and he hasn't. You know, so I mean, I was throwing that out there as like, well, you never know, they could, you know, but the
See, you need to get the DNA. You need the data because I like how many places did it hit? Like
just the mouth.
No, but in terms of like
how many loci?
Yeah, like in terms of the loci, like what was the count on that? Like was it like 6? Like where did what did they use?
I don't know.
I mean, we're gonna watch everything. That's everything, because that was what they did in Garcia when they brought in TrueAllele, and it was that black box shit because their lab had come back and Garcia was a 1 in 12, meaning that one of the jurors, you know, is just as likely to have left that material, the biological material on that door handle is Anthony Garcia, yet the judge was going to allow it in. So they went because they had forever, because of the length of that case, because of the competency issues and everything else that came along with it. It was giving them ample time to go to TrueAllele, and then they wait till the 11th hour to go to them. And, you know, we had never heard of them because they were kind of a fledgling company at that point. And then, you know, we get it back to our expert, and Carl Reich's a genius. Like, the guy's fucking amazing in terms of being able to have lay people understand DNA science. And I'm talking about jurors, you know, it's like that's his superpower. It's just a real unassuming little scientific nerd who I love deeply because he's amazing, you know. And it's like, that guy's like, how can I challenge anything? Because he's not giving me the algorithm. I don't know how they're arriving at the number. If I can't challenge that, then it's literally black box shit, like the worst black box you can ever imagine, because no one can challenge. Because his argument is proprietary. Like, it's my whole company is wrapped inside of that algorithm. I'm not giving it up, because once I do, I'm like one of a million. Everybody's going to, so it was like, I'm like, fine, but your problem, your business model problem is going to be you shouldn't be allowed to have your shit used in courts of law because no one can test your shit.
Yeah, and I do think Cruz is aware of that. I mean, he did get the witnesses to discuss and react to some academic papers. Some of it was just to establish like the time of survival, the maximum windows that DNA could survive in different areas on the body, but also on some of the reliability. And in pretrial motions, what I think is so interesting is the wording switches, where it seems like an issue was raised where it's not just dealing with partial profiles, but a partial match problem. And that was all handled at a hearing before court. And I wouldn't expect that this judge would know the difference. And defense maybe couldn't work around that. But it seems like before this trial, Cruz had concerns that what they did was rely on a partial match. Not a partial profile, but a partial match.
Wow.
So, I mean, I would hope he has a witness. He also brought up when writing his motions about TrueAllele, like, hey, you can't get into their proprietary algorithm. I thought it was a great motion. He raised several grounds why there would be issues with how the DNA was collected and then the testing of it's unreliable. But he brought up once a similar company, SRT Mix, released their algorithm became public, people discovered errors. So I think there are some good arguments on the docket that would suggest that Cruz has either become familiar with or has somebody helping him figure out how to digest it. And unfortunately, this is my first case that I'm familiar with him, so I don't know.
Yeah, I like him. I like his demeanor, just overall. I mean, he's not refined in his cross examinations, but he always ends up kind of getting the point out. You know what I mean? Which at the end of the day,
he has like a natural that doesn't make sense meter,
right? Which he's good at, and that kind of thing.
There's a couple of times like he makes the argument almost right, but he misses it a little bit. But
where it might not land for a jury who doesn't already have something in.
No,
I
mean,
mind.
I'm talking legal arguments. Like when he's made some legal arguments that are like close, and I'm like, wait, he's a little bit wrong there, but still the judge is very wrong, And like I'd made that explanation about the prior consistent statement. He said enough, he didn't use the right buzzwords, but I don't think it would have made a difference. But that's, I think, like Bob's saying, like where he's like, no, this doesn't seem right, kind of thing, like that he's usually on the mark. But then the judge really demeans him in front of the jury, like the comment she made yesterday. I think it's the first time you're both right, which was basically saying it was the first time he was right.
Yeah.
And then she didn't, he actually was right, but she only took like one little part of what he said that was right and misapplied
Evened out the playing field.
Right. It didn't even, none of that should have been getting in. None of that should have been getting in. So,
and then to comment in front of not just like jury presence, but the client.
To me, if they don't challenge a DNA, I don't think it's enough necessarily for reasonable doubt, because they've got to be given an explanation for his DNA in the mouth. And I can't tell if it doesn't seem to me like you got from the cross-examination anything that would explain it, because to me it has to be explained as wrong. Like that it's not there.
Right. It's not his.
Right. That you're.
Well, I think the more compelling thing is the idea that they only end up having these matches confirmed after they take some swabs. So I think there's integrity issues, chain of custody.
But that's
issues
what I'm
galore.
confused about.
And I don't know if the jury will pick up on that. But then we have the interview with. I don't think Faust is going to take the stand. But we have his interview played where he's like, when he's reacting to this news that some girl that was murdered in 2001, he's like, I heard about that girl. It was in the paper. People were saying that blah, 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 blah. He'd already said prior that, he used to get with a lot of females back in his day and that he doesn't discriminate. So I do think there's the visual on the record that he was the party playboy, would always be jeweled out. And I think one of the most critical things that Cruz has done is make sure to show the jury that at the time of this crime, he was the same age group as Tara, because the jury's sitting there, they're looking at Faust in the courtroom every day and they're seeing pictures of a young Tara, like the last state that she was alive. And they might not be able to keep that top of mind that, hey, this isn't this guy here sitting in the courtroom versus a 23-year-old.
And then you ask questions on cross like, can DNA transfer come from someone buys you a drink and opens your straw?
Yeah, we only got with the like, could it be skin cells? You can't say that it's not.
So, I mean, I don't know much about him in terms of his background, right? So, whatever, he's got some priors. I'm not worried about that necessarily, but in terms of like, where was he at in his life at that point in time? Like, what was he doing? Like, was he in school? Was he work? Like, what was he doing? Like, because in order for me to kind of build out his life in terms of like, he was just that dude, had a job he was fucking with, slinging some shit on the side and just kind of, you know, being a 20 whatever year old and going out and partying. That's, you know, that like, is there a chance? Because Allie's right. Like the best bet, if you can't fill out those answers for me in terms of where they might have ever kind of crossed paths, if you're not like going all the way into consensual sex, which to me is super scary for a lot of different reasons down in Georgia. You know, to me, you've got a real fucking problem. And like, do you think that was answered during trial? Because like, I'm hearing like, maybe they, you know, maybe they were in the bar, man. I mean, that, yeah, like, I don't know. It's like, that's not super compelling to me. So like, we really need more, but I hope the jury, because I know that you watch this diligently. All right. And
yeah, and I mean, I don't get how we have Kris Melton's DNA on the anal swab if the last person there is, and the theory that the expert, not this witness, but the next GBI that talks about the DNA, Ashley Hinkle, she ends up saying, well, another possible way without penetration would be, or the drainage. Then later she goes back into this insertion being a way that you could get DNA from vaginal to anal without, like, I guess the theory would be that Faust transferred Kris Melton's DNA from the vaginal cavity doing anal insertion. But there's no Faust DNA in the anal swab.
So let me ask you this, because here's some ways that this can happen. Did he ask on cross if they were both in the same bar and there's coughing, sneezing, you touch the same
to.
What do you mean?
He was objected to and he cannot say that they had an encounter at a restaurant that night.
No, they don't have to have an encounter. They don't even have to have an encounter.
By encounter, I mean even be in the same room, the same public place. I don't mean literally having sex.
He has him associated with a location 584 feet from her door, and they can't end up in the same location?
Nope.
That is actually ridiculous, because if there's multiple people in the mouth, that can be explained by you're in a bar, there's coughing, there's sneezing, people touching things.
Life is gross.
It is.
You know, like, wait.
Yeah,
what?
they said it was a violation of Rule 412.
Which is
what?
what?
Into the rape shield law. Well, let's read the statute, actually, because I think you'll think the language is interesting.
No, that's not that has to be about sexual promiscuity, not being in the same location at the same time.
It up. I think it is the rape shield law. Like when I saw that argument, and I'm like, what the fuck are they talking about?
I gave Bob the boot. All right, we're super tiny here. But yeah, this one, Rule 412 in Georgia. So complainant's past sexual behavior not admissible, and it's a complainant not admissible in prosecutions for certain sexual offenses.
Well, yeah,
I don't know if you want to read it in any detail at all, but
it's probably the same as most rape shield statutes, but it would have zero to do with them physically being in the same location where coughing, sneezing, skin, like if it's what time of the year was it?
January.
So
the 18th into the 19th. So they believe that the fire was the morning of the 19th.
What state are we in?
Georgia.
Georgia gets cold in the winter, right?
Yep.
You're cold, your skin, you can have skin shedding in the air. You do not, I mean, these are all different ways that like I had to give it some thought, but
I
at
mean, but
first I
we're
couldn't.
all sitting here without having any real actual knowledge of the strength of the profile. You know what I mean? It's like I was starting to say is like, Kat, I know you're a diligent observer of the cases that you're watching. And if you're walking away from this thing kind of unsure of what the DNA represented for the state, then he should be walking, right? Like,
Yeah, that is where I am, because their explanations to me, like, it seems like they're things that would be worse for Kris Melton and don't help explain why we have Faust here. Like, I don't get how, if Faust is the one that transferred something somewhere else and it resets the clock, that if something can only survive at maximum 7 days in the vagina, and Kris isn't sure if it was 10 days or 6 days since he last saw her, that somehow between that maximum window, day 6, and Faust coming into the picture, which you would think would be on the 5th or 6th day if he's in the oral swab and present, and that only lasts for like 24 hours. One of the witnesses said that the clock could reset if Faust comes in, transfers the DNA by doing insertion in different areas of the body, and Melton's DNA, the timer on that, even though it would be a max 7 days in the vagina and 3 days in the anal cavity at best.
okay,
if it was coated in semen.
Can I stop you right there?
Yeah.
I want to stop you right there. With respect to that, okay, this concept that dude's semen is just fucking hanging around it. I mean, I'm not a woman, all right? So I'm coming from a complete
The
place
state
of
said she
ignorance.
showered, her hair was wet.
Right. I
at the
mean,
time
she
of death.
showered in a week, right?
Yeah,
Probably
come on.
daily. What the fuck is like, I mean, am I in crazy world? In what world does that's what I'm saying. I don't have a vagina, obviously. So is that true? Can it stay there for a week?
Well, and that's where they come up with the drainage, which would rely on like
For a week?
ejaculation. And there's no semen. Semen was not found. Partial semen was not found.
I'm
So
fucking.
if we don't have seminal fluid, how do we have the drainage explanation? That stuff just goops out and drips down and gets stuck in the anal cavity.
It sounds like he fucking raped her anally and then killed her.
Out of anger, like
Right.
snapped, right?
He's furious. He probably, like, I saw, like, I don't know what's true and what's not true in the chat, but like somebody's like, oh, Tara was known to have been, messing around with an attorney she worked for. I'm like if dude finds out about that, it's a problem.
Well, and this is so granular, and I don't know if a lot of people think this way, but I feel like if I was sitting on the jury, because the defense can't get in, not only can they not get into consent, but they're obviously not talking about alternative suspects. They weren't even allowed to get into potential suspects in the early stages to talk about how the investigator proceeded with their investigation, because the state objected to the mention of other suspects' names in the report. What I'd be wondering, I think that would backfire. If I was sitting on the jury and I didn't hear that in 2 decades that the investigators looked at anybody else besides Kris Melton, I'd be like, they didn't investigate everybody. What about anybody that went to law school with her? What about anyone that's a weirdo in the area? They just didn't investigate these people.
No.
And of course, they did investigate other people, but the jury has heard zero, not an iota, that they looked at an alternative suspect contemporaneously. And I mean, that's something that if it was Kris Melton on trial, that I assume that's what he would want to argue. Like
100%.
like-
So in terms of them calling Melton in auto doc, I think the proceedings are done for the day. Am I wrong on that? Auto
oh yeah,
doc
they
is
ended
set-
court.
Yeah, I mean they did their motion for directed finding.
And
I-
guys, if you missed it, they might not have court at all tomorrow, and if they do, they're going to start at 12. But that it's still up in the air.
drainage lasts up to 14. The whole drainage thing is just like, what the fuck? Oh
And
my
like 4
God.
witnesses said the word drainage. Like they all knew they had to mention drainage.
It's
Just
a
get
week.
the word out there.
It's a week. I've been with my wife for a long time, and I am not aware of a situation where my shit's fallen out of her a week later. Yeah, like you're like, oh, hon, your shit
Starting
just
to fall
dropped.
out.
Oh, it was a week. I mean, what the fuck? This is truly terrifying. It's true. Like what's going to end up with this thing is that TrueAllele's some black box bullshit. Because we have to see what's what. We have to look at the data. We have to see what they had. And it's just, I really hope Cruz has somebody. I would have put him on fucking Reich, because Reich's awesome. Like Reich and Reich is a mixed profile guy.
That's
Like,
the type of thing I just like to watch, even if I don't think the other evidence is compelling. Like, that's
Yeah,
the type of
and-
thing I like to see in the courtroom anyway. Like, have your shot to, especially in a trial where people might be watching, but have
Yeah.
never questioned the strength of DNA evidence and how it's used, how it's applied, more so than what the data itself can tell us.
Yeah.
I just like seeing that stuff come in.
Me too.
Because there was a time where I had no idea that you couldn't, if they have his DNA, that's them. Throw him off the bridge, put him under the jail. Like, that's
Right.
at one point in my life, that's how I would have looked at it.
Off with their heads.
Yeah, like, I mean, and then you learn things.
Yep.
So
I mean, it's a credit to you that you give yourself the space to do that, because there's a lot of people out there that just can't do that or won't do it, in terms of kind of expanding their minds, expanding their horizons, thinking about things critically. It's a better way to go through life, in my humble opinion.
well, I like, the chat plays devil's advocate. I think everyone should be okay with, hey, what if someone looks at this way, without the chat having to be like, how could you think that? We're just presenting possibilities. You never
100%.
know
Yeah.
the way someone
That's
could react to a piece
our
of
whole channel is
information.
about that, and it's like, for our mods, it gets like, they get super protective of us, but we say it over and over. Like, I never step back from a challenge. Like, if somebody wants to debate me on anything, I'm fine. And if I lose, I lose, and if I win, then I have an expectation that person to be like, yo, okay, you were right. You know what I'm saying? But it's like, I'm always up for the debate. Like, that's the entire thing. If we're not up for, if we've given up that, if the art of debate is going to be lost, then we're lost, truly, because it's like, you just can't, you have to hear opposing theories, especially in cases like this, in order to be able to challenge your own theory. You know what I'm saying? So it's like, this is a scary case, man.
Yeah.
Uh,
I have a stupid example. It's a little bit of cat lore. This was back in the Twitter days before I ever had YouTube. It was a defense attorney. It was a celebrity that was being accused of an ex by a woman of sexual assault and battery. And what she provided as proof in a civil suit was text messages, and the text message reads something like, she's like, oh, I have like the pregnancy test, even blah, 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 blah. And the response from the guy, the accused, was, I came on your back, with exclamation points. And I saw a defense attorney, or at least that's what it said in his profile, arguing like, that's the evidence of the assault and battery, as if there's no other explanation. And I'm like, but if you look at the context of the preceding messages from months ago, this is someone saying that they're pregnant and somebody saying, how are you pregnant?
Right. I ain't the guy.
I came on your back. Like, to
Right.
me, it just, the way I read the messages was just such a polar opposite of the way, and I'm sure I've been on the flip side, right? Before I would understand why somebody would use that language. But he was an older guy, and I just don't think he ever heard someone speak colloquially like, I came on your back. Like, it just didn't even click.
Right.
And if you don't talk to people about the way they use words, the way they say certain things, you would never think of that possibility the next time.
Yeah.
Probably more
100%.
importantly, if you're ever a juror, or if you're ever faced with the opportunity of representing a client. Like, I like attorneys like Doug Weinstein, that make their client part of the defense, because
Yeah.
their client can explain certain things to you that you might not even.
Exactly. Well, I mean, if like you didn't grow up kind of savvy to that, like in terms of like being able to truly, like, that's one of my better abilities in terms of, being a criminal defense lawyer, is that, like, kind of my upbringing, like, I am able to communicate in an effective way, to where it doesn't seem like I'm full of shit, and where I can kind of get that kind of connection with my client, to where I'm pretty confident that they feel comfortable in terms of us being able to have a dialogue that I think is going to net benefits down the road, where there's a lot of lawyers that just don't really fuck with their clients like that. You know what I mean? There's just a lot of lawyers like, oh, the case, go visit them at the jail twice and,
Here's
whatever.
what the state's offering.
Yeah, right. So it's a different type of practice for sure. But, Allison and I were always really hands-on lawyers with our clients in terms of, really trying to get to know them because it matters. It matters in terms of, especially if it's a case you're going to trial on. If it's a case where you're like, all right, they got the evidence and you go to your guy and you're like, look, this is what it is, at this
Jury
point.
trial's a risk for these reasons.
Yeah, right. So I don't know. It's I like Cruz though. Like, is he pretty young? Like, how long has he been practicing?
I think I've seen the chat mention like maybe like 8-year time range, and I don't know what that star point would mean, but
that seems right. By the time he's 15 years in, he's gonna be a beast.
I think so too.
Yeah. Because it's like he's
I think he's managing a lot. I think this is a pretty big case.
It's a big case.
As with Wolfenbarger, where there wasn't even DNA, we had 2 very good attorneys, Don
Yeah.
Samuel, Joel McDermott. They were great attorneys. And, obviously the resource piggying off each other. And there's a co-counsel here, and there's another, I haven't seen the appearance for the third guy that's been there 2 days now. I think he's been there 2 days. And co-counsel has argued a little bit at the bench, but he obviously hasn't cross-examined. He didn't do any cross. I watched the whole trial. So that's a lot of prep work for a single attorney in a murder cold case.
Huge amount of work.
So, yeah.
It's like I was talking about when I talked about this the other night, and people just couldn't stand her. And I always remember, what is it, babe? Shannon Smith, maybe from the Crumbly trial. So Mom Crumbly. Do you remember that? That's the school shooter's parents.
Yeah.
So, but like Shannon, I think that was her name. And I felt so much sympathy for her, knowing just how hard, talk about a lot of evidence and a lot of shit to do. And you've got 5 banker boxes just piled up at the end of your counsel table and really no one to help you navigate through all the shit that you need to produce as you're going through cross-examinations and preparing your own directs and doing all the things that you need to do. Solo is really, really hard.
Well, I think it's getting worse as time goes on because there's so much more data available to being available in a discovery file, and the state has the resources to get these parsing softwares, and the state can employ them, and then they don't need to identify to you, the defense attorney, what they've parsed down and what they plan to focus on. They're just going to give you the whole dump and say, well, it's in there somewhere.
Yep.
And so you have to have the wherewithal, the resources, and the money, because it costs money to get these. One of them I looked at was like 10 grand annually.
Yeah.
Who pays for that? Who pays for that? And how do you, if you take on like an indigent client, how do you even split up that billing? If you buy it on your own, can you even bill the court for that as a fraction?
I think the way that you'd have to do it is a couple of people that, have private practice, we
Get
were
together.
well, either you do that or you bite the bullet, understanding that it's going to, number one, allow you to parse all of the evidence, which is obviously critical.
Yeah.
When you get 15 terabytes of shit and you have a year to try to go through everything, it's overwhelming. And frankly, there's just not enough time in the day to do it. If you've got audio, video, even if you've got it transcribing it for you, either way, the time is going to be used. If you have to watch 16 hours of surveillance shit because you're looking and hoping that you're going to see something that helps your client, and you're like, you know what, man, I got so much other shit to do. I literally don't have 16 hours to sit here. And if you don't have a staff, where you're saying, all right, I'm going to put one of the paralegals on this shit. Okay, here's your job for the day. You're sitting here and you're watching this like a fucking hawk. And this is what we're looking for.
And you've got to anticipate, we see how prosecutors will take something that really objectively is the most innocuous thing and twist it to be some type of consciousness of guilt spoken out over a jail call. So while you're reviewing stuff, you have to not just review it with your own lens, but you have to have this constant be on your toes. Could the state take this and try to turn it into something in front of a jury, like looking at it from every angle.
Yep.
And Jim here, Happily Angry Lawyers, like Miss DeWilliams in YSL, she was getting like 15K and had to, that trial went on forever.
Oh yeah.
So she had to fight with the court on that.
Oh my God.
And
It's
then
like,
they had a division of labor in that case. Like Max Shart, who represented Shannon Stillwell, was the guy who listened to a lot of the calls. He would listen to the audio and he would know what needed to be redacted. He would handle all of those arguments, unless it like was so ancillary that there was a Bruton issue and it wasn't going to impact his client at all. And that one attorney for that client would be like, hey, there's a Bruton issue. You can't play this at all.
Yep.
And move on. But like they were able to do a division of labor across the co-defendants that were tried together for the first
and it was
trial.
still a nightmare. It's like
still a nightmare.
those RICO cases, like those need to go the way of the dodo, because it's like, even back when my dad was trying RICO cases, like in Illinois, always on the federal level, obviously. And it's like, it's so hard for the state to make their case. It just is.
That's why I was interested in
it's
the
fast.
YSL RICO, because I said it was the state.
Impressed by you fucking doing the damn thing. Like, because that thing was grueling in terms of streaming. But it's like, I was like, that's when I was like, oh, cat's the fucking truth. You know what I mean? Because
I wasn't going to stream it. People were asking me and I'm like, I'm watching it, but I'm not streaming it. And then I got so pissed off and it was still pretty early on in the trial. I got so pissed off when they were bringing it was like their second plea deal witness, and the way that it was written and pressing them on, you can't testify truthfully. Well, we threw you in jail. We followed your car. We pulled you over. We threw you in jail. We denied bond. Multiple bond requests for 7 months. Christmas comes around and suddenly we're putting this deal on the table for you to take a plea after we wouldn't even give you a bond hearing. I was like, that's gamesmanship. That is gamesmanship. And so I'm like, that's it. We're streaming these motions. And it started from there.
Yeah.
So
I mean,
otherwise I was just watching. I was just watching the car wreck.
It was really a fascinating trial. It's like, kind of from like our perspective as creators, once you decide to do it, it's like you're kind of in it, you know what I mean? And it's like for you to have done that, because it's like Woody was fucking appointment television, like that. He will forever and always be my favorite witness of all time. I loved everything about him. Like I could just watch him testify for years. You know what I mean?
I almost had a heart attack yesterday because I think it was Cocoa Beach, but something that came up on a news ticker locally for me. Woody's name is Kenneth Copeland. I see Kenneth Copeland arrest. It's just someone with the same name. It's like 15 years old. I was like, no, Woody. And then I realized different Kenneth Copeland.
Yeah.
So is there, do we know where she was in the 24 hours before she was unalived?
So they know that she was at the library studying with a friend. The friend said she left early, but knew that she had plans to leave the library by 10 that night. It seems like she had plans to maybe go out with some friends. And the last sign of life is the friend that left the library early. She was like, Tara told me to call her, let her know when I got home safe. And like a bad friend, I didn't call her. She called me. So Tara calls me and like, why didn't you call me? And she said that was, I think, around like 9:45 that evening. So that's
no
the
friends
only testimony.
So do we know, did she often go out alone? Did she plan to go out alone? Was she supposed to go out with friends? If she did, I'm assuming that they would have interviewed these friends and figured out where she was.
Allie's trying to crack the case right now.
Well, I'm just trying to come up with an innocent explanation. There's either an innocent explanation for his DNA, which I understand the judge is not allowing in any way, shape, or form, or you have to attack science and say that the DNA results are wrong. And I think without either one of those things, that a jury is not going to be able to get over. I don't care how suspicious the boyfriend seems. This guy's DNA is in her mouth. This guy's DNA is in her mouth, and there's no explanation for it.
Yeah, I think that's an extremely tough burden, and I mean, I'm seeing it in the comments. Like, why would Tara mess with someone like Edrick Faust? So if you have,
but again, like we talked about, it doesn't need to be that. It can be you touch the same salt shaker at a restaurant, the same water cooler, the same doorknob, or again, like you're. Communication stuff in the air, skin cells in the air, in a in a crowded, not greatly ventilated bar.
Yeah.
You know, like if they were like, oh, she hung out at this place a lot. Well, then maybe you do say I did often go to
Yeah.
my mother-in-law's and I was at this
I don't
bar a
think
lot.
there's anything direct. I think the closest thing is just the general idea that she was in the sorority and was very active in any events that they had going on and would socialize, pick different dates for like any formals and events that they had. But that's not the same as, hey, she had a habit of going out on Thursdays. like very different.
All right. Huh.
So, and I don't know.
Well,
I think the defense is going to put on a case in chief, but unfortunately on the docket, I can't view the witness list for either side. It's just not available. So, which I thought was a little weird because the jurors' names are sealed or not sealed.
the jurors' names aren't sealed?
Nope.
They
All
usually
12
seal
of
them
them and
until
the
afterwards.
alternates are available. Yeah. Isn't that interesting?
Yeah. Huh. Well, did we answer everybody's questions?
Yeah, I mean, I think I don't know if we really have clear questions. I think we have kind of a what? Like a
Were
bit
there
of a what.
supers?
Yeah. Yes, we did. And thank you guys, by the way, for sending them in.
Yes, that was
Are you
very
guys, I
helpful.
know you guys have been doing evening streams. Are you doing anything tonight?
I don't know. We might. We were talking about possibly doing a Murdoch thing, but maybe we need to watch this just to go over what happened with the Supreme Court today. I think it was very clear based on the court's questioning that he's going to get a new trial.
Very interesting. Everyone, a lot of people in the chat have been talking about that, and also the beginning of Dale Warner, that case as well. So there's a lot I feel like to catch up on.
Are we going live tonight, babe?
Yeah, that's the question.
I don't know. Did you want to do like we're gonna do Murdoch. I don't know if tonight's the night though. Is anything going on with the
if not tonight, do you guys think that like you guys should follow Defense Diaries anyway for like 1,000 reasons, but especially you guys have been asking about certain topics, and you guys already know I've said they're the place to go for Aaron Spencer, which that's still stagnant while they deal with the switch of judge, right?
It sounds like it's going to trial mid-March.
Really?
Yeah.
Oh, that's quick.
Yeah.
All right.
So
they're the source for that.
That's the word on the street. So I don't know.
Yeah, you guys, because James, thanks for the question here, James. But I mean,
she is the complaining witness legally. She, the victim. You cannot comment. So we had a case once, where it was two people who knew each other at a party, allegation of that she was too drunk to consent, grape. And she had said that she had no sexual intercourse with anyone for 3 days. And this is why I said that 3 days was really like the important part. And I think if we would have been allowed to ask her, she would have even backed that up to further. But they had asked her 3 days because that's what they're really using. So they say to people, have you had sexual contact with anyone in the past 3 days? You know, so she said she hadn't had sex with anybody, and there were 2 people's DNA in her vaginally. And they would not let us get that into evidence, even though she's saying if anybody's DNA is inside her, it was by force. So I'm saying the rape shield statute shouldn't apply because this isn't challenging her, whether, her sexual choices, whether she's promiscuous or not. She was forced. It has no bearing on her, what do they call it? Chastity or whatever words they use in the statute. And we weren't even allowed to bring it in to show that she was either lying or didn't remember what happened,
just to challenge your credibility,
or that she was sore from this other person who sexually assaulted her. And sorry, I'm using full words and I know I don't want to get her,
dare you, man,
dinged, essayed, and that she has no recollection and that it was consensual with the defendant. So to me, that statute shouldn't come into play when someone is saying they were assaulted, because it's supposed to be dealing with saying this is you're promiscuous, so you wanted it, and that's clearly not the the issue. But to say that she can't say they could have been in the same place having nothing to do with a sexual encounter makes zero sense to me, unless they're saying there is no evidence. You've got to give me a foundation, and a foundation would be he was known to hang out in the same area, which probably doesn't want to say, you know.
And I think that's where we get to the cold case issue that the judge was just leaning on. Like, it's a cold case, so I'm going to give you more of the benefit of the doubt. But at the same time, how is somebody that was never a suspect contemporaneously, wasn't a suspect until decades later, supposed to be able to like realize and even think of something that could go to that type of evidence, or go and procure it?
If they said, I went to my stepmom's often, I went to multiple bars down there often, that was like where I hung out, you know, there's reasons why the defense wouldn't.
Yeah, it's a double-edged sword.
Right.
There's no question. It's, you know.
And if you can challenge it on the science, stick to the science.
Yes.
You know?
Yeah.
But they're already putting in that he had this house nearby, so he had opportunity. So that if there's that opportunity, there should be opportunity for you know, transfer.
Right.
I don't know why he wouldn't have been allowed to ask the expert, you know, can you get DNA in your mouth if you guys are from transfer from I touch a salt shaker one day, you touch it the next day.
Forget all that shit. How about a bowl of peanuts at a bar? Okay. Like in somebody's
popcorn machine.
Whatever the case may be, you know, anywhere that there's going to be transferred DNA in a public place, it's like, I'm always like, yo, could I get like a new bowl of snacks? Cause I don't know whose fucking hands were in this shit. You know, they're always like, yeah. But you know what I mean? It's super easy. Like there's a bunch of ways that you can think of that DNA could transfer in a public place. But it's like Ali says, like the concept.
You just gotta let it be
out there. Like brushing shoulders is a dangerous gambit. It just is. But if you have, but I agree with Allison. I don't know how she's keeping that out.
Right.
Like,
even
was she created like so she wanted some kind of heavy duty foundation as like, do you have anything? Do you have anybody that could corroborate the fact that he was ever in this establishment, like that he was known to frequent it? You know what I mean? It's like,
but it doesn't even have to be that same day.
No, that's what I mean. I'm talking about frequent.
But she would have had to have been in a public place.
I think that goes to your point, Ali, that it doesn't need to be the same day. That's where we need a DNA expert to say that. Because you can say that, but a jury might not be primed to.
Well, that's what I'm saying. He could have asked her, like, if tomorrow.
I do think he has he has witnesses that he wants to call. I just can't see the list, but he's made arguments in front of the court, and there are, you know, motions relating to experts. I just can't see who's on his most recent witness list to say.
It's always a good idea to explore it with their experts, because someone said, like, you know, how do you get in this without him testifying? You just get in that DNA can come in the mouth from shed skin cells in a public place, from, you know, you touch the same door handle days apart, you touch the same salt shaker days apart, you know,
same peanuts.
Yes, the peanuts is the greatest one.
Thank you. And you just ignored it.
Any peanut
salt shaker. I'm licking.
Well, I'm just saying all the things, you know.
I was eating some hand food. I had a sandwich. I picked up the salt shaker.
Bars are renowned for not cleaning glasses well. So you can drink off of the same glass days apart.
Oh, yeah.
And we just saw, what trial was it where the guy tried to wash the DNA off in the dishwasher, and the DNA was still on either a knife or a cup.
Yeah.
Very reassuring.
Google searched
hygiene.
It. Does
Fucking
it come
Walsh.
off in a dishwasher? Yes.
Brian Walsh.
Right. So we know it can hang around. And so you can actually sip off of the same cup. And like you guys are saying, if she's got multiple unknown people's DNA in her mouth, and that absolutely proves that random people's DNA can end up in your mouth just from being in public.
I bet I've got like 7 people's DNA in my mouth right now.
I know. I feel like I want to go check right now.
I was in there fucking that Jewel, man. Like DNA was all over the place, man.
I feel like let's go.
Deli guy, he's like, hey, man, you want a piece of salami I'm cutting for you? Sure, buddy. I got that guy's DNA in my mouth. There's no.
I mean, I'd have DNA expert come in there and be like, can you check my mouth right now?
I need to know.
No, actually, can
how
you-
many profiles are
Can
living
you
in
check
my mouth?
the prosecutor's mouth so that there's no
You
allegation?
gotta
that I-
ask, did you brush your teeth this morning first?
That lasts like 10 minutes. As soon as
Well,
you
but
get
that's
out
the
into
point.
the
That's
shit.
the point.
Right. Yeah, exactly. It's a fresh start every day. So as far as I've seen a couple of questions in the chat about the hands, whether or not
Yeah.
Ali and I saw the hands. It's the convenience level of that is obviously off the charts for
I think he
Mr.
punched the
Melton.
wall to make new injuries. I think he
Yeah.
had injuries on the top of his hands, which would be consistent with someone trying to claw when
Yes.
someone's doing a strangulation. And
Yes.
he had that. If you saw the little glimpse of the picture with the plumber cement, as Cruz says, on his
Mhm.
hands, it looks like this was covered when they were doing the fingerprinting with the stuff.
A-
I
and-
think he punched a wall to get these other injuries, to say that all of these injuries.
Or if it's
Or-
brute force, and say, for instance, like he's got her standing up. If we're gonna skip the whole drainage thing and just say that he anally raped her, sorry.
Well, they did say that they think the stab, the single stab, was from. They could be from behind.
Well, that's what. So that's what I'm.
standing.
That's exactly what I'm saying. So imagine a scenario in which he's standing behind her. He's got her bent over against her will, and like he's trying to control her with his two hands, and they are rubbing massively friction wise against the sheetrock. I mean, there's just a lot of ways, and I 100% think that it's a possibility that he was trying to cover his shit, so he did punch the wall. But I think even without that, I can see ways that he would get that pattern of injuries without having punched the wall at all. The fact of the matter is, it's awfully bad. If he was the guy on trial, like those pictures of his hands sealed the deal.
Well,
You
and
know what
the
I'm saying?
prosecution would not be defending the pictures.
Right.
The
I
defense
mean-
would be calling the guy to say, but you fingerprinted him. You had the opportunity to look at his hands and you didn't notice
100%.
anything, did you?
100%.
So it'd be a role reversal.
It's crazy.
Yeah.
It's crazy.
We've also got shout out to the real Emily Ross saying, what do you think about lawyers that just want to win because political opportunities? Like I said, my lawyer was great, not a criminal lawyer though, but passed away. Everyone wants to move up. I don't think necessarily everybody, and this is speaking personally, might want to climb the political ladder.
Yeah,
but I would say it's
I had
certainly
zero interest in doing that.
I think you find that, more with a prosecutor than you would with a defense attorney, because prosecutors, they more often move on to be judges. They more often move on to,
run for office.
to run
Like
for
beyond
office.
that, like in terms of state legislators, like you can look at that track. Typically when the prosecutor track, like it's unfortunately the vast majority of judges are prosecutor track lawyers who, when a young lawyer out of law school, go in the prosecutor's office, do it for 10 years, and then they make that move for the bench. Like the thing that I only wanted to see out of both Allison and I is Allison on the bench. And that wasn't for political reasons. That's because she'd be a fucking amazing judge.
good judiciary.
You know what I mean? Like that, it's like you want that judge who's willing to put in the work, who actually gives a shit, who's going to actually read the case law and really try to take that gatekeeper role super, super seriously for evenly for both sides. Like Allison's, even though she's a defense attorney through and through, she's still got a very even-handed way of looking at shit, and
Right, and
from
you have to put on your even-handed hat when you decide to take the bench. I mean, we've got most of the judges are former prosecutors.
that's what I just said. Yes.
Right. No. So
Yeah, I mean, without question, and the problem is that it's defense attorneys that are forced by operation of their job to have to be objective. Whereas with prosecutors, you're myopic as fuck. It's like whoever your cops come up with in terms of a suspect, they're like, this is what we got. If the prosecutor's like, all right, I think we got enough. I feel comfortable going and taking it to trial. I think we got enough there. But you are super myopic. You are not being objective at all. You're looking super tunnel visioned at one person, and that's your only thing. Whereas with us, we have to be as objective as humanly possible. We're trying to come up with every alternate theory known to man.
Well,
and
because the
that
truth
fits
typically, in a
somewhere
lot of
in
ways,
between.
will help your client.
right. Plus, we have to be able to give our client a fair assessment of what their risks are.
Right. 100%. You know, and it's just like, the system's just kind of, it's wonky, but like the thing that I'm so grateful for is truly with YouTube in particular is, you know, concerned citizens such as yourself who take a real interest in the criminal justice system, who sniff when something is not right and you put it on blast, you know, and it's a real contribution to changing the system, you know, because it's like I've said it before, I feel like I have a much greater reach now than I ever did in a courtroom one time in it. You know what I'm saying? So it's like, in terms of trying to change the narrative that exists out in the public and try to get people to be interested in being critical thinkers is, you know, a daunting task sometimes, you know, but it's like, and it's super fulfilling. Like, I love sitting in your chat and reading through your chat, and I love every day.
They're so great.
Right. And ours is the same way. And we obviously have a bunch of bleed over, you know, and it's like, but it's super fulfilling to read that there's people out there that, and especially the ones that are like, I couldn't stand defense attorneys for forever because I watched Oxygen and Discovery and they just made them out to be the biggest douchebag, you know, and to see those people be like, you know, you completely changed my mind on what the role of the defense attorney is in the system is so incredibly gratifying. It's like, it makes it all worth doing.
You see that switch of the don't let a single guilty person go free versus it's better to let 100 go free than imprison somebody who's not actually guilty. I think that's to sum up the switch that people have. And I mean, again, I've been there. You know, when I was like 14, 15-ish, I thought the death penalty was like absolute. Like, before I really looked at any major issues, and it's not even like a death penalty case is necessarily what made me question the justice system, but we get smaller cases wrong all the time.
All the time.
And so to see us get something wrong where there's such an egregious consequence, something so dire, I'm like, all right, well, you know, maybe
take a peek at this shit.
Yeah, maybe it's better that we say, hey, we can't be 100% certain, and there's a lot of problems, and I think we're becoming more aware of exonerations and wrongful incarceration and how long that process takes to get there. And then even when you have a conviction vacated, it might not mean you are looked at as being innocent in the eyes of the law. There's still all these different barriers you face with
or the eyes of the public.
Yeah.
You know what I mean? Which is like the worst part. It's like, it really is one of those things where, you know, you need people to kind of speak up but like recognizing that there's a problem is the first step, like in anything, you know? So when people are starting to kind of like open their eyes to the fact, like, oh, you know, it's like, I kind of thought like somebody's arrested. Well, they did some shit wrong. And then prosecutors are all white hat wearing mofos and, you know, they're all on the up and up. And like, this thing is, and then when you start to kind of critically think about it and you know, cause like that thing about prosecutors being elected officials just has never sat right with me because of the fact it creates an inherent conflict because it's that platform where you're more concerned about getting convictions than getting it right because you're running on I'm tough on crime. I have a 98% conviction rate. Well, okay, motherfucker, but you're just convicting anybody that you can. And it's like, I'm always talking about.
Or it's convictions with like pled down sentences.
Everything.
So sometimes just getting the conviction, it's not really even like someone that's guilty and takes a plea. You're taking the punishment off the table just to get an easy disposition.
That's more of what it is because we're also like, you know, we watch murder trials, right? But the reality is that 80% of the shit that's running through the system is not murder. It's all the little cases that you were talking about. And in those little cases, what the move of the prosecutors has turned into in the last, since I've been practicing, is to overcharge. And then when they overcharge, it leaves them the wiggle room to be able to go to our client and say, all right, you know, we've had you sitting under this, the threat of this felony, this heavy felony for 2 years now, pending trial. And here's what we're going to do. We're going to make an offer. We're going to kick it down to a high misdemeanor and give you no jail time. And even if that person has not committed that crime, that is almost an
You
impossible
don't want to
thing.
turn down the risk. It's risk mitigation.
It's all day, you know, and it's like, and I'm having that conversation with my client, obviously, you know what I'm saying? I'm like, this is what they're doing, you know, because
I can't imagine. I think that'd be one of the
unreal.
toughest parts of having those
Unreal.
conversations.
It's
because you
unreal.
have to be real, but what you're telling them is, hey, you might have to put aside that you have personal knowledge of your own innocence, but you might want to consider biting the bullet here because of the prospects, the risk of taking this to trial.
Because you never know what a jury's going to do.
You never know.
Mavka and Sky, it's not like, I'm not even talking about like the lesser included at the trial phase. I'm talking about when you're in that negotiation period wherein you're trying to work out a plea, or you're potentially contemplating, your client's contemplating taking out a plea. Like there's a long period of time that you know, between arrest and trial. Typically it's like with Sarah Grace Patrick, when that thing was like barreling down the tracks towards trial, I'm like, holy shit. It's like, that is way too fast. And it's like, I get it that, like, you know, like she's maybe thinking she wants to go to trial that quickly. But I mean, like in that particular case, man, her defense is going to have to be ready, because they're coming at him with some bullshit. And they got this judge who's I can't describe that judge. There's something about him, like him allowing that first bail hearing to go
It's
as
a hairstyle.
Oh,
Raises
dude, like,
questions.
everything about that dude is just like is off about it. He was like, well, you know, I really like to keep it on track. I'm like, well, that's because you're a young judge. And I don't know if you've ever practiced, bro, because, you know, like the reality is, unless it's the defendant pushing a speedy demand, which it's a dangerous gambit. It's a double-edged sword, because you're pushing to the state to trial more quickly than they would choose, but you're also pushing yourself to trial more quickly than you'd choose. And, you know, strategically, it can blow up in your face. You know what I'm saying? So it's like, in that case in particular, it seemed like it was the judge that was really trying to keep this real tight deadline in terms of when he wanted this trial to happen, under the guise of, oh, well, you know, Miss Patrick is claiming she's innocent, so let's just get this fucking thing to trial. You know what I mean? Like, if she's like, you know,
it's almost like weaponizing someone's right to apply for bond.
Exactly.
Like, well, why don't you just take it to trial then? That's a very pretrial incarceration is a term for a reason. Like, it's an option pre-trial. It's not equivocal of, if you just want your freedom, just rush into the trial stage,
right,
and get it done and over with.
Right.
So to me, it's weaponizing someone's request for bond.
100%. And it's like in that particular case, I knew there was no shot she was going to get it, because I mean, really the only change of circumstances was the fact that the trial got kicked. You know, I mean, I didn't hear anything during that first bond hearing that gave me pause about anything that she may have done, because they didn't put forth anything in terms of actual evidence that she is in fact the person who did this. And, you know, instead what we got was a parade of victim impact statements that were completely inappropriate. It was so weird. It was so out of place.
And a highly publicized, people were watching
Kat,
that
are you
bond
a
hearing.
clean channel? Like, I've been like swearing like a sailor over here. Sunshine for You One kicked you a fin saying, here's my money for the cuss jar. Are you a clean channel? Because I can, believe it or not, I cannot swear. Like, I did it in a courtroom for a long time.
I
apologize if you're a clean channel, because
it's
really
weird.
have been
I
trying
don't
not to
curse
swear.
that often, but I pretty much just read like charges. Like, if I'm reading a news article about a heinous crime, or I'm reading the charges on an indictment,
yeah,
I'm not really in the position. I've been there where I've said unaliving or grape instead of rape, but now I just say it. Like, I honestly don't think YouTube flags me for that.
I'm talking about for the
like it used
bad
to.
words, the swearing, not
Yeah,
like,
so I don't mind, because I say the terminology that relates to like the crimes we're talking about anyway, and that's gotta flag it as well, I would think.
yeah, I just want to be respectful to your channel. Like, if you're, you know, because it's like there's channels, and I typically ask before I go on, I'm like, you clean?
No, I appreciate it. Thanks for asking.
Yeah,
It's
all right,
cool. I'm not.
all
I do curse when I get really pissed off.
I mean,
I
I'm
just
perpetually
can't think of
pissed
another
off.
word.
I'm always pissed off. Yeah, it's like, you know, watching this stuff, it's hard not to be perpetually upset.
Well, and I think it's necessary because everything that you're saying, and honestly, I think it goes back because Emily's trying to clarify here, her initial chat, the
Oh
one
yeah,
who's climbing
I
the
didn't
ladder.
take anything that Emily was saying as like some kind of slight on us. It's like,
Say, I think it's kind of like three-pronged. There's people that want to climb the ladder, there's people that want to advocate for somebody, and then there's people that just want to go be lawyers because they think that's a good career path, and maybe they end up in corporate law, right? They might not make it into
yeah,
the criminal space. Maybe they switch mid-career. That pathway changes halfway on. I would think the idea of the politicization, I can never say that, politicalization of criminal justice, the pressure, the growing eyes from social media, from YouTube, the name Jessica Berryman, who was called out by this judge in this trial, is Jessica Berryman in the courtroom. It seems like her coverage is over on Facebook and Meta, Instagram Lives, like that type of. I don't use that space for videos, but what I'm saying is she's over there doing it for this trial. People are watching and consuming live trials through Facebook and Instagram Reels now. TikTok, another place for true crime, for trial coverage. For these people with political aspirations, the voter block, the constituency that they're going to be appealing to, could change over time. Probably not overnight, but a recent example I'm thinking of, also brought forward by a podcast, Stephanie Tinsley, speaking of Murdoch, Mark Tinsley's wife, she put together a podcast called Everything They Missed for a man named Andrew Hayes and got some attention. And while her podcast wasn't the direct reason for post-conviction relief to have a fighting chance, it made a relative of the deceased have questions. And they went and contacted the person who is now actually charged with the crime instead of Andrew Hayes. And he recorded his conversations after building rapport with her, and she admitted to it over the phone with him.
yeah,
To being there, that Andrew Hayes had nothing to do with it.
yeah,
And that chain of reaction from her doing the podcast got this to the attention of the district attorney. This is Shelby County, Tennessee, where Amy Wyrick used to be district attorney. Now it's Steve Mulroy. He won election over her. He won the election by campaigning against her. And he came out and did a press conference declaring, even though it's still caught up in the appeals court, they said, we're not going to fight your efforts, Andrew Hayes' team. But we think we had the wrong person and we want to have accountability. We want to get this right. And we're issuing charges against the other woman, Sarah. I forget her last name at the moment. But I really think that it's politically appealing in some areas, largely because of trial watching and our I think, growing critical thinking, that what Steve Mulroy did for Andrew Hayes would become more popular.
yeah.
So I'd like to see the political draw kind of even itself out instead of just being, we want to vote for the person that's tough on crime for the sake of it, regardless of the truth.
I mean, that's the hope, ultimately, because it's like we're doing the same thing with Julie Beverly. That's that case that we believe it's a wrongful conviction. It's a tough case, and she's down in Southern Illinois, and I did that Murder on Podcast Road, and it was on iHeart, so it's like we're going to get a lot of ears on it, but that concept that you talked about earlier, wherein you're able to kind of flip one of the victims' families because of what you're uncovering through your investigation. And I'm a boots on the ground guy, I was down there, and I was asking questions and poking around and trying to talk to people that, should have been witnesses at trial and, trying to find out what they saw and what they may have heard and things like that, and you get a lot of resistance down there, but that's the hope that as we continue to dig, because, I'm going through the transcripts of that particular trial, and, Julie's, by her own admission, her public defender was not on her game, and she was pretty candid about that, but then when we try to go back to her, like, yo, I'd really love to see some of the discovery in this case, because we have this case that's taking place and we got a mixed race girl, living in a extremely white area of Southern Illinois. And, there were certain things done during the trial that make me believe that, race played a great part in what happened here ultimately. But, I want to I want to be able to dig into the police work to see kind of where this thing went off the rails because, but like
Or if
ultimately,
you could speak to any of the jurors and
right.
what were they thinking when they convicted?
And we did, and like it was super fulfilling to have one of the jurors who started listening to the podcast reach out to us and say,
Oh my
"All right,
God.
yeah, like I gotta tell you, man, like I'm like you guys just had me rethink everything because it's not what we heard at trial, none of the things." And it was like so, but like that part of it is amazing. But what's even more amazing is that thing that you were talking about, where you can get one of the family members of the victim to flip in terms of their opinion.
Because that puts so much pressure on the district attorney's office
Right.
because they always want to
Exactly.
say that they're an advocate for victims, even though like we've watched several cases here where prosecutors abandon the victim's family as soon as the victim's family isn't fully on board with
Yep.
who
Yep.
was pinned as the culprit and charged.
And then they just strong arm them to convince them they have the right guy.
Yep.
Yeah. Trust us.
Which is really sad. It's traumatic. I think it's traumatizing. Like, especially
Yeah,
if
you
it ends up
had
being on appeal.
the woman in what's his name, babe, where the key to the car, the RAV4.
Oh, you're talking Stephen Avery?
Right.
Teresa Halbach?
In the first crime that he was found not guilty of, the victim there said that the state had her so convinced it was him when she had nightmares of the incident, it was his face that she saw.
Mm-hmm.
And then she expressed, remorse.
Great
that the wrong
remorse.
person was
Yeah.
right.
Because that was a DNA case, but and then what happened with that thing. Yeah, I don't know. It's frustrating. So tomorrow's a break day.
It could be. They don't know yet.
Okay.
Yeah, they said noon or we'll let you know. So who knows?
Okay.
Yeah.
Maybe we got to go back and watch it, babe. See what they
Yeah,
said.
especially if
this
it's an
DNA.
off day. Guys, make sure you follow Defense Diaries anyway. But in case you guys are bored tomorrow and there's no court and Bob and Ali decide, let's watch these GBI witnesses. And I keep emphasizing GBI because, yes, they're the DNA forensics people that are coming to speak to us in this trial, but they're state workers. They're
Right.
all in the same club. So I think that's important to emphasize. But yeah, whatever you guys cover anyway, whether it's Murdoch or anything, you guys are covering things that everybody's asking about. So
Yeah.
Sheriff Chuck has a question for you guys. What are your thoughts on the state starting their case with putting on 8 days of defending Kris Melton?
I kind of think it's odd. I don't know why
It's super odd.
prosecutors keep doing that.
It's like it's the same thing Lally did in the first read point or 1.0, wherein he put on his pre-Buccal case, trying to get in front of what he knew the defense was going to end up doing, which was calling all the House defendants, in the civil case at least, and so he's essentially they did the same thing here, and it's like it's weird.
And then you just had the lead investigator kept saying, but he had an alibi. I knew he had an alibi.
Liz.
When he just
First name basis
testified
Liz.
that it was only his word that created his alibi.
Yeah.
I mean,
And
that
they
other
only spoke to him
guy.
4 times in 2 decades.
I mean, because I guess from a prosecutor's perspective, he's coming if the defense calls him. Because if you're the defense attorney, you're thrilled because trying to direct exam him through, what you want.
That's what I was thinking. Why not make, even if you call Kris, what about some of the other, because it's not just Kris Melton that Cruz worked with. It was all of the anyone that had involvement with questioning someone in the early days.
Yep.
Like, did the state really need to put on more than 1 or 2 investigators? They could have waited. If the defense wanted to rely on what they did through cross, they could have made them call them.
Yeah.
And what did the, isn't there I don't know if they said how the fire was started, but aren't there ways to start a fire where it's something that's going to take off when you're an hour away so that then you can have your alibi? Because I don't know that
they're leaning on that. The state is partially leaning on that. They need there to be just enough of a time where the fire could have been just smoldering before it really caught. But they don't want it to extend too far because they want it to fall within Kris Melton's very shaky alibi window of that 7 to 9 a.m. before he has the bank receipt at 9:08. Because the 7 to 9 window is just the word of his friend Josh, who ends up saying, I don't remember anything about the bank. But and we went to Nash, and nobody verifies this Nash plumbing company. Nobody
Right.
speaks to a receptionist. So I don't think that 7 to 9 window is really a credible alibi. And we do have that bank statement at 9:08. We have the clock, supposedly, if we take that at face value, 9:32. Someone says a neighbor thinks that they may have smelled smoke around 8:50 in the morning. And then you have someone actually calling in 911 reporting the fire at 11:22 a.m.
I just can't imagine that there's not a way, if you want to do something that's going to, like light something that's going to start the fire later.
Hours later.
Right.
Well, we
I
have
mean,
4
to
burners
me-
on the stove, and then the roommate says there was a blanket on the couch that was no longer on the couch, and they believe that the blanket was used, set on the stove, and then carried into the room as the means of starting the fire. They had an ATF guy testify about fire
Yeah,
engineering.
we saw that. We saw
and
you
he
talking about that.
couldn't narrow down the window, but really the state just wanted to get, if there's low ventilation, if there's moisture. It was foggy that morning. Kris says it was raining, but maybe that's only further out west.
But you
really
made
in the
all good
area.
points about the material, not knowing that it's the same material, what it's treated with, what's on it. It's old.
If she used the blanket after taking a shower, maybe it was damp.
Maybe she
you
had
just-
like
you
a
just
pot
don't
of
know.
mac and cheese going, and she stepped over her shit.
On all
caught
4
fire.
burners. It was all 4 burners that
He's
the
like, "Whoa,
fire
whoa."
department saw.
So, but like, what about the concept of like the homicide takes place the night before and dude just dips over there the next day, knowing obviously she's not alive. I'm gonna dip in
And then
here
sets
real
the
quick.
fire after,
Yeah.
get rid of the yes, I've wondered that too. You don't just because you can pinpoint, if we can narrow down the start time of the fire, which like my theory when this case started, I think once something catches, if there isn't water, I thought it would just burn like crazy. And people are in the chat are like, I've had personal experiences where someone didn't put a cigarette out, it falls off the dresser, and it takes 5 hours to actually ignite.
Sure.
And so I'm learning through this, and the state wants the possibility to extend just enough in the jury's understanding to get where, if you believe Kris's alibi starts at 7 a.m.
So where's Melton the
fall out
night
of that.
before? Where is he? What
At
was
his
he doing?
parents in a
He
door
says he's
that,
staying at his parents' house.
but it's got a door that goes inside and outside
Right,
without
well,
having
he
to
was
go through
trying
the
to
house.
say he was staying upstairs, but then he switched it up, and he had the basement room.
And the coworker says he came out
Right.
the basement
The
entrance.
coworker was
when
like,
picked him up.
I picked him up at his parents. He was staying in the basement.
Right.
That's what the coworker said.
It's like when I
So-
stayed at my grandpa's. It was like I had that basement exit. It was like free pass. He had no idea when I was in and out.
Yeah, it's
And
almost
when
like a
was this-
multifamily
I'm like,
unit.
what's up?
So
What's
I
up,
guess they
Grandpa?
can't tell when she last used her phone because phones were different back then, or did we even have cell phones in 2001?
Well, I think that the idea would be, there's no data of like you're getting a notification. We could see that you
Right.
checked your email at a certain point. It's not going to be as granular. And with a landline, it's if nobody's calling you. And even if someone called you, if you don't answer, that's not necessarily a sign
Doesn't
that
mean anything.
you're dead.
Doesn't mean
Right.
anything. Yeah.
We just know that Kris Melton called her 5 times the day before, and that they apparently hadn't been speaking. Potentially, that's the defense's argument for days.
Boy,
prior
that'll
to
get your
that.
ire worked up, won't it? Oh, like this. She won't even answer my shit. What?
Well, that's why people have suggested since
Allie
the
will
only
get in
thing
the
missing
car.
was a laptop.
She'll come
What if he
find me.
sent like an incriminating email to her when you didn't pick up the phone? Like I've heard stories where modern day, you block someone on a social media and then they're sending you an email. It's like a meme. It's like a joke that people say when you try to break up with somebody. So the 2001 equivalent, not answering your landline, let's send an email because she's a law student and be at the library and might check that. So it does kind of, it's just something the chat threw out, but I'm like, hey, that's kind of interesting. Maybe that is a reason someone would want the laptop and didn't steal any other valuables.
Right.
Couldn't they still get your emails from the post?
I don't
even
think
back
they
then?
tried. That
Put
just
up
goes
ma-
to a bad investigation.
Put up Mavhawks 547 comments. So it's
wait,
like
is it?
it's
I think-
alibi, not black. It's
see.
like so true. I wish Judge Fleischer, I make a motion that Judge Fleischer precedes every trial. He's like, I want him on the bench for every single trial in America. That's who I want on the bench. Good old Judge Fleischer, bow tie and all. just leaning in, just flame throwing people, like calling it like he sees it. Like that guy, man.
Yeah, I watched a recent one with him where he knew one of the attorneys in the gallery would be ready for a case that someone that didn't have counsel was sitting up there. It was something like a younger kid, and I don't even remember the case, but he just looked at the attorney in the gallery, and the guy was like, "I'm ready. I got this one. I'll represent him," and came up with this binder. A joy to watch, Judge Fleischer. But yeah, I think I agree with Mav Hawk here.
Yeah, exactly.
What'd you say, Ali?
You got another comment from Freedom Ring 757. Super.
Yeah, so we've got the travesty was when judge let Detective X testify to the deceased Detective Y's report. And again, this is unavailable witness issues with cold cases of deceased alibi witness Z's alibi for Melton to help refresh his recollection. And you don't see anybody trying to refresh Faust's recollection in his police
Deceased
interview.
alibi witness. See, so there was someone gave Melton an alibi years
Hearsay
ago.
within hearsay within hearsay, and they let someone else talk about it.
So there was obviously an alibi witness who has since died, who had made a statement,
right,
to a detective who is deceased, and they let another cop. It's a lot of dead people testifying. That's the bottom line. A lot of dead people testifying right there.
Yeah, and the judge thinks that circumstantial evidence should carry even more weight because the case is so old.
See, I don't know why the state wouldn't have had to say, "Do you recall where you were on X date?" No, I don't. Do you recall being at such and such a spot? Because then if he says yes or no, or if he says no, but maybe, it's not going to refresh his recollection that someone else, I don't know, he should have had to ask him specifically about that spot first, but you can refresh recollection with anything, but it handed him an alibi.
Oh, I remember the old Pop 3 on my Crackberry.
Yep.
Clack, 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 clack. Allie got me that thing fresh out the box as soon as that thing hit. She got me that and the TiVo. I was like,
well, that used to be the move, the phones with the keyboards, because
Yeah.
it was all about texting, and obviously the touch screens were like, it wasn't just the pulse from your hands or whatever. I don't know the science behind it. You had to actually pressure the
like to have the full keyboard as opposed to the Nokia with the 1 through 9 with the ABC.
You had to press it 3 times.
Oh my God. It was like, it took me 15 minutes to say what up. All right.
Well, yeah, let's wrap it up. I mean, we had James, I missed this one, 2/3 of all property crimes are wage theft. And I think this was going back to, let's disposition these cases. Let's get deals worked out. I don't know if you guys have ever experienced something that could be politicized. It's a misdemeanor, and the district attorney doesn't even offer a plea because they want it to go to trial.
Oh, yeah.
They want it to be publicized. So there's that scenario.
Yeah.
And then we've got the real Emily Ross. And I love to be optimistic about these things. I don't know what I would do if I was like on trial for something and someone said they had good evidence against me. I'd like to think if I'm innocent, I'm not giving a plea. But I really don't know once I'm in those shoes.
It's
so,
like
Bob and I had a case where it was, like I said, we didn't take many SA cases. So these were 2 brothers that their dad's girlfriend's son accused them of sexual assault. And he also said that he was like assaulted by a babysitter, a female babysitter. And it was clear like he was very upset about the promises that were made to him, because I guess the boys didn't, the brothers maybe came to America later. I forget what it was, but once they all came, the girlfriend's son was like, felt like just cut out. And the story made no sense. And it was like both brothers at the same time, no sense. And he remembered them reading a specific book to him, and that it happened on that night. And I looked up the copyright of that book, which didn't come out until years afterward. And there was like no evidence. And we told the guys, you know what, we will represent you for free, so that that's not going into your decision right now about whether you want to plead or not. But the state offered them 0 jail time, and they'd still have to be on the offender registry list. And
they can claim that they got an offender. They got a conviction against an
Right.
offender.
Well, they do get a
they
conviction.
both took it. Yeah.
Yeah. It's it's that's like, in Emily, your point is so well taken, because that's how everybody on the planet feels. Everybody on the planet feels like, I would never, under any circumstances, ever admit to doing something that I didn't do.
Until they stack the cards against you.
Until they put the threat of, essentially, for all intents and purposes, ending your life as you know it. And then they give you a carrot, because it's like, that's what I was talking about, that year and a half, 2 years, where this incredibly dark cloud is floating over your head of the
Especially
unknown.
if you don't have bond, if you're being held pretrial
Or even if you
incarceration.
do have bond, Cat, either way.
Yeah.
You know what I'm saying? It's like that unknown is so terrifying that, and as the attorneys, we have to be honest about, look, trial's a risk, period. And it's not to say that they don't have a theory, because they do. And it's not to say that they aren't going to be able to get some of their evidence to fit their theory, because they will. So, how much can we offset that? It's a calculated risk. And, and it's like, because you can't just it's unethical for any criminal defense attorney to ever tell a client, we're going to win this 100%.
Yeah, you can't give a guarantee.
You can't do that. So and nor would you want to. It would be incredibly foolish, and it would be reckless to do that, because you can't say that, because every set of jurors is different. It's like we say it all the time. Picking the jury is the key to the case. Always. Those 12 people that you put in the box ultimately are the key to the case. If Faust gets 12 really, deep thinkers, or, people that are willing to get into, the minutia and think about things heavily, or even 1 or 2 that are back there and like 12 Angry Men style, like, well, what about this? Like, I was like, burn him. Well, hold on. You need that one person back there, hopefully more, to get people to say, all right, I hear you. But I don't think this case is like that. I don't think this is going to be, and this is on the limited amount that I've seen. I don't believe that this is going to be a case where, if they go back and do a straw poll, which I know for whatever reason judges are saying, don't do that. I'm a fan of them. I like to know where people, stand right from the get, because then you need to know if you need to do work. So if you go back there and everybody's like, man, I don't know. You know what's going on in there. If you've got a bunch of people like, I don't know. I don't feel real comfortable with the guilty thing here, and you've got a couple of people that are like, what, are you out of your mind, dude? Look, they got this, and this. Like, who else could it be? And then you get the, it's like that
persuasion.
whole, it's that thing back there. And it's like a real thing. Like, I wish that we could have fly on the, that's what I call it. Fly on the wall for jury, give no idea what the case is. Give no names of the jurors that are in there, but just be able to be the fly on the wall to listen to deliberate. Dude, I'd watch it all the time. I would watch it every day, all day, jury deliberations.
Or I wish we could have simulations where, the same jury, but if a different defendant was on trial, right? And similar parties presenting the case, just would you also convict another person?
You don't have the weight there, though. You know what I mean? You need the weight of the reality of the situation in order to make it as authentic as possible. That would still be super interesting, but it wouldn't be as amazing as being a fly on the wall, listening to just all the deliberations that take place without, again, they give you the fact pattern, what happened, but you're just listening without having any, I'm trying to figure out a way to work around it. So here, let's, because I think it would be so instructive to everybody, to people in the system, to potential jurors, which is every American citizen. It's like, I think there could be a lot gained from watching the process in action, but it's a pipe dream.
Yeah, the closest thing I have is fiction, the show Bull, where they do the focus groups that mimic the pulse of the jury.
Well,
it's
yeah. Well, it was like that show that was, what was it called? Where the dude had no idea that it was like
Jury.
yeah,
It was
was
just
like,
called Jury.
yeah, so it was like it was like Truman Show shit. Like he had no idea that they were all actors around him. He thought it was a real thing. And it was awesome. It was fun to watch, because like watching his shit was genuine, in terms
And
of
it's interesting that he like had his BS meter go off, but then he didn't really peep it, and it's like,
yeah,
could we all be fooled? And then this could actually be a real juror sitting on and trying to wade through real facts, but he got comfortable thinking this is just how this.
Yes.
Of course, that only could have worked in a Los Angeles courthouse. Like that, I don't think he would have been fooled in another courthouse anywhere else. But,
yeah.
I
mean, the lengths that they went to make that shit authentic was pretty impressive.
The behind the scenes, guys, if you haven't watched that, watch that show, because the behind the scenes is just a cool production to see.
It is. It's great. It's great.
Hidden cameras and the trash cans, and because they rented out like a shut down courthouse that wasn't even open anymore.
Yeah, Ali and I think binged that like in a night.
Yeah, me too.
Yeah, it was great. It was great. Couldn't get enough of it. All right.
Thank you. Yeah, thank you guys so much.
Yeah.
Whatever you guys cover, whenever, chat, make sure you are tuning into Defense Diaries. They're always covering something good. They go through the motions, they react to live trial streams, and they both have great insights. And if you can't see, they're willing to consider different opinions. So if you like what we do over here, you'll definitely like it over there. I appreciate you guys both so much for popping in on your day off.
Well, of course.
Giving your insights.
I got to take the guy for a nice walk today because finally the weather broke, so that was nice. And then went and shopped a little bit. So it was a nice, relaxing day because we like watching the Murdoch thing was like like I just enjoyed it. I just enjoy watching that because of the level of lawyering and judging that goes on at that level. And it was high level shit. It was really fascinating. If you love kind of the system and you want to know how it works at the appellate level and above, like I highly recommend that you just start. Like I was telling Ali, I was like, I want to start watching these all the time. Like even in cases I don't even know what the hell it's about. Like I just like watching the argument, and it's really, you can learn a lot there in terms of.
I'll start sending like the court of, it's not always state Supreme Courts, but it'll be Court of Appeals as well.
Cool.
For different areas. When I see a YouTube channel that streams them, I'll just send you guys a tweet. I'll just make a public playlist. I'll just start adding them to a playlist, so anyone that wants to watch arguments anywhere, you'll see what channels actually televise them.
I love that.
And
awesome.
We'll invite you on next time. Jim already said he's on board, happily angry lawyer, for the next Georgia Supreme Court.
Cool.
Oral arguments.
Awesome.
So maybe it'd be Steele, maybe it'd be Andrew Fleischman. Who knows who you'll get when you turn on.
It's like the wheel of fortune. It's like, who knows? Who knows? Yeah, there's some good lawyers down there. All right, Kat, you're amazing. Chat, we adore you. Old and new, we adore you. Thanks for hanging with us all this period and listen to me in particular. Yeah, Allie's been trying to crack the case for the last hour. Like she's got the 1,000-mile stare going. She's typing, she's figuring shit out.
I was trying to find some scientific articles.
I know. Well,
we will tune in if you do something on this one. Guys, this is going to redirect over to Miss Janet Demeanor, who has Jodine Weber on tonight, former FBI analyst, always sharing her insights. My guess is they'll be talking a little bit about the Guthrie, the FBI, Bitcoin, new developments. It's a lot. You guys are just talking,
I rabbit holed the heck out of that thing yesterday. I was like,
I was gonna say, it was just you. I didn't see Ali on for the part that I watched, so you went into that last night, and it's just a lot. It's really interesting to hear a bit more about what they do in those scenarios, what they don't want to say too soon, what they do want to say, and see if it pulls anything in. So I think that'll be great. That's Wine and Crime Wednesday with Miss Janet Demeanor. Defense Diaries. What was your guest name yesterday?
I had Joe Jackalone on.
Joe.
Yeah, it was Joe Jackalone. Or I went over to old Mike King's, his house to hang out. It's like my backstory with Mike is awesome, because he's like dyed-in-the-wool cop.
Allie's shaking her head like, don't go down another rabbit hole.
Right, no one needs to hear that right now.
Whatever.
Go to
okay.
They're waiting to
Yeah,
go
we're
to
gonna get to
misdemeanor.
misdemeanor. She
Yeah,
just
she
started
probably
2 minutes
started
ago.
already.
So
All right.
I'm gonna end this, guys. This should redirect you there. Thank you so much, everybody. Thank you, Defense Diaries. And
Thank you.
I'll post a community post tomorrow if court is canceled. If not, expect noon Eastern time.